and then setting it for another date after that, which we're not sure when that will be.
That would be fine, Your Honor, to put it for next week.
Let's put it on for next week, February 5th, just to see if y'all are ready to set it for a final hearing at that point.
Very good.
All right, 9 o'clock?
Yes, Your Honor.
All right, 9 o'clock.
Your Honor, that's all I have before the court may be excused.
Yes, sir.
Thank you.
All right, Ms. Dudley. I don't remember you. What do you have?
You know, I had George Scott in 24 CL 2605, and he wasn't transported. He wasn't transported.
He wasn't on my paper docket, which was printed yesterday, but he's on my, he's on the computer docket.
If we could put him on the 5th, Ms. Lane, because the state needs to look at something for me. We're trying to see if we can work it out.
For the bond hearing?
Yes, sir.
So the notice was done on the 23rd, which is what, last Friday?
Well, we added it. I'm gonna see if we can try to. I'm trying to get it worked out. So if we can, obviously, I'll do it on that day as well.
Gotcha. All right.
I did, and I had.
February 5th, 9 o'clock.
Yes, sir.
Just renotice it if it's actually going to be a
Yes,
bond
sir.
hearing, just so I know.
Yes, sir. I will.
Thank you.
All right. Thank you.
Thank you, Mr. Woody. Have a good day. Mr. Patel? Okay.
Jay Patel on behalf of William George Hyde III, 23 CF 2165. We're before the court on a petition to expunge. I understand that the state has reached out to the alleged victim, and they stipulate.
So sorry, my computer monitor just keeps turning off by itself and then turning back on, so there's probably a loose connection. I'm sorry, Mr. Patel, go ahead.
No, we're before the court on a petition to expunge. The state has reached out to the alleged victim. There's no objection, and
Okay. Is that accurate, Mr. Sprouse?
That is accurate. I spoke with the victim, and she's adamant that the petition be granted.
Okay. Then it'll be, then it'll be granted. Well, it looks like I've got an order here. Let me see. I saw the certificate yesterday. Order signed.
thank you, Judge.
Thank you, Mr. Patel.
May I be excused?
Yes, sir.
Thank you.
All right. Sorry about that, Mr. Tony. Go ahead.
Good morning, Your Honor. My client was supposed to appear by Zoom, Your Honor.
I'm in the middle of turning that on.
Yes. That's the state of Florida versus Miguel Andrew Gilmore Rodriguez.
And I apologize for not getting back to your office about that earlier, but saying Zoom was okay, and then I had some quick questions, and
That wasn't a problem, Judge. I just appreciate, the court giving him an opportunity. He's in college in Tallahassee.
it's not something you want to tell me.
I shouldn't have said that.
All right. I don't have them on yet. The only person I've got is Mr. Ramey, who's waiting.
And what I could do is I could go back. We don't have, because he's in Tallahassee, I'm just waiting for him to send me a copy of the written plea. I could just go and come back, Your Honor, and contact him, sign it over him, have him PDF.
I'm sure we'll be here just about all day, Mr. Tony.
Okay. Well, let me do that then, Judge.
All right.
Thank you.
All right, thank you, sir. And I've got Mr. Ramey is on Zoom.
You are in the meeting now.
All right, Mr. Ramey, can you hear me?
I can, Your Honor. Good morning, sir.
All right, good morning. Sorry about the technical difficulties. Let's get started. Who do you have first?
Judge, I have, State versus Matthew Heaton, 25-656. It's a arraignment on a VOP. Mr. Strauss and I have talked some about it. Don't know if we're in a position to resolve it today or not.
Okay. All right, so what would you like to do with it? Just enter a denial? Do you want to set it for a hearing? As far as an evidentiary hearing?
If I could,
I made it on, I'm sorry.
forgive me, Judge.
Go ahead, Mr. Sprouse.
So, Mr. Ramey, I considered what your offer was, so the state is willing to reinstate with 6 months CC and inpatient treatment. But it would be a modification with the same term, but adding 6 months of the what would be probation would be community service, if that makes sense.
Yeah, yeah. We're willing to do that if we can do that today.
Well, probation, do you have an issue?
Prefer that he be screened and make sure that prior charges that they don't qualify for graduation. So, yeah, you send this letter for.
Right, I didn't expect him to plea out today for those reasons. It was just so Mr. Ramey can get working on that placement, and then we can get it resolved as soon as possible, so.
So it'd be inpatient, and would it be bars to bed inpatient?
Yes, sir.
Okay. So basically, Mr. Heaton is, until there's a place to send you, they're not willing to just send you off on probation and have you out while you're waiting to get into your program. So what Mr. Ramey will do is talk to you about that and get you applying for the programs, because as probation has stated, sometimes you might have certain charges that would make you ineligible for certain programs, and we don't want to set you up for failure. So that's the big part of it. However, if something gets worked out and we can squeeze it into one of my Thursday pretrial detention hearing dates or something like that, as long as all the kind of ducks are in a row, I'll take the plea as soon as I can, especially if it's a situation where they won't put you in the pipeline for a bed at the inpatient program until you've actually pled. So I want to make sure we get that done as fast as possible, but I also want to make sure it's done right and not in a situation where you get set up where you can't complete something because you get there and then they find out that you're not eligible. So we don't want to end up in a situation like that. So what date would you like to put it back on, Mr. Ramey? I've got a date next week. I'm not sure how much you can get done between now and then.
Probably 2 weeks, Judge, if you have something available.
Well, the only things I've got February 5th, which is next Thursday, a week from today, and then I've got February 26th, those are my miscellaneous dates. So I can put you on either one of those, but again, if I can sneak y'all in for a plea anytime that we can get everybody in the room, we can certainly do that. I know, Mr. Ramey, with your current situation as far as the travel, might be difficult, especially speaking with Mr. Heaton privately. But however I can do that to promote a resolution, I'll do it.
Yes, sir. Not sure the 5th gives us enough time to do that. So we set on the 26th and then try to look at a date where we sneak it in once we get all the paperwork done between those two.
Okay. All right, so what I'm going to do, Mr. Heaton, I'll put you on February 26th, but as I've said, and your attorney said, if we can get you in a day earlier, I know the next 2 weeks after that 5th date, I've got a trial set, but it's not going to take the whole 2 weeks. So I can always find time. It's just about getting everybody available to handle it that way. But we'll get it resolved as soon as you're ready, as far as the program setup. All right, so February 26th at 9 o'clock, with the caveat we could bring it in earlier. All right, who else do you have, Mr. Ramey?
Judge, I have one other case that you set for a status conference, State versus Cheyenne Davis, 24 CF 1535, 24 CF 1060, 23 CF 2826, 23 CF 2800. She's in custody.
And she's present in the courtroom, Mr. Ramey.
And we've been working on, I've been working with Ms. Flowers and Mr. Mull to try to look at getting her into drug court. And when I spoke to Ms. Flowers yesterday, she didn't see any impediment to getting her in court, but she wanted to speak to Mr. Mull to be sure. And we have a case over here in Bay County where she has VOP that we want to send over for a global resolution, which our judge and prosecutor are agreeable to do, if Your Honor would be agreeable to that as well.
I mean, if drug court's willing to take her cases, has she been screened?
I've done everything, yes, sir.
Okay. Have you been to a drug court date yet?
Yes,
And
they
when-
said I was accepted and everything was good. I already went to the observation and everything. Yes, sir. I've actually been accepted for a month, kind of waiting for stuff to,
It's definitely drug court, right?
yes, sir.
Okay, there's a couple notes in here that just listed as mental health, which,
Well, that's how it started out, and then, yeah.
okay, I just want to make sure they're putting you on the right docket for it. When is the next time you're supposed to go to drug court?
Well, there really isn't a set date. Like I said, I've been waiting just for some paperwork from Bay County to be taken care of. They said they were going to hopefully try to get me in next week, but I've kind of been hearing that for a month.
I guess it really comes down to, can they handle it when you're still here? That may be the problem. Well, whatever we can do to make it work, Mr. Ramey, I don't have an issue with drug court. I think we've talked about it previously. It's in the court minutes that that's what we set today's status for. But until Bay County makes their decision, we're kind of in a holding pattern.
Yes, sir, and I've spoken with the prosecutor multiple times, and I expect to receive that transfer paperwork sometime either today or tomorrow, early next week.
All right, do you want to put it on the 5th, or do you think that's too fast?
I would like to try to do that, Judge. That would give me enough time if I do get it today or tomorrow or Monday to go over it in an electronic jail visit with my client and be set for getting it resolved on the 5th.
All right, let's do February 5th at 9 o'clock. That's 1 week from today, Ms. Davis, and then see if it all works out with Bay
Okay.
County.
Thank you.
All right, we'll see you next week.
Thank you, Your Honor. That's all I have. My big excuse.
Yes, sir.
Thank you, sir. Good to see you.
You too. Hope you're feeling better. I'm just gonna keep the Zoom on, so whenever they pop up, we'll know they're ready. All right. Who's ready?
Ready, Your Honor.
All right, come on, Mr. Maddox. It looks like I've got at least 5 of yours are the quarantine issues, so they'll appear by Zoom. I've got the Zoom up, so once they join, I'll tell you. Otherwise, we can handle your non-quarantined folks.
It's Ariana Davis Jackson. Your Honor, Ms. Davis Jackson's present, 25 CF 1265. We're here with a agreed upon resolution, Your Honor. Your Honor, may I approach?
Sir. All right, Ms. Davis, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Can you state your full name and date of birth, please?
Brianna Nicole Davis Jackson, 102689.
And Ms. Davis, is it Davis or Davis Jackson?
Davis Jackson.
Okay.
It's listed in the information how I have it, Your Honor. That's why I put it that way, I believe.
I just want to make sure it's accurate across all the different paperwork.
Double check, but I believe that's how it was spelled in the information.
Yes. All right, but I still want to make sure I'm calling you what your actual name is as opposed to the typographical error somewhere else. All right, Ms. Davis Jackson, you're here in 25 CF 1265. We are currently charged with battery on a law enforcement officer, which is a third-degree felony and punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that you've made with the state where it calls for you to plead to a lesser included offense of misdemeanor battery. That's Florida Statute 784.031A1. The agreed upon resolution is credit for time served and adjudication of guilt, so that's a conviction for battery. $622 in court costs, $100 cost of defense, and y'all agreed to do community service to pay off your costs, is that right?
Yeah, you can do the community service to pay off your costs. It's just an option. You can pay the costs too.
I don't know if I can do community service because I'm legally disabled and I'm having surgeries on my back.
That's fine. Well, you can pay the cost. That's not, I'm not requiring you to do community service.
Well, how long would I have?
Well, you can make a payment plan with the clerk's office. I can give you a period of time to go set that up, and then you just work that out with the clerk's office to pay the costs on a monthly basis.
How long do you think you need? Could you have 180 days to do that, Your Honor, based on her circumstances?
I'll give her 90 days to set up the payment plan.
Okay.
See where it goes from there.
Okay, all right.
All right. Do you understand that, Ms. Davis Jackson?
Yes, sir.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
And are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement you made with the state?
No, sir.
And do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are on page 2 of that agreement that you signed?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And do you also understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and what is your plea to the lesser included misdemeanor battery?
Contest.
And that's the state's agreement?
It is, Judge.
Okay. All right, I'm gonna accept your no contest plea to the misdemeanor battery charge as freely, voluntarily, knowingly given. I'm gonna give you credit for time served, adjudication of guilt, $622 court costs, $100 cost of defense. I'll allow you to do community service if you choose to do so for paying of your costs. Otherwise, you have 90 days to either pay your costs or set up that payment plan.
Okay.
All right, I will need your fingerprints because it is a battery conviction, and then you have 30 days to appeal the judgment and
Yes, sir.
sentence.
Thank you.
Thank you.
James Barrow. That motion for contact, Your Honor. I'll try and figure out where he's at. Rebecca Glover. I don't have any information on Ms. Glover, Your Honor. Unless she's in custody, but I thought she was released.
Well, she's not on my jail list.
And Kalia Ward, Your Honor, was
Hold
still.
on a second, let me take care of, let's see what's going on.
Oh, my apologies.
given to her on the 13th. This was a no bond warrant. She just happened to get me at first appearance. I gave her a bond, and then she didn't show up. KPS no bond.
Yes, Your Honor.
What do you have next?
Kalia Ward, Your Honor, 25 CF 517. She pled into drug court, so that case is resolved.
What was the case?
25 CF 517, Your Honor, Kalia Ward. Yes, Your Honor. And then I would just ask we pass James Barrow. I'm going to have my office reach out, see if there was some confusion over the time. But it's just a motion hearing on contact, Your Honor. Appreciate that. And that's all the out of custodies I have. Do you want me to go ahead and start with my custody?
Yeah. As long as
Okay.
they're not the people on the quarantine list. 'Cause they-
Yes, Your Honor. Your Honor, this is Mr. Arnett before the court in 25 CF 492. It is a VOP. It's first time up. Spoke to the state about this case yesterday. Don't believe they have any objection to the continuance I'm seeking.
Yes, Your Honor. To which date?
The next miscellaneous, which was February, did you say February 26th?
26.
26th?
Do you just,
That would be fine.
Okay.
you
And
want it
it
with subpoenas or without?
No, without, Your Honor.
Okay.
Although I anticipate that at that point we'll know what we're doing, one way or the other.
That'd be fine, Your Honor.
Okay.
February 26th, 9 o'clock, no subpoenas. Mr. Arnett?
Your Honor, this is Mr. Comey before the court in 24 CF 1657. Your Honor, at this time we'd enter a denial. I would ask for the February 26th date without subpoenas.
No objection.
Without subpoenas?
Yes, Your Honor.
Does he have an arraignment date on his new cases?
I believe it's later this afternoon, Your Honor. We'd go ahead and enter a plea of not guilty on that case.
There's not an information filed, and I
Okay.
don't believe it is arraignment for this afternoon.
It might not be. I thought I saw him on there. If not, Your Honor, I'm fine tracking this VOP with whatever that arraignment date is and going from there as well, if that's what the court would prefer.
The case is set for 2/26.
Okay, perfect.
All right, so February 26th, we'll just put everything at 1:30. That's without subpoenas.
Yes, Your Honor. All right. Jail credit issue.
Yes.
Does the state object to awarding the credit? Hey, Mr. Crooks. We're dealing with your credit.
About the credit, Your Honor.
Well, let's announce the case. This is Damian Crooks, 19 CF 357. Just to make sure it's clear on the record, I received a letter from DOC talking about how the judgment showed credit for his jail time, but not for his previously served prison time,
Correct, Your Honor.
and wanted to know what the intent was. Obviously, I accepted the plea. I said credit for all time served.
Yes, the defense's position is he's entitled to all of the credit that was spelled out in that letter, Your Honor. I don't think there's any argument to the contrary that can be made, quite frankly.
And I went back and watched the plea from, I can't remember what the date was off the top of my head, but, and there wasn't any discussion of anything other than credit for all time served.
Correct.
I believe that he will be entitled to whatever amount of time he has served for the case.
So, okay, all right, so we'll have to get an amended judgment and sentence that shows not only the jail credit, but the DOC credit.
Yes, Your Honor.
Hopefully it'll come quickly, because I think that resolves his case. Because
It should.
I think it was a split sentence. He had done some prison time, then was on
Correct.
probation for it, then did several stints in jail during his violations. But he's obviously entitled to it unless there was some sort of agreement not to give it to him. But again, I went back and watched it, and there was no such agreement, so. All right.
I told you I'd watch
I'll
it.
just need an amended order on that.
Yes, Your Honor.
and we'll make sure that happens.
I am just going to adopt the exact timeframes given in DOC's letter unless there's any issue with that, which I don't think there is.
There wasn't for me. I didn't go
Okay.
back and double check all the dates because I'd have to check their system anyway to do that. So I assume theirs are all right, but I'll take a look at it before I sign the final order just to make sure their numbers are correct.
Yes, Your Honor. All right, thank you.
All right. Thank you, Mr.
Right, sir.
Crooks.
Your Honor, this is Ms. Chloe Cox before the court in 20 CF 3038. Your Honor, at this time, we'd enter a denial.
What would you like to set it for?
The 26th without, Your Honor.
No objection.
February 26th, 9 o'clock, no subpoenas.
State have an offer at this point on this case?
70.5 months DOC.
Okay.
That guideline.
70.5.
February 26th, 9 o'clock.
Thank you, Your Honor. Who you got next? Okay.
Looks like Mr. Tony's client is on Zoom now, but he's not here. Anybody have a number for Mr. Tony?
I'll text him.
I mean, his office is about 50 feet from here, so.
I did reach out to Mr. Barrow, Your Honor. He's going to be here soon. He's running late this morning. I apologize for that.
We'll see what he says.
Yes, Your Honor.
Dale Moore?
Elmore? All right, this is Mr. Michael Elmore before the court in 20 CF 219. Your Honor, could we pass Mr. Elmore to this afternoon? I might be able to work out a resolution.
Run for 2 o'clock. Y'all think you can work it out this morning? Well,
I
Otherwise-
want to give Ms. Flowers some time to review. I think I sent her an email, but if not, I want to discuss it briefly with her, so
I
let's
don't think
just,
they'll transport Mr. Elmore back and then bring him back again, so he's gonna sit here all day. That's the only reason I'm bringing it
you
up.
do have an issue with that, sir? Okay. Yeah, we'll pass him this afternoon just to make sure I have enough time.
2 o'clock.
Your Honor, this is Mr. De Lorenzio before the court, currently, I believe, in 23 CF 1858 and 23 CF 2393, the two VOPs. Your Honor, we'd enter denials at this time. I would ask for 226 without subs.
February 26th, 9 o'clock, no subpoenas.
He also has a new case that's pending, Your Honor, 26 CF80. It is presently here, Your Honor. I believe it'll stay with us. His other case is in Santa Rosa, so it should stay here. Is that scheduled for arraignment this afternoon? I don't think it was, but if it was, we'll enter a plea on it.
Ticket set for the 26th at 1:30.
Perfect.
Let's just put everything on the 26th at 1:30 then.
Yes, Your Honor. Your Honor, this is Mr. Austin Foreman before the court in 21 CF 1984. I would enter a denial at this time, would ask for 226 without.
That'd be fine, Your Honor.
All right, sir. Thanks.
Thank you.
That's my last one, right? Okay, perfect. Your Honor, this is Mr. Dustin Gallardo before the court in 16 CF 1549. Same thing with this case, Your Honor. I'd ask to pass it to this afternoon. We may be able to work out a resolution.
2 o'clock for a possible resolution.
Thank you, Your Honor. See if I can work it out, all right? Your Honor, and then just so that we're keeping track of everything, the 2 of mine that are in quarantine this morning are...
I've got a list of 2, Ottman and Brown.
Correct. Brown is going to be a resolution. If we can get him here or get him on Zoom or something, it would get him out today, Your Honor, so if possible.
He signed an actual paper plea?
No, I just worked this out this morning, Your Honor. The state and I were discussing it yesterday. But it would get him out. It would revoke and terminate his probation credit for time served.
Has he gone over a plea agreement?
I went over the particulars of them. If we were to work something out, yes, but no.
Well, not the terms of the actual agreement, but everything else that's in the agreement they have to be informed of and read?
It would be prudent of me to go over that again just to be safe, Your Honor. If the jail will let me see him, I'll certainly go down there and get the plea agreement. If they'll give it to him and have him sign it, I can do that, coordinate it, but I would need to be able to go over that with him.
Yeah.
Yeah, I mean, sometimes they'll let me do things like that, sometimes they won't, depends.
See what they say, since he's gonna be released today.
Yes, Your Honor.
I'll be sure they'll pull some strings to make that happen.
Yeah, the state is fine with whatever, at worst case scenario, the 5th.
Well, I'd like to handle it today if we can, but he just needs to be informed of everything that's in the plea agreement, so. Exactly.
Yes, Your Honor.
Just make sure
But
that.
I'll make it happen one way or another.
Okay.
And then Jeremy Ottman, excuse me. We may get that one worked out, not sure yet. We'll see.
We'll work on that, so we know.
Yes, Your Honor.
Both quarantine.
Thank you. That's all I have right now.
All right, thank you. Mr. Russell?
Morning, Judge. I have 2 cases on the docket. Nicholas Atkins. Mr. Atkins is present and approaching. Case numbers are 23 CF 373, 23 CF 531, and 24 CF 1457. Mr. Atkins' cases were passed to today. We were waiting for an updated evaluation from Dr. Zeman. We got it. I provided copies to everybody, but to make it official, I want to file a copy. I've got a copy marked as Exhibit 1, ask that it be filed with the clerk in order that it be sealed. It's my understanding that the state is going to ask for a second evaluation. May I approach?
So I don't know if it'll be sealed as much as confidential.
Okay, as long as it's not.
I want to make sure that I use the right clerk terms.
That's fine, Judge.
And I've reviewed it, so you can give that directly to them. I received one via email yesterday and reviewed it yesterday.
I was going to suggest March 26th, Judge, and then we can move it up, should we get the report before then. State was going to ask for Dr. McDonald, I believe.
So I'm just trying to get to your cases.
Oh, I'm sorry.
That is-
Number 10.
It seems like every docket has a different order. You said that you have it as 10?
On my docket, Judge, Nicholas Atkins.
There it is. What date did you ask for? You said the 26th, but did you say February or March?
I was going to suggest March because it's going to be Dr. McDonald, and then if we get the report sooner, then I can try to move it up, but
State,
Without objection.
and you're asking for a second evaluation?
That is correct.
All right. Let's go March 26th at 9. Purpose of a second evaluation.
thank you, Judge.
Thank you, Mr. Have a good day.
And then the other case I have on the docket, Judge, is right after that. Joseph Carroll, case number for the record is 24 CF 2383. I had set Mr. Carroll's case for a bond hearing today. It's my understanding from security that he refused to be transported. So I would propose to leave it on the 225 pretrial conference date. I will go see Mr. Carroll and find out what's going on. If he wants to reset the bond hearing, I will. Go from there.
I was just gonna ask, so for the purposes of today, I would ask the court to deny the motion, and then if they want to have a hearing, they can file it again.
I think it just gives Mr. Russell extra work to do, or his assistant.
Yes, sir.
So it's just not going to be heard today. It can be reset.
Right.
So, but I should expect another notice of hearing.
You'll get another
Okay,
notice.
okay.
Right, right,
Yes.
Basically, that's what I meant, to have, yes.
No, I understand now. I think we're all on the same page.
Okay.
So it'll go to the 225 pretrial at 9 o'clock. But if you want to have another bond hearing, just do another notice.
Yes, sir. Will do.
Thank you, David.
Thank you,
All right,
Judge.
thank you. And Mr. Russell, I looked into that. The reason you asked for the bond hearing, at least it was on your motion, I didn't see a case number for that, so.
It took me a while to find it, Judge. I can. It's not under Joseph Carroll, it's under Joe Carroll.
Gotcha.
And that's why I couldn't find it.
If I call this guy up. No, go ahead.
Judge, do you want the case number?
Yes, just so I can take a look at it.
The foreclosure case number is Okaloosa County, 25 CA 3072. And the parties are,
I can look at it, Mr. Russell. I'm just, based on the case number, it's clearly recently been filed, very recently, so. I just wanted to see kind of what the status of it was, but we'll readdress it if you set for another bond hearing. Anybody else?
If I may recall Mr. Barrow, Your Honor, he's here. All right, this is Mr. Barrow before the court in 25 CF 2191. We're here on his motion to amend the pretrial release conditions, just requesting a no violent contact order at this time. Certainly, Mr. Barrow is happy to answer the court's questions if the court wants to inquire as to why he was not here.
Barrow, we started at 9 o'clock. Where were you?
I was confused about my presence being required at this one. I thought my next one was the 23rd of February.
Okay. Was there, the motion says that there was an affidavit requesting no contact be lifted.
Correct, Your Honor. I did provide that to your judicial assistant, but I have a copy here for the court as well. I also have a copy for the state if the state needs another copy.
State's seen it.
State object?
State objects.
Okay.
Based on my reading of the facts and the very limited nature of the affidavit, I'll reconsider it if she wants to come in and testify to these things, that she
Okay.
wants contact and that she hasn't been forced, pressured, or threatened in any way. Just normally, when I receive those types of affidavits, if that's not spelled out, I've got a concern.
Okay.
That, but you know, we can set it as early as next week on the 5th, but without more information and the very concerning allegations in the arrest report, without having her here, I don't think I'd be willing to grant that.
Understood, Your Honor. Let's tentatively set it for the 5th then. Let me see if I can reach out to her and have her present for the 5th. If not, I'll certainly alert your office and we'll get it rescheduled for another time, but I understand the court's concerns and we'll address those.
Are there any other pending cases, family law cases or anything like that? I didn't see any, but
To my knowledge, Your Honor.
it's again based on the facts that were discussed in the report.
Understood.
All right, put it back on February 5th at 9 o'clock for her to come in and tell us what she would like.
Yes, Your Honor. Understood.
All right, otherwise, there's still no contact, sir.
Sure.
So, any contact between now and then could be considered a violation of your pretrial release and lead to you being rearrested.
Understood, Your Honor.
And that includes not only direct contact, but third-party contact. So you can't tell her, anyone to tell her messages or try to convince her to do anything else. All right. Thank you.
Thank you, Your Honor. All right, well, it's for the 5th, so make sure you're here.
Mr. Tony, I believe your client is on Zoom.
Judge. Your Honor, in case 2025 CF 2184, pursuant to negotiations with the state's attorney's office, the defendant withdraws his previous entered plea of not guilty and in return pleads no contest to the misdemeanor charge of possession of paraphernalia. Adjudication is withheld, and we be responsible for all court costs associated therein. May I approach
Mr.
you?
Rodriguez is on Zoom, but I don't see a video yet. There we go.
Approach you.
Yes, sir. All right. And if you could unmute yourself, Mr. Rodriguez. All right, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Guess no morning classes today, huh? All right, can you state your full name and date of birth, please?
Michael Rodriguez, 1607.
All right, and Mr. Rodriguez, I've been given a plea and sentencing agreement that would call for you to plead to misdemeanor possession of drug paraphernalia in violation of 893.147. Is that what have you gone over this agreement with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Do you need any more time to speak with your lawyer about it?
No, sir.
Are you satisfied with his representation and advice in this case?
Yes, sir.
All right, terms of the agreement are that it would be a plea to paraphernalia, withhold of adjudication. What's that, $270 in court costs? And $270 in court costs. I can give you 30 days to either pay those or get a payment plan set up since there's no probation. Is that what you want to do? Is that what you want to do, Mr. Rodriguez?
Yes, sir.
All right. Has anyone forced you to do this?
No, sir.
Has anyone promised you anything other than the terms I've just read?
No, sir.
And do you understand that if you enter this plea, there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which are on page 1 of and page 2 of that agreement that you signed?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
Okay, and what is the plea to the misdemeanor possession of paraphernalia?
No contest.
Mr. Rodriguez, your plea? Guilty, no contest, or not guilty?
No contest.
All right, I'll accept your no contest plea to the misdemeanor paraphernalia, withhold adjudication, $270 in court costs. You have 30 days to pay those or set up a payment plan. You have 30 days to appeal.
Yes, sir. Thank you.
That's all I have, Judge. Thank you.
All right, thank you, Mr. Tony. One more person on Zoom, I'm not sure who it is. Is there a Miss Gilmore on Zoom? Miss Gilmore? Is anyone else expecting somebody on Zoom? Sharon Gilmore?
Judge Nico Herbert, we did a motion for him to appear by Zoom. Nico, if you're on as under somebody else's number, you need to unmute yourself and respond.
I've asked them to start video and unmute. And all right, we'll see if they pop up. I'll give them a few more minutes, but. All right, Mr. Williams, you said Mr. Williams is. All right, your inmates are ready.
Thank you, Judge.
Gilmore just disappeared.
Okay. Give me just a minute. I've got a Robert Hall, but Ronald Allen would not normally be.
Time I come to court, it was dated off to February 25th.
I thought it was regarding status on a eval.
Yeah, I do have Ronald Allen on staff, Judge.
I signed an order appointing a second expert for evaluation back on December 19th.
That evaluation was for the state judge. I think we already provided Dr. Zeman's findings.
And then on 12/23, we set it for the 25th of February. Mr. Allen's correct. I'm not sure why it's on this docket, other than potentially status as to see if whether or not the evaluation was done. Does anybody have any information on the evaluation to be done for Mr. Allen?
Judge, that's for the,
All right, Mr. Sprouse, is this your case, Mr. Allen, Ronald Allen?
I don't believe so.
You're listed on my
What's the charge?
system.
Just based on
Possession
what
of a
he's-
weapon or ammunition by a convicted felon, firing a missile into a dwelling, ag assault, criminal mischief, resisting without.
the first two
What-
are F2s.
I'm not sure why it's on this docket, because it was set for the next pretrial, but for some reason it's on this docket, and there's a second evaluation for competency that's no one's seen yet, and it was ordered over a month ago.
I have not reviewed his case because I don't believe it was on my docket, Judge. But I can check.
Well, I see a notice of hearing from. All right, Mr. Williams, looks like your office filed a notice of hearing all the way back on December 16th for today for a competency hearing.
Judge, I
But
don't
it doesn't
know.
seem to have been discussed back at pretrial.
That's correct, Judge.
All right, why don't we leave it on the pretrial for February 25th? If y'all could follow up on that evaluation, make sure it's been done. And then we can either discuss it that date, or if you get it early, you can try to bring it in early, but I don't really have much earlier than next week.
Yes, sir.
Or other than next week, yeah.
Thank you, Judge.
All right, thank you,
All right,
Mr.
thank
Allen.
you. All right.
Well, I guess, you want to ask
There, the
Mr. Allen if
Thursday.
he's talked to the second evaluator?
You haven't?
Okay, let's follow up on that to make sure it gets done, because I signed that almost 6 weeks ago.
And forgive me, the second evaluator is who, just so I can put it in my notes?
Dr. McDonald.
McDonald, thank you.
We already have Zeman, so it must be McDonald. All right, this is Brandon Dykes, 21 CF 1811 and 1909. I believe we're here for a Nelson hearing, is that right?
That's what I have, Judge.
Mr. Dykes, can you raise your right hand? Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
I previously read your motion, your request regarding a Nelson hearing, but now that you're here and under oath, tell me why you'd like to have Mr. Williams removed from your case.
Your Honor, I truly believe that we're nowhere near the same page, but that's just not the worst. Can you hear me?
I can hear you.
That's just not the worst of the issues, Your Honor.
Well, I would need something more than we're not on the same page.
We had a specialist come in, and I had given my attorney a lot of information leading up to that. I was present only for a video conference with the guy, Sawicki, after he had done everything. And when I told him, you know, what I had told my attorney, he said, he asked, the camera, I guess he moved over to him and he asked, why didn't you give me this information? I could have used this information. It would have been helpful. It was the whole reason why he was talking about having to go back is because had he had the information in the first place, he wouldn't have to go back through the phone again for another time. That was one of the issues, and he said that he should have known that he could have used the information. It was very pertinent in my case. that was one of the things that happened. And then we came to court about a month ago, I guess, whenever you had just gotten the Nelson hearing on your desk, and we gave me this hearing date. And he said that he had been to see me twice since that date, and that was just completely not true. He hadn't been any since we talked to the guy, Sawicki, on the conference call. He hadn't been back at all since then, but he told you twice that he had.
When was the conference call?
Your Honor,
Ballpark.
I can't remember if I had it added here. I had somebody write this for me with the notes that I've taken. It was, I guess, Your Honor, I can't give an exact date. I would think it was summertime. It was before my birthday, I believe.
I don't know when your birthday is, Mr. Dykes.
September.
When's that?
Prior to that. But we hadn't, the only time I had spoke to him again was when we met in that little room back there off of this, and he said the only reason he was in here was it was an exercise in hand-holding. I had asked to speak with him before. I had sent letters to the public defender request forms that we get. But the last time I spoke with this man, besides that little room back there for 2 minutes, was when we had the conference call with Mr. Sawicki prior to September. I've asked, I said, you know, the biggest thing was talking about, he came in when a few months after I met him and said that the state was just looking for a death penalty case, and that I was right, that there was a chance, and just the way it was spelled out to me, the only thing that I got out of the whole deal is, oh, well, there's a chance that they're gonna try you with the death penalty on your case. That same meeting, I said that I wished to engage in further plea negotiations, and on his way out the door, as I was going to the little holding cell there, he said, just remember, the state only needs one. The state only needs one. I felt severely intimidated, not by the fact that I know the severity of the case against me, but that I had just heard about the deal less than a month earlier, and it was at this podium, I believe with Ms. Rivers, that I even heard that the deal. We hadn't discussed anything to that point. And what else? I did make.
Just make sure it's clear, though, that this case is from 2021, so it predates a law change on this being a capital. I mean, it's a capital offense, but it's not punishable by the death penalty. Correct?
Judge, when it's my turn, I'll
okay.
explain if he's either completely misunderstood or is completely mischaracterizing. And the law change doesn't change Supreme Court opinion.
Well, that's not for us to discuss today, but this case predates the change in the law that would even allow for a death penalty in such a case, right?
That's correct. What I was doing was I was going over the initial plea offer with him, and I have to go over what he's charged with, what degree offense it is. So I was explaining to him that it's a capital case, all right, that there are cases that...
Hold on a second, Mr. Williams. I'm not sure whose device that is, but it's at least the third or fourth time I've heard it, so please silence it next time it gets taken.
That there are certain hoops...
All right, hold on. Whose device is it? All right, turn it off. Completely off. That's 4 or 5 times now. I'm sorry, Mr. Williams, go ahead.
That capital cases are punishable by either life imprisonment or death, but that there's both a Supreme Court case that says you can't get the death penalty in anything other than a case where a death occurs, as well as there are certain hoops that they'd have to jump through. First being they'd have to get a grand jury indictment. Then they'd have to file notice of their intention to seek the death penalty. That if it was a death penalty case, I'm no longer death qualified. They changed the qualification requirements, and so I wouldn't be handling the case anyway. So effectively, the death penalty is not an issue in his case. That I do think the state of Florida is planning on, trying to seek the death penalty in some other cases, but I explained to him that doesn't apply to him. I'm just explaining what a capital case is. And at no point did I threaten him or tell him that, I was going to do anything like that.
Anything else, Mr. Davis?
Yes, Your Honor, he didn't threaten me, no. Like, I felt threatened by the comment, but I was the one that informed him. I said, I think the law says, based on my limited knowledge, that they would have had 45 days to bring that notice from the initial charge anyway, yada, yada, yada. And he said, well, I think that's changed. That's how the conversation went. But I gave a counter offer to the plea. I haven't heard anything back from that, and that was prior to August.
I just want to make sure, I'm not asking y'all anything as far as what plea negotiations have been made. So anything, information you give on that would be, you voluntarily telling the court. I don't typically get involved in that kind of discussion. So I just want to make sure you know that you don't have to tell me what they offered. At some point, we'll talk about that if the case is going to trial, because I want to make sure that you've been conveyed all offers, and all offers that you've made have been conveyed to the state. But I don't think we're at that point yet. But go ahead, Mr. Dykes.
Thank you, Your Honor. I have repeatedly to this office expressed my, I'm sorry, I'm reading from this, but I'm a little nervous. I have repeatedly expressed my desire to cooperate with law enforcement on several things. Not just, I understand this is about him directly, my understanding of a Nelson hearing, but I keep hearing the Charles Russell this, Charles Russell that. That's from Lisa Rivers prior to him. I heard it from every public defender before. Charles Russell doesn't do this, doesn't allow us to do. Charles Russell was my attorney for like a week. I never met the guy, but I know he was on my case. But I had expressed a desire, and according to the paperwork provided to me by the public defender's office, my public defender is required to be at any interview with law enforcement while I'm in custody that I have. I have expressed it very openly several times, the 2 times prior to our meeting with Sawicki, that I wanted to cooperate with law enforcement. And I was told that if I wanted to do that, I would have to arrange that around him, not through him or with him. He'd have nothing to do with it. And I said, well, so I would have to have my mom call and do this, because the jail won't let us contact those guys unless it's like something happens in the jail. But I was told I had to go around it, but I went back through my paperwork because I was positive that I couldn't go around him. My initial form with the public defender's office says he must be there and that he will be there. And that, I've had too many opportunities, Your Honor, to do more than the right thing, and one of them was a major deal where somebody was attempting to have somebody killed.
All right.
But
Mr. Williams, I'm not sure if you have any advice for your client at this point. But
You need to understand, you're being live streamed. Everybody who wants to log on to the
sorry. That was that. That's been ongoing for quite a while.
Judge, if I can respond. Judge, I generally don't know and don't want to know who the target of the investigation is because our office may represent them. So typically, law enforcement will get involved, they will talk to them. At some point, I might ask, all I want to know is the individual a public defender client? And at that point, I would move to withdraw from this gentleman's case because I can't be in a position where we're representing Joe Sixpack and I now Joe Sixpack is under other investigation and somebody's going to say I should call him and tell him, but I'm not going to call him and tell him because I've got other ethical obligations. So this is the way I've always done it. Also, this is the type of case that typically substantial assistance is not something that the state lights on. The state is interested in. I have negotiated.
Has there been a plea offer conveyed to him?
I have. That's how we had the initial conversation.
All right. Now, did he ask you to go back to the state with a different offer?
I did talk with Ms. Barrettman. We've talked back and forth, but they're adamant on what they want. Now, I've not gone out to see him again since he said that he was going to file a Nelson inquiry. I was getting ready to go out and see him because it'd been a month or so and he still hadn't filed it. And then he filed it before I actually got out there. As the court's aware, generally once they file a Nelson inquiry, we don't do anything else on the case, and I certainly don't want to go out and have him say I tried to talk him out of a Nelson inquiry. I don't.
What about meetings with him before? He claims that
I have met with him, Judge. With regard to the I've unfortunately had meetings with him that I haven't logged in Stack. I do have the Zoom meeting. The Zoom meeting was August 29th.
August 29th?
August 29th was the Zoom meeting with Sawicki. It was shortly after the Mr. Sawicki set it up, asked us about it. It wasn't long after Sawicki and I went down and viewed the videos. Mr. Sawicki never said any of the things that Mr. Dykes is claiming he said. He never expressed any dissatisfaction with me. He did indicate that he was going to review his notes, although my reaction of when he talked about reviewing his notes is I spoke with him again and asked him, can you give me a definitive answer? Is there anything here that's helpful to this?
I don't want to have you disclosing contact with experts on what their reports are if they haven't written them yet. But
well, I have had contact. We have, both myself and Ms. Rivers have had instances where he's been difficult to get a hold of, but we have persisted, although frankly I stopped persisting once he filed the first request for a Nelson inquiry. I go out and see him, he'll tell me, oh, I've got all this stuff that I want to, I'll say, all right, well, give me names, addresses, and a brief description, or phone number, and a brief description of what they're going to know about your case, and I'll talk with them about it. He says that he already gave it to a previous attorney. I've not been able to locate it. Or I'll come and see him and he'll say, well, you know, I have all this stuff that I wrote down, but I don't have it with me because I didn't know that you were coming out today. In all honesty, Judge, with regard to the remark about hand-holding, at one point, shortly in the case, I told him, I said, well, I tell you what, I'll just make an ongoing appointment to come out and see you every week. And he said, well, that's not really necessary. I said, look, part of this job is, you know, getting to know each other and a degree of hand-holding, making sure you understand that there's somebody there and that they care. I don't mind doing that. And then eventually he said he didn't need to see me that often. The ongoing thing is that he doesn't want to be transported down. and he doesn't want to push the case to a conclusion. He feels like it's being pushed to a conclusion against his will.
Well, it's going to be pushed to a conclusion, Mr. Dykes, because it's a 5-year-old case.
I understand, Your Honor. Item number 2 was, I have provided those addresses and phone numbers. One of those people I talk to daily, 2 of those people I talk to daily, neither of them have ever, that number was provided to Olivia Ramsey, Timothy Gibbs, Lisa Rivers, and this gentleman. Nobody has ever reached out to get that cell phone. Nobody has ever reached out to get that digital evidence that I'm not going to say who has it or what it is. Nobody has ever reached out for those. And yes, Your Honor, I did provide 68 pages to the court openly of conversations between my wife and I several years ago, where she was, besides going to, I don't know if all the conversations there, besides drive my kids off into the river, if I didn't just sign the divorce and settle, if I tried to take it to trial with Judge Ketchel. I provided all those where she said she was going to find a way to take my children from me in October of 2020. I provided those notes openly to the court, Your Honor, in legal format, because the day I was arrested, I was headed to court to take custody of the children from her because of her ongoing abuse of them. But I'm sorry, that information is provided to their office for several years. I did again provide the address, the phone numbers. I don't know. My mother has had to move because she sold her house to bond me out, which funny phone conversations, and a couple days after she got the money to bond me out, my charges were raised. Additional charges were added. And my bond was set $100,000 higher than I could have afforded. But other than that, I've discussed many things, factual information that's in the case that I never spoke to anybody. Not at the pretrial people about being a $40 million bond and all that stuff. I never said anything to them. I actually told them I have a lawyer and I wouldn't speak with anybody that morning. But these are, again, things that I have discussed with this gentleman and Lisa Rivers and Timothy Gibbs, because those are the only 3 lawyers from this office that have come at all to see me since I've been locked up. Mr. Gibbs had a lot of stuff moving forward, needing that information from those people, but unfortunately, I don't know his situation. I know it was unfortunate, whatever happened, from rumor mill. But there is evidence that is not here. There's body cam footage.
Mr. Dykes, let me just stop you for a second. Mr. Williams says he doesn't have it. Do you have the information you want him to have?
We've had it, Your Honor. He refused to reach out to get it. He's literally, every conversation we've had, it's pretty much plea bargain or trial. There's no, let's get this, no, let's get that.
When did you provide the information about this witness?
When the very first, I gave those phone numbers the very first meeting with this
Mr.
gentleman.
Dykes, let me just rephrase my question then. On what date do you think, I don't know when he first came to see you. I don't know when your birthday is. I don't know when these things are. When I ask for a date, I need a date.
The first time we met, sir.
No.
I believe it was sometime beginning of last year.
I'm showing like January 14th. Spoke for nearly 3 hours.
All right, so Mr. Dykes, are you saying you provided this witness information to Mr. Williams on that date in January?
I provided the witness information up front. He wanted additional paragraphs.
Mr. Dykes, these questions aren't hard.
Yes, Your Honor.
Did you provide that information in the meeting in January?
Yes, Your Honor.
Okay. I ask my questions the way I ask them because I want a particular type of answer.
Yes, sir.
Okay, so just answer what I'm asking you.
All right.
So Mr. Williams, can you confirm he gave you witness information over a year ago?
No, Judge, I can't. My recollection is that he said he'd given the information previously to one of the previous attorneys, I think Brandy.
But I guess my concern is, Mr. Williams, if you met with him for 3 hours and he said he gave you information to a previous lawyer in your office and you don't have it, why is there not a meeting to say, okay, I need that information again because it's seemingly disappeared and I want to do my due diligence now?
Judge, we talk about this almost every time that I go out there. It's inevitably, well, I didn't know you were coming, so I didn't put it together. You know, I need to put it together and bring to you. And so we spent a while, the 3 hours was talking about his marriage and, you know, how things kind of went this far south, I guess. Then I've got 429, spent about an hour with him. He's got a long list of complaints about the system, previous attorneys. He explained to me how he thought his ex-wife had accomplished this.
I'm not asking for what you necessarily talked about, especially if it's potentially strategic.
Part of it was, I told him I put him on the jail list for a follow-up to get the information from him. And so on 5/1, I go out to see him, and he's still trying to get me witness names with a paragraph and what they would tell me about.
All right, so let's stop there. Mr. Dykes, he says that you were going to give him names back in May. Did you give him the names again?
Your Honor, the names were provided up front, and to both.
All right, Mr. Dykes, did you give it to him in May? That was my question.
I can't recall the exact date, Your Honor.
Well, when you say up front.
I wrote paragraphs on
Mr.
his
Dykes,
stuff.
I'm talking now. I want direct answers because my concern right now is that you're in a case that's been pending for 5 years, right?
Yes, Your Honor.
Okay. And I'm trying to make sure things are happening timely since I've taken over the case, okay?
Yes, sir.
So if he says he doesn't have the information, then you need to give it to him. And telling me I gave it to him up front instead of answering I gave it to him on such and such dates or which particular meeting, was it the first one? Did he ask you again in May? I'm trying to follow up on these things because you have had several lawyers during the 5 years of your case. But you can't just depend on, I gave it to him before. If they ask for it again, you have to give it to him. Now, he's telling me that you don't always bring things to your meetings with him. There's been situations where you've refused to come to court. So you have to take an active role in this too, Mr. Dykes. Go ahead.
Yes, Your Honor. I provided notes at a meeting. I don't recall exactly which one with him. We sat and I wrote out a brief paragraph next to the people he needed to contact and what they had on a piece of paper that had some of my information on it. Their office was given me a small little packet of information that Olivia Ramsey peeled out of a folder when we first met. I went through and wrote notes across the whole paper. That was provided to Timothy Gibbs. Those are my handwritten notes, and they are pretty much the only open notes I have on this case that don't pertain directly to the only other notes I have pertain to motions that could have been filed that other people have helped me with.
Okay, but if he's told you that he doesn't have the notes that you gave to someone else in his office, previous counsel, don't you have to supply those again?
Your Honor, I would love to. I asked for discovery. I literally got a packet from his office after they argued with my mother about how they provided one years ago. I got another packet of information which has, I understand that there's a lot of paperwork in these discoveries, but absolutely nothing that I had said during our final meeting, even with Sawicki that day, that I wanted in that discovery. None of that paperwork's there, or available transcripts, other information. But Your Honor, up front, when I first met this gentleman, he was very adamant that I asked a single question because I wanted to feel who he was. And that question was, why are you with the public defender's office after all these years? And he literally told me that the only reason he was there was because he has severe uncontrollable diabetes and the insurance is cheap. That showed me up front that there was a lot of indifference to his job. He is here to protect and defend us as clients to the best of his ability. But to tell me that you're only here for insurance, told me up front this information. I gave him the benefit of the doubt for over a year, now over a year. I understand that we lost these last few months for the Nelson hearing, but Your Honor, one phone call to one of those people that I already provided directly him the number, would have given, and all he had to say was, I'm with Public Defender's Office. That's it.
When did you give it to him?
I gave those numbers to him the first day we met. I gave him the phone numbers, Your Honor.
All right, Mr. Williams.
No, Judge, I don't have any record of that. And Judge, in terms of the part of what I'm doing, especially with somebody in as much trouble as this gentleman, is I try to establish a rapport. And a lot of times I'll ask, well, you know, why aren't you in private practice? I explain to him, I have been in private practice.
I don't want to get into that, Mr. Williams. I understand what your claim is and what he's saying, but I just.
Judge, in terms of copies, I'm going through, and I've got my secretary's notes, even back in September. Mom said defendant wants more copies of discovery on both cases. He's previously been provided with discovery. She also said that he'd spoken with me and that if he speaks with the sheriff's office, he wants me present. If somebody had contacted and said, okay, I'm speaking with officer so-and-so on this date, I'd have either been there or I'd have contacted the officer and rescheduled it for when I could be there. But nobody's ever contacted me about any of that. I've got, again, 10/23/25, copies of all discovery sent to the defendant at OCJ.
All right, so Mr. Dykes, did you get a copy of discovery back in October?
Yes, Your Honor.
What's the problem with the discovery then?
It's completely incomplete. It's a police report with some copies of certain, it's 5 copies of the same police report, almost 15 copies of the same, of multiple copies of the same documents. There's no transcripts of interviews. There are no transcripts of the phone calls that the state has added to discovery. There is, it's missing.
Has anyone played these interviews for you?
No, Your Honor. He said that, and he said prior to July, prior to that.
Hold on, Mr. Williams, are there recorded interviews that he's never heard or that you've never
Not
gone
that
over?
I'm aware of, Judge, but again, this was somebody else's case for a long period of time. Typically, David would go out and play those for him.
That's your investigator, correct?
Yes, sir.
Has that ever happened, Mr. Dykes?
No, Your Honor, I've never seen anybody but the lawyers, ever. This is the Public Defender's Office, Your Honor, and it's a constant thing in my case. I don't feel that they can be objective in any of this. In 4.5 years, we've had no movement. It isn't my fault.
Judge, looking at my notes, contains the phrase, he's never been able to give specifics on anything.
All right, I don't want you reading off your work product notes at this point, Mr. Williams.
I'm just trying to, and on a case like this, I've got to go back to my notes.
I understand. This is what I'm going to have you do, Mr. Dykes. You need to give him in writing what you want him to do. Particular witnesses, you don't have to file it with the court, obviously, but there has to be a written record of these things. Because when it's just a conversation, you say this happened, he says it didn't, I don't know what happened, I wasn't there, there's no recording of it, obviously. It's a conversation you have with your lawyer in the jail. But if there's something missing from the discovery, what I want, Mr. Williams, is give him a copy of each of the discovery exhibits. Not necessarily everything that's in them, so he knows what's been provided, and he can then tell you what he needs out of those that he doesn't already have.
You're talking about the exhibit?
The exhibit that gets filed with the court. And if there's recorded interviews that he can only watch with someone going to bring them to him, then that has to happen. And if it doesn't happen before we have our next pretrial date in February, then we're gonna have a problem. Mr. Dykes?
Your Honor, you said this back before July, you told the same thing. I was supposed to have a competency hearing, a mental health evaluation. I have severe learning disabilities. This only came from my little notes. I can't work with this guy. And I respectfully ask that you get this office off of my case. I don't want to go at this alone, but that's going to be my only other option. I can't work with these.
Well, I've spent 20 to 30 minutes talking about this now, Mr. Dykes. I've asked specific questions. I've asked, have you followed up with certain things, and everything you keep saying is, well, I gave it up front. You won't even tell me who you gave it to and what approximate date you gave it to them. Provide them with what you want them to look at, what you need to look at yourself, and then we'll come back and we'll talk about it. But I'm not going to kick your third lawyer in a year off of the case because you say this hasn't happened when he has notes to say otherwise. So that's what's going to happen.
I would like to request to represent myself.
Well, then we'll set up a FREDA hearing. It's not going to be today.
Yeah, just so you're aware,
I'll just point out, you told me that you're concerned about your own competency and your abilities. So I'm not sure where that's going to go, Mr. Dykes, but I'm not saying this is the end of it, but you have to give me more.
Judge, back in '23, we had him evaluated. Well, wait a minute, no, this was the authorization for Sawicki.
All right,
I've never spoke with anybody from mental health since I've been there, and the guy that works at the jail told me if I'm not going to kill myself or somebody else, there's nothing he can do for me. That is the extent. That's the extent of what they've done.
The mental health people in the jail are not the people who do competency
I
evaluation.
understand, but nobody has
Mr.
ever
Dykes,
seen me.
have I interrupted you?
No, Your Honor, I'm sorry.
Then give me the same respect I've given you.
Judge, I will check, make sure that we get, in fact, I'll just style it as a follow-up eval. My understanding is that the one was done very early on in the case, but it may be that I'm confused that was when we initially tried to contact Sawicki. But I'll check into it, and I'll get him scheduled for an evaluation. Follow-up, if not the original. But this sort of interrupting and going down a different rabbit trail is part of what we're dealing with when we talk.
Mr. Dykes, your Nelson motion is denied without prejudice. You can bring it back. I'd like to know how things go. I don't want to hear about the conversations you have as far as what y'all talk about, because I don't want you divulging your own strategies or confidential conversations. But if the things that I'm talking about aren't done, you providing him what he needs, whatever he asks for, and vice versa, then yeah, we're going to have another discussion about this.
Yes, Your Honor.
And if you want a FREDA inquiry as to whether or not you can represent yourself, you're going to have to file something.
I can barely conversate with this guy. I got to do something. I'm not trying to spend the rest of my life in prison. I can't, I'm sorry, I can't continue because I may divulge something. I'm sorry.
Okay, well, I don't know what that means, Mr. Dykes, but I've denied your motion at this point. If you have any other further motions or inquiries or requests, you can do that in writing.
Thank you, Judge.
All right, thank you.
Thanks. Judge, did you want us to schedule a FREDA on it, or?
He hasn't filed anything yet.
All right, Judge. So you'll need to file something in writing if that's what you want.
He already has another court date, right?
He does, Judge. He's on for the 20th.
February 25th, 9 o'clock.
Judge, we've got a negotiated plea in this.
Hall, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Robert Lee Hall, 7/16/73.
All right, Mr. Hall, you're here in 23 CF 160 on a violation of probation. Do you understand that?
Yes, sir.
I've been handed a plea agreement between you and the state that calls for your probation to be modified to extend your probation for 2 years. Complete your original requirements. Is this inpatient rehab required under an Alabama sentence?
Yeah,
What is
he's
that?
got an Alabama sentence, Judge, it's requiring rehab. We want that to count for his stuff.
Okay.
The idea is to get.
But I don't know what it is. I mean, what is the program?
I don't have any further detail other than he's been sentenced to a program in Alabama. And I don't want him to have to do 2 programs.
I understand that, but what is probation going to verify what he's doing if we don't even know what the program is?
They'll have to provide, proof of.
But if I just say, do whatever Alabama says, then that's the only thing that can be enforced. What is the program?
Is it a substance abuse program?
I would assume so, based on the charges, but what is the program? Has it already been ordered by Alabama?
It's already been ordered. He was sentenced over there, sent over here, because we had a hold on him. And then upon his release here, he's got X number of days to report to the program in Alabama. That's one reason.
Is it some sort of like Alabama DOC program? Is it a private program? Is there a name for it?
Do you know the
Just a
name of the
rehab.
program?
It's just a rehab. I got to complete a 6-month rehab.
So, but he's already pled, so there's paperwork to this.
Yes, sir.
So we can get our hands on that, right?
Yes, sir.
Why don't we do that? Yes.
For the record, if he's going to Alabama, he would still have to go through interstate compact.
Right, we-
Pay the $125 fee and wait to be accepted before we can just send him to Alabama.
These are the kind of things I think need to be run through probation before there's an agreement, just so they can point out all of the common missteps that happen in this type of situation, and so they can verify what it is as well. And again, Mr. Hall, the whole reason I make sure of these things is so you know what you're supposed to do.
Yes, sir. I
And
know
me
what I'm
just
supposed to
saying, do what Alabama told you to do without being specific doesn't really tell you what I'm ordering you to do, because I don't even know what that is at this point. So we can bring them back later today, but having some idea on what Alabama has ordered him to do would be nice.
Can you tell me what court or what county?
Covington County.
Covington? Judge,
My concern is it sounds like everyone's doing this based on what Mr. Hall has told you has been done, and no one's actually checked into it. Bring them back when you have that information. We're going to take a 10-minute recess.
All rise, please.
It says that he missed an appointment, he said, and he got kicked out of his class.
Judge, this is Heather Heitker. This case is 2013 CF 1808. She also has a new law violation set, I believe, for the 26th of February for arraignment. I'm going to enter denial at this time and ask the two cases to frack. Maybe we can get a plea offer that will resolve it next time.
And an information in the new law case has been filed.
For the 26th?
Yes, sir.
26 at 1:30 for that arraignment, and this will go along with it without subpoenas.
All righty, ma'am. If I get an offer, I'll come out and see you, okay?
Okay.
Judge, Mr. Huertas is here for a bond motion. He's also got an arraignment scheduled for this afternoon.
How would you like to proceed, Mr. Williams?
Judge, we're requesting a bond from Mr. Huertas. He's been incarcerated since the arrest. It's been $19,000. Requesting a bond of either $10,000 or a signature bond. He's employed with G.I. James. He's been there for about 1 year. He's planning on residing with his boss off the racetrack. Were you ever able to nail down the, the address on that? And has lived in this area his entire life. And an information's been filed, so I'd like to go ahead and arraign him. Please not guilty. Request 15 days pre-arraignment motions and trial by jury.
State's position on the bond?
State's position on the bond is that it should remain the same. He's charged with tampering, possession of controlled substance, possession of weapon by a convicted felon, or ammo by a convicted felon. Just because somebody can't afford bond does not mean that it is by itself unreasonable. I believe given the charges that his bond is correct.
Judge, the presumption certainly is in favor of bond if we make.
That bond is.
I think it's.
The state's main concern is protecting the integrity of the system and the process, and given the tampering charges, given that this results from a search warrant that was conducted by a drug task force, I think it's a serious case and the bond is appropriate. And somebody's ability to pay is one factor in many that this court uses to determine an appropriate bond.
State file on both tampering or evidence issues?
Yes, on the tampering.
State filed a 4-count information, Judge. Possession of firearm, ammunition, or electric weapon by a convicted felon, possession of drug paraphernalia, tampering with evidence, specifically methamphetamine, and then possession of controlled substance, fentanyl. Here at arraignment, I'm not in position.
My concern, and I bring this up in almost every bond hearing that we do, that the three things that I have to look at as far as my concerns are danger to the community, flight risk, and integrity of the system. My reading of the arrest report talks about that he admitted to ingesting or eating half a gram of fentanyl once he heard law enforcement was there. So, number one, I'm surprised he's here. But two, that he also was accused of having things on his person, which then ended up in the police patrol vehicle.
That's correct, Judge, and that's the case that we filed on. That's the tampering charge that we filed on, is the methamphetamine in the back of the patrol vehicle, not the ingesting for evidentiary
I think
reasons.
someone willing to risk their life in order to potentially tamper with evidence shows me a concern that they're willing to do things to impugn the integrity of this system. Bonds will remain where they're at.
Thank you, Judge.
His next court date, do you want the 2/25 date? As far as this
Put him
pretrial.
on for 2/25. if you
All right, February 25th at 9 o'clock for your pretrial conference, Mr. Huertas.
Thank you, Judge.
I think the bonds are reasonable.
Judge, this is Mr. Hutto. Mr. Hutto is already on the docket for pretrial conference. I believe we're here for a Nelson inquiry.
Mr. Hutto, raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. I've previously reviewed your correspondence. It was directed as a letter to me, Mr. Hutto,
Yes,
but
sir.
obviously anything that comes to me has to be put into the court file so everyone can take a look at it.
Yes, sir.
And you made some concerns known about Mr. Williams and how he's handling your case, so tell me about that. What are your concerns?
I just don't feel like that Mr. Williams is able to represent me properly. I've also had.
Why is that?
I've asked him to do several things. I've asked him to come see me several times. I've given him case laws to apply to my case to try to speed this along because the state is trying to give me more time than what I should be getting. And
What does that mean?
they're offering 18 months when I only score out to like 9 to 10 months in county. They want me to do 18 months DOC.
Well, you don't score county. You either score prison or you don't. So.
Well, but I don't score out to prison.
Okay.
And I've given him case laws to apply to my case to have the charges reduced or dropped or whatever. Like I have case laws right now for one of my cases that it proved me innocent.
Okay.
Plus I've had prior conflict of interest with the public defender's office on 2 different occasions and prior cases that I would really prefer not to be represented by the public defender's office. It's nothing personal to Mr. Williams. I just don't feel like that there's been adequate time been applied to my case.
All right, Mr. Williams, your response?
Judge, my meeting with Mr. Hutto upon his return, he had been scheduled for trial, failed to appear at either jury review or docket day or jury selection. I don't recall now which. But he was wanting to go into drug court. And he had been denied drug court before simply because of a transportation issue. They didn't want, given where he was living and his lack of reliable transportation, for him to be in drug court. So he told me he wanted to go into drug court. I thought Terry Henderson was still doing it. I sent an email to her. The email was picked up by an Andrea Oliver, and she emailed me that she had taken over and that we had a discussion about, and I've got a copy of the email here. We had a discussion about what his score sheet was. I explained that we'd found some inaccuracies on his score sheet before when he was originally set for trial, and to corrected those, gave her the new score sheet information, and she indicated, that sounds great. I will see him tomorrow and keep you updated on the progress. I don't normally hear anything else.
When was that?
That was back on 12/11. And normally on a drug court case, I wouldn't hear anything back until they were ready for me to go out and go over the plea agreement with them.
Have you been out to drug court, Mr. Huda?
I went to one sit-in, Your Honor.
When was that?
The last time we come to court, the next day I had my sit-in.
Okay, so
The one sit-in.
right before Christmas time, right?
Yes, sir. Right after that, they said that I wasn't eligible for drug court because of a violent felony offender with special concerns. And they said that it was because of a guilty plea to an aggravated assault. But there was never no guilty plea to an aggravated assault. It was a no contest plea to an aggravated assault.
Not sure that matters to them.
But I don't see how it makes me a violent offender with special concerns. When I know people
it's
with
a
multiple
Sir.
violent offenses. Yes, sir.
Violent felony offender of special concern is a specific defined status in Florida Statute 948.06.
Okay.
So it's defined, and it has to do with what you're charged, what you've been charged with, what you've been convicted with, are you on probation? So I don't know if that applies to you or not, but that's what it is. It's not them making some decision that they feel some special concern for you. As far as what your past
I've
is.
repeatedly asked as to why there is this special concern, and nobody can tell me why.
I just did.
I mean, I understand what you're saying, but I don't understand the law in terms of statutes and this, that, and the third. But I mean, I've asked for it to be explained to me as to what is definitively causing me to have this special concern, because this has caused me not to be able to go to drug court or mental health court or anything.
2018 CF 2279, you were convicted. You pled no contest, but you were found guilty of aggravated assault with a deadly weapon.
Okay. I mean, I can't argue with what you're saying, because I don't know how the system works in that manner.
I understand. But if drug court says you're not acceptable to their program, then.
And I understand that completely. But that's why I'm trying to understand as to why they have me listed as a violent felony with special concerns.
Judge, this is.
Have I answered your questions now, Mr. Huda?
Partially. I mean, it's still hard for me to understand as to, you say that I pled to a no contest plea, but they made me guilty.
But you were adjudicated guilty.
How was I adjudicated guilty when it was a no contest? I don't understand. I don't understand that. That's what I'm saying.
Well,
There's things that don't get explained to me.
Do you want me to explain it to you right now?
I mean, it'd be great, sir.
You have three different things that you can plead: guilty, no contest, or not guilty. If you plead no contest, which means I'm not fighting the charges, I'm not admitting any sort of guilt. However, I think it's in my best interest to take that plea, an agreement that you made with the state, and part of that agreement is a felony conviction, adjudication. And that's why it's an adjudication of guilt, even if you pled no contest. Otherwise, people would just plead no contest all the time and never be convicted of a felony. But you were convicted of aggravated assault in the 2018 case that I referenced.
Yes, sir. Okay.
Judge, I will point out, we had him in court on the 22nd. I've not had any further correspondence from drug court. On the 22nd, I explained to the court that we were trying to get him through drug court, and that's why the case was continued.
So did they tell you on December 23rd or 24th,
No, it was like
whatever it was?
2 weeks later, they told me that because it was the holidays, the next week we didn't go because of Christmas, or the New Year, because it fell on the New Year. And then the week after that, they didn't come and get me, and I'm trying to figure out what's going on. They said, well, they decided to move me to mental health court. When they moved me to mental health court, I seen the lady Susan Thornton, I think's her name, and she said that they had considered me for the program, but then there was the VF, the special concerns, that she had to go and ask the assistant state's attorney if that was okay, or had to run it through them or something. I can't remember exactly what she said it was, that she was going to check into it. she never come back and see me again.
Okay, so, but we're here to talk about why Mr. Williams isn't
Yes, sir.
handling your case.
Yes, sir.
So what is the concern?
I mean, I've asked him to apply certain laws and stuff to my case, and we're not getting nowhere.
I don't
and we're
understand what
still
that means,
here.
apply the, I apply the law to the facts of the case.
Okay, yes, sir.
So what is your concern? Is there
I'm-
some motion to be filed that he hasn't filed? Do you want your case set for trial? I'm not sure what you're asking.
I want to resolve this as quickly as possible.
Okay. Well,
And that's
the
what I've been
state's
asking
offer,
for.
then your options are these. You can accept the state's offer or continue to negotiate with him. You can plead straight up to the court, and I can sentence you anywhere from probation to the maximum possible sentence. Or you can set your case for trial. What you haven't told me yet is anything that Mr. Williams has failed to do other than apply some law in general to your case.
I just don't feel like we're seeing eye to eye on what needs to be done.
Okay, but all I've heard is you don't like the plea offer.
Okay.
But without more specifics, you're not giving me anything to make a
I mean,
decision.
I just feel that there's a conflict between him and him because we're not agreeing on what needs to be done about
What are you wanting to have done that isn't being
I
done?
want him to apply the laws and stuff that I found. and-
Explain.
I mean, if we're gonna go into detail about my case.
Well, I can't get into the relationship between a defendant and his or her lawyer unless you invite me in, which is what you did with a Nelson inquiry. Now, if you would like me to make a decision based on what you think he hasn't done, you have to tell me what those things are. And just saying, I've given him some case law that, sir?
I'm sorry.
Have I interrupted you?
I'm sorry, I apologize.
Okay, it's okay. I just want to make sure that we're making a clear record here. You're not telling me what the potential issue is. Just saying he hasn't applied the case law that I've given him doesn't really tell me anything.
I don't feel that he's even reviewed my case to know what laws to apply.
Why?
'Cause in a fleeing and eluding case, it basically states you have to be pursued by a law enforcement officer. You know, and in my case, the officer didn't even come near me. He turned off and went another direction.
Well,
But then still charged me with fleeing and eluding. but
Here's
he's
the
not-
part where I would tell you that you probably don't want to talk about the facts of your
I
case.
understand that, and that's what I'm trying to say. I don't want to discuss all that, but
Well, I'm-
without trying to explain what happened and that I've told him this, and he's not even looked into that to understand what I'm talking about.
Okay, Mr. Williams, has he given you some case law that he wants you to
Calling
review?
specific case law, remember, this case was originally set,
You even showed me a
gosh,
copy, I'm sorry.
Mr. Hutto, no one's interrupting you. You
I know,
shouldn't
I'm
do it to
sorry.
everyone
I
else.
apologize.
Thank you.
well, back in 2024.
He failed to appear at pretrial on April 28th.
Was it pretrial or docket day?
I believe it was pretrial.
Yeah, I've got it 4/28/25, whatever.
It's a pretrial.
But we were planning on going to trial on it. And my recollection is, although it's been a while since I reviewed the videos because I thought he was going into drug court, was that the officer pursuant to department policy stopped pursuit because of the potential for danger. And that's fairly common if they know the license registration, that sort of information. And they can try to pick them up later. The other case has to do, if I'm recalling correctly, has to do with another individual that said that he had left, and there was no pursuit, but it's that civilian witness that pointed the finger at Mr. Hutto. And I don't want to go into the strategy either, but that's the focus of the strategy.
My reading of the arrest report, Mr. Hutto, was that when they tried to make a traffic stop, a passenger of the vehicle jumped out of the moving car and ran, and they focused on that subject. But explains not only the pursuit, but exactly what streets and what right hands and left hand turns and things like that. So I'm not sure what you're asking him to do by saying that there's case law. Are you asking him to file a motion to dismiss, or you want to
That's
set
what
it
I
for
would
a
like,
trial?
yes. I would make a motion for dismiss.
Okay. Have y'all discussed what a 3.190C4 motion is?
No, sir.
And that at the time, currently, before the rule changes, that you still have to swear to it?
Basically, you'd be swearing that everything they're saying happened exactly the way they said it did, but it's just not a crime. The point of it is to avoid there having to be a trial for either side. If there's a disagreement on the facts, that's what the jury trial is for.
Radio instructions to me. I don't understand.
So in order to file a motion to dismiss, to say what I did is not a crime, the current status of the rule of procedure says you have to sign that motion saying, I agree these facts were true. Then the court, the state has an opportunity to traverse that by saying those aren't exactly the facts. And then, again, the current state of the rule says then I have to deny your motion to dismiss. And now you've just admitted those facts under oath that can be then used to impeach you or even potentially seek a perjury charge against you if they turn out that you knowingly provided false information. I'm not saying that ever happens. In fact, I'm not sure if I've ever seen it as far as a perjury charge, because perjury is very seldom used in that type of circumstance. However, if you were to then go to trial and make it and then take the stand, the state could then use your previously admitted facts against you to say, no, that's not what you said in this paperwork.
I understand that.
So otherwise, the court doesn't make decisions on, I mean, you're basically asking me to have a non-jury trial and determine the facts. That's not how motions to dismiss work in the criminal system at the time. So I'm not sure what you've asked him to do that he's failed to do at this point. And frankly,
My most concern is I've had conflicts with the public defender's office before in different cases. I've had them change.
But without, unless I know the nature of those conflicts, and if it was just because of the, hold on, Mr. Hutto, I say this about once a court date, it feels like now. When all you're doing is ready to talk, you're not really listening. And so you're not listening to the things I'm telling you because you're just thinking about the next thing you're going to say to me. So I would suggest you take a breath and listen to what I'm going to say to you. Just because you had a conflict before, it could have been because they represented someone who was involved in that particular case. And maybe that conflict has now been resolved. I don't know. But just because there's a prior conflict is not a sufficient reason for me to kick the public defender off your case. What else would you like to tell me? Motion's denied.
Judge, we've got to negotiate.
Thank you. All right, Ms. Jones, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Ms. Jones, can you state your full name and date of birth, please?
Kaylin Nicole Jones, 10/15/1985.
Okay, and Ms. Jones, you're here in two cases, both of which are violations of probation. It's 23 CF 269 and 24 CF 702. I've been handed a plea agreement between you and the state that calls for you to admit that you violated your probation, and in return, your probation will be revoked and terminated. As unsuccessful, you'd be adjudicated guilty of those underlying offenses if you haven't already. Credit for time served, $100 cost of prosecution in each case, and $250 in public defender fees. Is that your understanding of the
Yes, sir.
agreement? Is that the agreement that you've made?
Yes, sir.
Is that the state's agreement? Is this the state's agreement?
Yes, Judge, that's the state's agreement.
Okay. All right, did you go over this plea agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Do you need more time to speak with your lawyer? Are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms that are in this agreement?
No, sir.
Do you understand that if you enter an admission to your violation of probation, there won't be a hearing where the state will have to prove that you violated your probation?
Yes, sir.
And do you understand you're waiving any potential defenses that you have?
Yes, sir.
And finally, do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to the violation of probation in those two cases? Are you admitting or denying that?
I'll admit it.
All right, I'm going to accept your admission as freely voluntarily given. Revoke and terminate your probation as unsuccessful, adjudication of guilt, credit for time served, $100 cost of prosecution for each case for a total of $250 total PD fees. I'm going to give you 90 days to either pay those fees or set up a payment plan with the clerk.
Okay.
Otherwise, they'll be sent to judgment. This is a guideline sentence as you scored 22 points. All right.
Yes, sir.
Was she guilty on the underlying? Do I need her fingerprints? Looks like guilty. All right, so I don't need your fingerprints, but I do need to advise you have 30 days to appeal.
Okay.
All right, thank you, Ms. Jones.
Thank you.
Judge, we did get our, this is Stacy Kagaris, 25 CF 981. Judge, we did get the evaluation back, and I'm able to proceed on her case. I went out and spoke with her at the time. We were trying to do an arrangement that would resolve the case. The basic plan was to give her a substantial suspended sentence. This is a situation where she didn't make it to the office as quickly as she was supposed to. She was told to be there the next morning when it opened. She wasn't able to get there that early. She was thinking that she was going to be violated or anyway. So I've talked with her about that. And the idea was to give her a substantial suspended sentence as an incentive to, and then have her go back in. Turns out that Ms. Flowers doesn't have this case. I don't know why I was thinking that it was in as a lower offense. I've talked with Mr. Sprouse, and at this point, I've not gotten a firm answer on it.
I emailed back no to the suspended sentence because it's always a fight about the suspended
I
sentence.
just got that you didn't like them.
Because it's always a fight to impose an agreement.
Okay, she's got about 7 months in. It would be a downward departure. I went out and I explained to her what the issue was yesterday, and she just she wants to go back on probation. Do you have is it something where I can pass her and you and I talk and there'll be a solid offer?
The solid offer is admit to the violation, revoke and terminate for 30 months, DOC, $100 cost of prosecution.
Judge, rather than that, I think what we need to do is go ahead and set it for a contested hearing. I'll talk with her some more. If she decides she wants to do that, we can have her do that or renegotiate or what have you. It's relatively simple. My only witness would be her, so I could do it as early as next week.
Well, I would assume the state would need some witnesses since it's their burden.
It should just be the
All right,
probation
I'm just computing the calculations based on the previous guidelines right now. She would score 29.85 months. the 6 for the violation. I'm just trying to make sure I understand where we're coming from.
And the offer is 30 months, but the state would accept guidelines.
29.85.
That's correct.
All right, so you want to set it for a VOP hearing?
Yes, sir.
Eventually?
Let's do that. I'll go out to the jail and talk to her. I'll go over that with her again, but in my conversations that I've had with her so far, I don't think that's likely to happen.
I signed the other day to get out today, 2 years probation with a suspended 36-month.
And
That's what you said was happening today.
Yes, that is what I thought was going to happen today, and then I went out and I saw you yesterday evening, before
You said
5.
the wrong person was given my case, and you had to see if the other person.
Right, and he's not agreeing. The quickest I can get your case resolved, hopefully, with, well, it's going to be whenever the judge says that we can set it. I've tried to get it set for next week.
Mr. Rouse, what's your opinion on that?
We would not be able to be ready by the 5th, but we would be ready by the 26th of February. But I know we're adding a lot of contested hearings to that docket.
Sign something.
All right, so, ma'am, your options are you can take the plea that they've offered, which is almost basically 30 months in prison. You can plead straight up, or you can set it for an evidentiary hearing, which we can do on February 26th. At that time, the state would have to prove that you violated your probation.
Ma'am, an evidentiary hearing is a trial, okay? It's not a jury trial, it's a judge trial. This is stuff that I went over with you. You would be able to explain to the judge why things happened, and the judge would have to decide if that was willful and substantial. We're not going to be able to resolve it today with you going outside saying what the court said.
February 26th, 2 o'clock, with subpoenas.
Yes, sir. Judge, I believe we're here from Mr. Hutto on another.
This is Mr. Kemp.
Or excuse me, Mr. Kemp on another Nelson hearing, although I think he's also scheduled for DOP. I had it as a call date, not as
Yes, it's without subpoenas.
basically, he had brought it up last time. He was going to redo it, and was going to file that on 27th.
Yep. Raise your right hand. Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. You filed a request in a Nelson hearing 2 days ago?
Yes, sir. I filed.
I think
one-
there was a previous one, right?
Yes, sir. It was, I tried filing in December. Yes, I also filed another motion in December to go with that, and it was to get the GPS coordinates off of the van.
So you filed a motion to compel,
Yes, sir.
But what your motion compels says that you're requesting the court to subpoena medical records for you. The court doesn't subpoena records for you. Your attorney can do that.
Well, I couldn't get them to do it.
Mr. Williams?
That's why I asked for the 60 days. I got a list of stuff.
Judge, if I can
Please
respond. I'm sorry, Judge.
No, it's fine. I just would like to know if that's what the issue is, why medical records, that doesn't even need to be a subpoena if he signs off on it.
Yes, sir. Judge, when I went out to talk with him before, or this last time, he mentioned that those issues, I have asked my investigator to look into them. One of the things that I think we're going to need to know, and I asked the investigator to go out and speak with him about it, was whose van is it? We don't even know if there's GPS coordinates for that van. In terms of medical records, on the medical, I mean, he told me about his medical issues. I had correspondence with the state about it and how all this came about. Basically, he'd been in a program, been injured, had to receive medical treatment, was, I think, in the hospital for a little while, and then brought back, and the program would no longer accept him. He was no longer medically fit. It was not a dual program. And so he was transported back to probation, kind of dropped off there. But in any event, I don't have the medical records. I haven't subpoenaed medical records, although I have, and normally we wouldn't. We would simply.
We're talking about his records, right?
Yes, sir.
So why is a subpoena needed? He
Well,
could just
that's-
ask for his record. He could sign a release.
Right, that's what I'm, actually, most of the hospitals don't even require that. I've asked to get it, we don't have it. We're still trying to get it.
Sir?
Go ahead, Mr.
Yeah,
Kemp. Sorry.
Being this guy, I'm trying to get a different lawyer. Me and him are not seeing eye to eye on this. We are, it's been 5 months. That was supposed to have been done back in October. But when we discussed it, he hadn't said one word about it. The stuff that he told you he was gonna do, he hadn't done it. The stuff he told me he was gonna do, he hadn't done. I'm just trying to get a different lawyer, sir, to speed this process up. If I could get those GPS coordinates, and I was told.
What GPS coordinates?
The van from the Phoenix house has GPS on it.
How do you know
The driver
that?
told me so, sir.
Okay.
He drove me from here, from the Phoenix house. He picked me up at the hospital, and he dropped me off at my neighbor's house. He dropped me off there. I didn't have enough time.
Let me just caution you.
Yes, sir.
You're talking about the facts of your case.
Yes. Yeah.
And everything in this, you're under oath.
Yes,
and
sir.
everything in this room is recorded, and your prosecutor's sitting at that table right over there.
I'm A-okay with it.
Thank you. Go ahead.
Because the truth is the records are not gonna lie.
I'm not asking you any questions about the facts
The
of your
records
case.
will not lie, Your Honor, and I'm all for it. The driver told me that there is records on it. So if you could just get those records for me, I can show you where that guy lied. I got dropped off at my neighbor's house. He went and said he was job scared of what he told me. He said, I'm not losing my job. I said, whatever you want to do, sir. I said, I cannot physically walk. I had 20 staples from here to here and 5 in my ankle. I could not walk. So the probation officer gave me until Monday to check in. And the other one, because of what that dude said, had violated me there. When I tried to check in on Monday, they said, Mr. Kemp, we already violated you. I'm here trying to check in. All I need is the records to show that I'm not lying. It's not gonna, that dude the guy told me that they're there. The GPS is on the van, and that's why he had to go to the probation office. So that's all I'm asking for. I've tried to check in.
Judge, again, I emailed Ms. Leone about these issues back in October. I simply have not yet obtained the records. I have talked to Mr. Anderson about trying to get the records. At the time that I talked with Mr. Anderson, and I did so recently because I could not find documentation of it when I was going through the file after speaking with Mr. Kemp in preparation for this next VOP date.
Sure.
I have asked him to. Now, I was thinking he was going to need to get with Mr. Kemp to find out who owned the van so they'd know who to get the records from. But I don't even know, just because he's got a GPS that he's using, I don't know that there's going to be records spent out on that. That's all something that Mr. Anderson's going to have to find out.
But why hasn't it been done up to this point?
Judge, I can't give you a good answer for it. I met with him about it back in October. We talked about it. I was focusing on trying to get the state to understand the medical situation, understanding what was actually going on. Wasn't really sure we were going to need GPS records anyway. I think we could get the same thing out of testimony of the van driver.
But what your client has just said is that he thinks the guy lied. So he's trying to get the evidence to show whether or not the guy lied. So if that comes out in the middle of a VOP hearing, it's kind of late.
Yes, sir.
All right, motion's granted. Mr. Kleins, come meet your new client. This is Mr. Scott Kleins from the Regional Office of Conflict Counsel. He's going to be appointed to your case.
Thank you, sir. What's your name? No, sir. Yes, sir. Thank you.
The gist of it, Mr. Kleins, is that he took a plea to go to Phoenix House. He was somehow injured while he was there, was determined to be no longer medically fit to be there. They sent him back, and the accusation is that he got out of the van and someone else picked him up, and he never reported to probation.
Does he score?
I think there was a downward departure on the previous.
That's correct. Right now, the offer is 42 months DOC.
But if we could, next, pretty much a month from today.
A month from today.
It's 4 weeks.
It's 2/26, correct, Your Honor? Yes. If we could put Mr. Kemp on for 2/26 without subpoenas, I just don't want to put this on for next Thursday and clog up the docket.
I understand.
No objection.
Able to get the record?
I'm going to come talk to you. I mean, I was quasi paying attention back there. So I know there's issues with the van driver and all that stuff. Let me put it, I don't even have the report or anything. I'll put it together. I'll come talk to you next week.
Thank you, sir.
All right, man?
Thank you.
Okay.
All right, 2/26, 9 o'clock, no subpoenas.
Judge, this is William Ray Lawrence, 24 CF 2858. Judge, we're trying to get him into a program, and my investigator's looking into that.
All right, so what would you like the
So
court
I'm
to
going
do?
to ask to pass it without subpoena.
You understand that, Mr. Lawrence? Have you talked to someone about a program? already?
Yes, sir.
All right.
The day after you come up there, Mr. Rex Project Hope will marry me. And I got your paperwork. Thank you.
Mr. Long.
All right, are you Jeffrey Long?
Yes, sir.
Okay, Jeffrey Long, 24 CF 1866. This is a violation of probation arraignment.
Judge, this is a negotiated plea.
All right. I think that's your hall plea.
Yes.
Thank you. Appears to be a downward departure.
Yes, Judge, that's correct.
All right, Mr. Long, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Jeffrey Loris Long, 12672.
All right, and Mr. Long, you're here in 24 CF 1866. It's a violation of probation. I've been handed it is a violation of probation, an underlying robbery by sudden snatching. I've been handed a plea agreement that calls for you to admit your violation of probation, 6 months county jail, credit for time served, $100 VOP fee, and $150 in public defender fees. Is that the agreement that you've made?
Yes, sir.
Is that the state's agreement?
Yes, Judge, that's correct.
Did you have enough time to go over this plea agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've read?
No, sir.
And you understand that by entering an admission to your violation of probation, there won't be a hearing where the state would have to prove you violated your probation?
Yes, sir.
And you understand you're waiving any potential defenses that you may have?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying that?
Admit.
Admit.
I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty, 6 months with credit for time served, and 6 months county jail with credit for time served, $100 VOP fee, $150 PD fee. I'm going to give you 90 days from your release to go ahead and pay those costs. Otherwise, you can set up a payment plan.
Okay.
Understand that, Mr. Long?
Yes, sir.
Revoke and terminate your underlying probation. Thank you. Looks like it was a underlying conviction, so I don't need your fingerprints, but you do have 30 days to appeal the judgment and sentence, Mr. Long. This is a downward departure based on a legitimate, uncoerced plea bargain. All right, thank you, Mr. Long.
Thank you.
No problem. Judge, this is William Michael Matthews, 22 CF 2717. He's got a new law violation he was arraigned on 12/4 for 25 CF 2248. I'd like to have this case cracked with that one. Just so the state's aware, part of the allegations against Mr. Matthews is a statement from the office that the mother made to the officer that he was not living there. She's since contacted our office, provided us with a written statement that that's incorrect, that she was not truthful with the officer. She is present in court if they want to talk with her. Otherwise, I'm having her set for a depot. My secretary's already in the process of that. I made a bond motion on him, largely because that will also get her in front of the court. Everybody will be able to ask her whatever questions.
Well, I mean, these are these concerns when someone says something, then comes in and testifies under oath the opposite, so
Yes, sir, but
I can only deal with what's in front of me.
So, Judge, if we can have this track, I think he's on for the 25th.
It is 2:25 at 9 o'clock. This will run with his new law violation.
All right, sir.
No, I think the Zoom turned off. Does it after like 40 minutes, I think. Fails there.
Judge, this will negotiate a plea.
Okay. there a score sheet? All right, Ms. Mead, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Donna Marie Mead, 8861.
All right, Ms. Mead, you're here in, is this a 2008 case?
Yes, sir.
Did you serve time up in Virginia then?
I served on the charge that violated this probation, yes, sir.
How long?
I had 2 years and I served 85%, which is the Virginia rule.
So old Judge Stonehandle didn't Crespi.
Yes, Judge, I don't have a score sheet because it's not in our system, so I'll
Okay.
have to go through and handwrite one.
All right. All right, Ms. Mead, I've been handed a plea agreement between you and the state that calls for you to admit your violation of probation. You'd be revoked and terminated off of your supervision, be time served, which looks like you've been in for about 3 months.
Almost 4, yes, sir. I was originally arrested in Virginia on
So
October.
you were there for a while before
Yes,
they
sir.
extradited
Yes,
you
sir.
here. Okay. I can only see from when she got here, so that's the 3. All right, so Ms. Mead, you also would have to pay a $100 cost of prosecution and $150 in PD fees. It'd be an adjudication, which you were underlined. Is that the agreement you've made with the state?
Yes, sir.
Is that the state's agreement? All right, and have you gone over this plea agreement with your lawyer?
Yes, sir.
Did you have enough time to do that?
Yes, sir.
And did you understand and sign the agreement?
Yes, sir.
You satisfied with your lawyer's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to do this?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've read to you?
No, sir.
And do you understand if you enter a plea of admitting your violation of probation, there won't be a hearing where the state would have to prove that you violated your probation?
Yes, sir, I do.
And do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying that?
Admitting.
I'm going to accept your admission as freely, voluntarily, knowingly given, revoke and terminate your probation, sentence you to time served, $100 cost of prosecution, $150 total PD fees. I'm going to give you 90 days from your release to go ahead and set up a payment plan for that or pay it directly to the clerk.
Okay.
You are adjudicated on the VOP. I don't need your fingerprints because looks like you were on the underline. And you have 30 days to appeal, Ms. Mead.
Yes, sir.
Thank you.
Thank you, sir.
Mr. Maddox, it looks like the jail's ready.
Yes, Your Honor.
Can we handle those, Mr. Williams? I think, Mr. Williams, you've got one who's Jeremy Nichols, but let's see who they've got.
I got Mr. Nichols.
All right, let's bring up Mr. Nichols really quickly. That's the only one that Mr. Williams had. Sorry to the jail. The Zoom timed out and I didn't realize it.
I'm having problem with the, can you see him?
I can't see anything. Here, let's see if that helps you. It doesn't look like your video is on. There it goes.
There.
Perfect, thank you, sir. All right, Mr. Williams, we're here on Mr. Nichols' case.
That's correct, Judge. Mr. Nichols, the state changed their mind and they're accepting the plea offer that we made last time. So you're going to be sentenced to that today, okay?
Yes, sir.
All right, but it is still a guideline sentence based on what it ultimately is?
It is, Judge.
Okay, Mr. Nichols, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth?
Jeremy Wayne Nichols, 8/20/87, sir.
All right, Mr. Nichols, you're here on a violation of probation in 19 CF 1274. Do you understand that?
Yes, sir.
All right, I've been handed a plea agreement that would call for you to admit your violation of probation and return and be an adjudication of guilt. You're to serve 60 months in the Department of Corrections with credit for time served. Revoke and terminate your probation, $100 VOP fees, and $150 PD fees, which I'll just send a judgment since you're doing a DOC sentence. Is that the agreement that you've made?
Yes, sir.
Did you read this agreement and sign it?
Yes, sir.
And do you need any more time to speak with your lawyer?
Yes, sir.
Okay, you're appearing by Zoom due to a jail quarantine. Do you need more time to speak with him about this before you enter a plea?
No, sir.
So I just wanted to add that part into it. All right, and are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this agreement?
No, sir.
Has anyone promised you anything other than the terms that I've read?
No, sir.
And do you understand that if you enter an admission to your violation of probation, there won't be a hearing where the state would have to prove that you violated your probation?
Yes, sir.
And do you understand that you're waiving all potential defenses?
Yes, sir.
And what is your plea? Are you admitting or denying your violation of probation?
Admitting.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given, adjudicate you guilty, sentence you to 60 months in the Department of Corrections with credit for time served, revoke and terminate your probation, $100 VOP fee, $150 PD fees. I'll send a judgment due to the fact that you're doing a DOC sentence. I have reviewed the guidelines. There's multiple changes to them as far as the level of offense and some of the things on your prior record and your VOP sanctions. But ultimately, it comes out to 58.875 months. So this is a 60-month sentence, so it is a guideline sentence. Do you understand all that, Mr. Nichols?
Yes, sir.
Okay. And I just need to inform you, you've got 30 days to appeal the judgment and sentence.
Yes, sir.
All right, thank you, Mr. Nichols. I'm assuming you're good? Okay, we don't need his fingerprints. All right, thank you, Mr. Nichols.
Thank you, sir. I'll bring in the next one.
I think the rest are Mr. Maddox. All right, your name, sir?
Mr. Brown, Your Honor.
Doesn't he take us up? No. Okay, my name's Anthony Scott Brown.
Okay. All right, Mr. Brown's here in 24 CF 1140.
Yes, Your
Mr.
Honor.
Maddox, go ahead.
Yes, Your Honor, we've reached a resolution in this case. Due to the circumstances, I personally went down to the jail, reviewed this plea agreement, reviewed his score sheet with Mr. Brown. I've reviewed it with Mr. Sprouse as well. We've all signed a plea agreement, Your Honor, if I may approach.
Yes, sir. All right, Mr. Brown, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Absolutely.
All right, you can put your hand down. Can you state your full name and date of birth, please?
My name is Anthony Scott Brown. My date of birth is 12/23/1985.
All right, and Mr. Brown, you're here, as I said, in 24 CF 1140 with a violation of probation. I've been handed a plea agreement between you and the state that would call for you to admit your violation, revoke and terminate your probation, credit for time served, $100 VOP fee, $150 cost of defense, and be an adjudication of guilt, and I'll give you 90 days to make payment of those fees. Otherwise, you can make a payment plan, and then it would go to collections if you don't pay that. Is that what you want to do today?
Yes, Your Honor.
Okay. It's called, he's got guidelines of 31.2 months.
This is a uncoerced, legitimate plea bargain, Judge.
All right, Mr. Brown, did you have enough time to go over this plea agreement with your lawyer, Mr. Maddox?
I did, Your Honor.
And are you satisfied with his advice in this case?
I am.
Did you understand the agreement?
Yes, sir.
And did you sign it?
I did, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your
Are
Honor.
you currently suffering from any mental health issues?
No, Your Honor.
And has anyone forced, pressure, or threatened you in any way to enter this plea?
Absolutely not, Your Honor.
Has anyone promised you anything other than the terms of the agreement I've already read?
Absolutely not, Your Honor.
And do you understand that if you enter an admission, there won't be a hearing where the state would have to prove how you violated your probation?
I do, Your Honor.
All right, you understand you're waiving all potential defenses.
I do, Your Honor.
And what is your plea to the violation? Are you admitting or denying that?
An admission.
I'm admitting.
Yeah, all right, I'm gonna accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, revoke and terminate your probation, credit for time served, $100 VOP fee, $150 cost of defense. I'll give you 90 days to pay those or set up that payment plan. Do we need his fingerprints?
He was previously, previously adjudicated, Your Honor.
All right, this is a downward departure based on uncoerced plea agreement with the state.
Yes, Your Honor.
Otherwise, it was 32 months prison. 31.2, excuse me. All right, thank you, Mr. Scott, or I'm sorry, Mr. Brown. Scott's his middle name.
Thank you. Thank you, Your Honor.
Thank you.
All right, good luck, man.
Yes, sir. Thank you.
You're welcome.
Thank you, Your Honor. Have a good day. Thank you.
Is that all you have there?
I was only notified. Are there any more?
I was given a total of 6 names.
Probably for the afternoon, Your Honor.
Oh, I'm sorry. Well, what about Ottman?
Ottman, yes, Your Honor. I personally spoke to Mr. Ottman while I was at the jail. We're going to put that on February 5th for likely resolution, Your Honor. State just needs to get in touch with the victim on that. My client has approved me to waive his appearance and set him for 2-5.
Okay. So Ottman will be February 5th, 9 o'clock. And then I think we'll have y'all back at the jail at 2 o'clock.
Yes, sir.
All right, thank you again. Sorry for the delay. If no one does anything on the Zoom for like 40 minutes, it just times itself out and it turned itself off, and I forgot you guys were supposed to be there. That's my fault. I apologize.
It's okay. Thank you, sir.
All right, have a good day. Medina? What's that? Oh, I see what you're saying.
Judge, this is Stephanie Medina. Case number is 4625 CF7 and 251026. We've got a negotiated plea agreement.
Thank you, sir. All right, Ms. Medina, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Stephanie Medina, or Lynn Medina, 011487.
All right, and Ms. Medina, you're here in 25 CF 7 and 25 CF 1026, all of which are violations of probation. Do you understand that?
Yes, sir.
I've been given a plea agreement that calls for you to enter an admission to your violation of probation. In return, the state has agreed that it would be a revoking term of your probation, 60 days in the county jail, credit for time served, $100 cost of prosecution in each case, $150 in PD fees, and I'd give you a period of 90 days from your release to go ahead and pay those or set up a payment plan.
Yes, sir.
Is that what you want to do here today?
Yes, sir.
I've looked at the guidelines. This is a guideline sentence, as you scored 29.2 points. Do you need any more time to speak with your lawyer about this?
I think I'm good.
Okay. Have you gone over the agreement with him and signed it?
Yes, sir.
Did you understand it all?
Yes, sir.
And are you satisfied with your lawyer's advice and representation in this case?
Yes, sir, I am.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
And are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've announced?
No, sir.
And do you understand that by entering admission to your violation of probation, then there won't be a hearing where the state would have to prove how you violated?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have? And what is your plea? Are you admitting or denying your violation?
I'm admitting.
Okay. I'm going to accept your admission as freely, voluntarily, knowingly given. Revoke and terminate your probation, sentence you to 60 days in the county jail, credit for time served, $100 cost of prosecution in each case, so that's 200 total, and a total of $150 in total PD fees. Adjudicated on the underlying. Looks like it, yes. So I'm going to give you 90 days after you're released to pay those costs or set up a payment plan. I don't need your fingerprints, but I do need to tell you you've got 30 days to appeal the judgment and sentence of the court.
Okay.
All right, thank you, Ms. McGee.
Thank you.
No problem.
I don't like how some of it's going over the top, some of it's not.
Judge, we've got a negotiated plea in this case.
Thank you, sir. So it's 6 months with credit for time served?
That's correct, Judge. Each case, each count concurrent.
All right, Mr. Mitchell, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes, sir. All right, can you state your full name and date of birth, please?
Christian Mitchell, March 20th, 1998.
All right, Mr. Mitchell, you're here in 24 CF 633, 23 CF 1050, and 23 CF 244, each of which are violations of probation. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that would have you admit that you violated, be 6 months in the county jail, adjudication of guilt, $100, that's with time served for each case. $100 VOP fee, $150 in PD, I'm sorry, $100 VOP fee, $150 in PD fees for each case. Everything will run concurrent. And this is a guideline sentence. Is that what you want to do here today? Do you need any more time to speak with your lawyer? Did you go over the form with him and sign it?
We haven't had a chance to talk yet yesterday.
Well, this is the original offer that you signed way back when. Did I go over that one with you?
Back in 24?
No, back on 11/26.
All right, Mr. Mitchell, we'll send you back. You can talk to him and go over the form with him just to make sure that you have adequate understanding of what you're doing here today.
I would still want to sign it if that's okay.
You just told me that you didn't go over the form with him. That's a requirement, so you're going to have to do that and come back.
I'll take a
Thank you,
couple
sir.
of minutes with him, Judge.
We can
make sure
handle it
remember.
today. It's just a matter of, I can't have you doing it up here at the lectern while we're trying to move other people's cases for them as well. It's nothing against you, Mr. Mitchell. I just want to make sure that gets done.
Yeah.
Afternoon, sir. Your name?
Mobley.
Mobley.
what I can do is, okay, it's not at all along the lines of what you were, or it's not along the lines of what you were looking for. Let me go talk with you back there, pass you, and I'll talk with you back there and bring you back out.
We'll see you back later today.
Judge, this is Zaki Moore. It's a VOP arraignment. He has a new law violation set for arraignment on 2/26. I'd like to have it track with those, or with that.
That's the arraignment date.
On the new law violation, I have 2/26/26 for arraignment.
There it is, yes. Are you entering a denial in the VOP?
That's correct, Judge.
Denial will be entered. We'll put it on 2/26 at 1:30 to run along with his new law violation.
All right, thank you, Judge. Okay.
Mr. Williams, do you want the Mitchell, that way you can talk to him about it? Looks like it was signed on January 7th. Is this Mr. Klein's case?
Your Honor, this is Mr. Fell. I've just handed him a modified, or I should say, new version of the motion. I'm going to consult with him early next week. I've already informed Ms. Leone that I expect to have this motion filed before next Thursday. I would like to leave Mr. Fell on for next Thursday just as a status. I know we've already talked as a party, as the court has talked with the parties. This is a situation where Mr. Fell has agreed that the court can rule strictly on the paper motions. It's a pure issue of law. So I want to go ahead and get the motion filed early next week, and then just leave him on for status for next Thursday, and then the ball will be in the state's court to respond, certainly.
Yes, I discussed that, yes, sir.
All right, Mr. Fell, we'll see you back next week just as status to make sure everything's getting filed.
I'll see you Monday or Tuesday. Okay, all right.
Ford.
Your Honor, this is Mr. Kelvin Ford. He's on today for an arraignment in 24 CF 766 and 24 CF 765. We will enter denial for Mr. Ford today. He does have a new law violation, 25 CF 2124. That is already on the 225 docket, so if we could just put these VOPs to tag along with that case and just leave that on all of them on the 225 docket.
Denial's been entered February 25th at 9 o'clock for pretrial conference.
All right, thank you. All right, man. Okay, Your Honor, I do have individual on the pretrial detention docket, Mr. Brake. I did talk with Ms. Glisson yesterday. I met with Mr. Brake yesterday morning for about 10 minutes, maybe. I was kind of up against it. I had 10 o'clock depositions at the state attorney's office. I did inform him that I was going to be asking the court to continue this to next Thursday for the detention hearing, based on the fact I had just been appointed, given the seriousness of the charge.
We were there last week, and that's when there was the discovery of the issue to appoint.
Correct, and I was reviewing, I'm going to call it benchmark. I don't know what it's called now, but I was reviewing the clerk's website, and I saw the order to appointing our office was signed.
You don't know the official name, or what maybe y'all just call it?
I typically try to be kind of flippant about it and call it like Bench Quest Smart Bench, like what, the clerk's website. In any event, Mr. Brake has no objection to me asking to continue this case. I don't know if he's been transported yet. I don't necessarily need him to be transported.
But does Ms. Glisson from the state know that?
Yes.
I'm covering for Ms. Glisson, she's aware and she's okay with that.
Okay, because I know there was quite a few people for the hearing last week. I want to make sure that everyone knows that if it's not going to happen, that not everyone's showing up for it, well, in 17 minutes.
Prior to me even meeting with him, I was waiting for him to come up, and I emailed Ms. Glisson and said, look, I'm going to have to ask to continue this. She asked me to confirm that late yesterday afternoon, so I'm assuming she was calling all of her witnesses. So.
Sounds like we might actually be able to eat lunch today. Probably not.
Yeah.
Ms. Rivers hasn't stood up yet, so that's fine. No, we're not.
No, I don't need to see him. I met him yesterday. He knows that, yes, he's aware that it's being pushed. And then the last one I have on the docket this morning is Ms. Sterner, Your Honor. Did the court receive the competency
I did,
evaluation?
and I reviewed it.
Okay. Your Honor, this is Ms. Sterner. She is present and approaching the podium. I did meet with her yesterday and explained the findings from Dr. McDonald. As the defense lawyer, I will stipulate that the court can make its competency determination based on the contents of that report.
Yes, sir.
And the state stipulates as well, Judge.
It's 10 days of personal.
And we have reviewed the report.
COVID vaccination.
All right, and I've reviewed Dr. McDonald's report yesterday. Found it to be
Get some metal plates in my
evidence.
face, sir.
Ms.
I
Sterner,
am
if I could
priority for
finish.
COVID vaccination and STD vaccination. I can't be in a closed-in confinement area for too long. That's why my email.
Based on my reading report and the stipulation by the parties that I can make the competency determination based solely on the report, I will find that Ms. Sterner is not competent to proceed. Also, it opined that she would be needed for involuntary with the Florida State Hospital.
And we'll provide an order to the
I have
court.
an address at 5476 I can be released to. We'll go to the health department and get my vaccination.
All right, thank you. If you could send me that order.
Yes, sir. That is all I have on the docket today.
I don't do medicine.
Do you have anything later this afternoon?
I do not.
Someone's speaking for my mom. And my mom. But my bond was paid.
All right, thank you.
Thank you.
Yes, I'm sorry. On the break case, it'll be February 5th at 12:30?
Yes, sir.
The next
Yeah,
time
and
I
I-
call attention.
And I do fully expect her to be here next week.
Okay.
Can we approach, Judge?
Sure. Who do we have, Ms. Rivers?
Sylvia Finney.
Let me try to find you. There it is. Oh, look at that. Flip right to it.
Your Honor, Ms. Finney's going to need to sign the agreement.
Crossover print.
Kirsten. It just depends on when they process you out. Okay. 126. We reached agreement.
Thank you, Ms. Rivers.
I was going to ask you questions.
Ms. Finney, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Sylvia Marie Finney, July 20th, 1999.
All right, and Ms. Finney, you're here in 25 CF 1166 on a violation of probation. Do you understand that?
Yes, sir.
All right. I've been handed a plea agreement between you and the state that calls for you to enter an admission to your violation of probation. And in return, your probation will be modified to 2 years of community control, followed by 1 year of probation. Complete all previous terms of probation that you were previously ordered to do, $100 cost of prosecution, $100 PD fee, and $50 application fee. Is that your agreement?
Yes, sir.
Is that the state's agreement?
Yes.
All right. And Ms. Finney, did you go over this agreement with your lawyer?
Sir?
Did you go over this with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Do you need more time to do that? Okay. Are you satisfied with your lawyer's advice and representation?
Yes, sir.
And is that your signature here on the report, on the agreement?
Yes, sir.
All right. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
And has anyone offered you anything or promised you anything other than the terms I've previously read?
No, sir.
And do you understand that if you enter an admission to your violation, there won't be a hearing where the state would have to prove that you violated your probation?
Yes, sir, I understand.
And do you understand you're waiving all potential defenses that you may have?
Yes, sir.
And this looks like the downward departure where she scored 28.95 months. State's agreement to do an uncoerced plea or bargain departure?
Yes, Judge, it was a modification.
Oh,
It's
it is modification.
not necessarily a modification.
All right, Ms. Finney, what is your plea to the violation of probation? Are you admitting or denying it?
Admit.
All right, I'm gonna accept your admission is freely, voluntarily, knowingly given, adjudicate you guilty, modify your probation in 2 years community control, followed by a year of probation, complete all previous terms of your probation, $100 cost of prosecution, $100 PD fee, $50 application. I do need you to speak with probation before you leave. Was she
Yes.
adjudicated? So I don't need your fingerprints, but you do have 30 days to appeal. Just to say I got it wrong.
Okay.
Your Honor, I have her terminated in 2027, so are we extending her probation as well?
Yes.
Over there now. Oh, okay, that's fine. Your Honor, this is Ashley Roberts before the court, 24 CF 2909, 25 CF 1923 for a Nelson hearing.
All right. You raise your right hand, Ms. Roberts. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
I previously read your motion or letter yesterday. Pretty sure I read it before that too, but I read it again yesterday. Tell me what your concerns are with Ms. Rivers' representation in your case.
I want to, I guess, retract that, because I don't have any concerns with that at this time any further.
Okay.
However, I did want to express with you, I went to Pensacola the other day, and they told me that I'm measuring further along than what the jail has on file. So I just wanted to share that with you.
All right.
Yeah.
What are we going to do otherwise today, Ms. Rivers?
Your Honor, the only thing it was only set for today because of the Nelson hearing.
The Nelson request has been withdrawn. What is she otherwise set for? Pretrial conference on February 25th, it looks like.
And they're thinking that I'm probably going to deliver before that. So I was hoping that something could.
So I'll talk about resolving the case. I don't have a bond motion set. I mean, this is a violation of probation, right?
Yes, sir.
We've already had a bond motion, Your Honor.
Yeah.
So, Your Honor, it is set for 2/25. If we're able to reach a resolution before then, we will set it before then.
I would love that.
Any day that y'all figure it out.
Yeah.
But there's new law violation, right?
There's what?
She has the VOP and new law. Yes, sir.
So 2024 is the
VOP.
VOP, which is a possession charge, and then 25 CF 1923 is also a new possession charge.
Yes, Your Honor.
I understand your concerns. I
Yeah.
think you probably understand mine.
I do, and I've been patient and nesting and doing what I can. I've even been trying to, because we just came off lockdown, so I've been trying to do courses on my tablet to kind of help towards the issue. Yeah.
Thank you.
Okay.
So, yeah.
Your Honor, this is Desmond Porter before the court on 25 CF 137. I have obtained your score sheet and calculated your information. Your Honor, based on the information that I have just received, we are going to request for the court to reset this on 2/26 with no subpoenas. If at that time we haven't reached a resolution, we will go ahead and set it. Months, DOC. There's the score sheet. This is the amount of days you've done. It's yours.
At 9 o'clock without subpoenas.
That's correct, Your Honor.
Just for, I would ask that this be the last continuance because this was continued before, prior to today already.
Yeah, and she said if it wasn't resolved that day, it would be set for a hearing.
I understand.
So I'll note that as well. Thank you, Ms. Leone.
Your Honor, this is Pablo Portugal before the court on 21 CF 748, 21 CF 749, 21 CF 750, 23 CF 456. He just needs an opportunity to sign the plea agreement.
Thank you. So downward from 75 to 60.
And Your Honor, I do want to address the score sheet issue afterwards, because
I'd rather do it now, just so I know. Or
So, Your Honor, I would like the court, if the court could make a ruling on, I think it's maybe section 6 of the score sheet. If the court is in agreement of that is how you do the scoring or not.
I don't know.
'Cause-
In that section, he's listed as having 30 points. That's
Right, Your Honor.
6
and it-
points per violation times 3, and then a new law conviction of 12.
But it says or. The wording on the wording on that says or. And I know the state, I've spoken with the state before, this is something that they do. Even though it says or, they do and. And if I could just get a ruling from the court on that.
Normally, it's 6 points if it's not a new felony.
Correct.
12 points if it is.
So if somebody violated, I don't mean to interrupt,
Go
Judge.
ahead.
If he previously violated, then that would be 6 points for a tech. And then
So
if,
violates on a technical, 6 points. Violates again on a technical, 6 points. Violates the third time is on a new felony, so it's 12.
12.
So it is the court's position then that despite the wording that's written on the document of that it says or, that you can do either or, that it's actually and.
I think per different violation. So if he's had 2 prior violations that were technical, and the third one is based on a new law violation, that's a felony, even if it's also technical,
Okay.
you don't get 6 and 12, you get 6 or 12.
Okay,
But
And
the
that's,
prior ones still count for the 6.
and that's just the clarification that I wanted.
That's
Thank
my
you.
understanding of it, but if someone finds something that's different, I'll certainly take a look at it, but that's the way I've always perceived it to be.
Okay, thank you.
All right. So should it be 3 6-point violations in the past, and this is now a 12-point because there was a,
All the points are there.
I understand, but what number violation is this?
Number
I just want to make sure it's not there's not a
3?
6 and a 12 for the same thing.
I think this is the
Third,
from my review.
third.
So he should have 2 6s and a 12? All right, so he's got 3 6s and a 12 on here.
The state would mark out 6 of those points.
All right, so I'm gonna mark it down to 2 6-point violations, so that makes it a 24 points for section 6, which brings us to 122.60 total points. I'm gonna get a calculator up here. 122.6 minus 28. So it's a total of 70.95. Therefore, still a downward departure.
Yes, Your Honor.
All right, Mr. Portugal, can you raise your right hand? It's just what you score versus what they've agreed your sentence is
Yes, sir.
going
Thank
to
you.
be. But everyone still wants to make sure the guidelines are right, even when they're departing. All right. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, and Mr. Portugal, can you state your full name and date of birth?
Pablo Isaiah Ventura, Portugal, 10/16/2000.
All right, Mr. Portugal, you're here in 21 CF 750, 748, 749, and 450, and 2023 CF 456. There's a violation of probation on each of those cases. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that would have you admit your violation of probation. You'd be sentenced to 60 months in the Department of Corrections with credit for all time served. Just understand you may have different amounts of credit into each case. I mean, the ones that are consecutive case numbers, I would guess you're probably the same. But this 2023 case, you may have less credit than the others. Do you understand that? All right. And I think as the agreement says, you're not relying on anyone has told you how much credit. Is that accurate? Okay. All right, so it'll be 60 months DOC with credit for time served, $100 cost of prosecution, $100 PD fee, $50 application fee, revoke and terminate all of your probation, and then any outstanding financials would go to judgment. Is that what you want to do here today?
Yes, Your Honor.
Is that the state's agreement?
That is the agreement.
Okay. All right, Mr. Portugal, did you go over this agreement with your lawyer?
Sorry?
Did you go over this with your lawyer?
yes, sir. Yes,
The
sir.
paperwork, did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice?
Yes, sir.
The sentencing judge, transitional judge. So, maybe someone hasn't told me something. All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the sentence that I've previously announced? And do you understand that if you entered admission to your violation of probation, there won't be a hearing where the state would have to prove that you violated your probation?
Yes, sir, that's fine.
And do you understand you're waiving any potential defenses that you may have? And what is your plea to the violation? Are you admitting or denying that?
Admitting.
I'm going to accept your admission as freely, voluntarily, knowingly given. Sentence you to 60 months in the Department of Corrections. That's concurrent between all counts, all cases. Time served, again, based on how much time you have served in each case. $100 cost of prosecution, $100 PD fee, $50 application fee. Revoke and terminate all of your probations or supervisions. And or outstanding monetary will go to collections. It'll be adjudication of guilt. I don't believe I need your fingerprints on any of them. I do need your fingerprints before you leave, then you have 30 days to appeal. This is a downward departure. With the modified score sheet based on what we've talked about, it was a 70.95 months, lowest permissible. This was 60 months, and based on that, it was an uncoerced plea bargain. Is
Yes,
that
sir.
right? Okay. All right, thank you, Mr. Portugal.
Thank you.
Just need your fingerprints and then your.
Your Honor, we've reached an agreement in this matter. I just need Mr. Russell to sign it.
All right, thank you.
Flowers, I thought you had signed it. You didn't, so I'll bring that over to you to sign.
Yep.
Yep, we're good.
Gotcha. So it's a modification.
Yes, Your Honor.
All right, Mr. Russell, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Jonathan Blake Russell, 03/24/98.
All right, and Mr. Russell, you're here in 24 CF 893, 914, 25 CF 34, and 1013, all violations of probation. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that would have you go admit your violation of probation. In return, it'd be a modification to reinstate you with the next 6 months on community control, weekly drug tests during that time, so just during the 6 months of CC. Is that the way I'm reading that? Yes?
That's correct, Your Honor.
Okay. Complete original requirements, $100 cost of prosecution, $100 PD fee, $50 application fee, and continue to waive cost of supervision. Is that what you want to do today, Mr. Russell?
Yes, sir.
Have you gone over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And are you satisfied with your lawyer's advice and representation?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've announced?
No, sir.
Do you understand if you enter a plea, there won't be a hearing where the state would have to prove that you violated your probation?
Yes, sir.
And you understand that you're waiving all potential defenses?
Yes, sir.
And what is your plea to the violation of probation in the cases I've announced?
Admit.
I'm going to accept your admission as freely, voluntarily, knowingly given, modify and reinstate your probation. It's going to be modified to the next 6 months will be on community control, weekly drug test during that time, complete your original requirements, $100 cost of prosecution, $100 PD fee, and $50 application fee, and I'll continue to waive your cost of supervision. It's an adjudication of guilt. Had he previously been fingerprinted? Yes? Okay. All right, so I need you to go back and talk to probation who's sitting there behind you. Then you have 30 days to appeal, Mr. Russell.
Your Honor, this is John Saber before the court on 25 CF 1769 on our motion to reduce bond. Mr. Saber, and I am not sure of that first part that I put in there. Mr. Saber is before the court on a charge of burglary of an occupied dwelling with a bond set at $10,000. Possession of burglary tools with bond set at $5,000. Possession of controlled substance bond set at $2,500. Introduction of contraband, the bond is set at $2,500. Resisting an officer without violence, bond is set at $1,000. And illegal use of personal identification, bond is set at $500. Petty theft, bond is set at $500, totaling $22,000. Mr. Saber is his bond, he's unable to post these bonds, and he is asking the court to consider reducing those bonds. He is a lifelong resident of the area. He has mother, sister, nieces, girlfriend that all live in the area, and he is asking the court to modify the bonds in counts 1, 2, and 3, and 4 to signature bonds or significantly reduce those bonds.
State's position.
No, burglary of occupied dwelling.
The state's concern is protecting the community. So with the litany of charges and the resisting arrest, I think Mr. Saber is where he's supposed to be. I don't believe that the bond is unreasonable. Just because somebody's unable to pay the bond does not mean it's unreasonable. That's one of the factors that this court considers. But we object to a modification. We believe that the bond is correct. Thank you.
Looking at his first appearance paperwork when these were set,
Yes, Your Honor.
it indicates that there's 4 prior failures to appear, either 20 or 21 prior misdemeanors and 9 felonies.
Yes, Your Honor.
And I believe he was out on bond when he picked up these charges.
I believe he was, but that case has been dismissed, correct?
Well, the case was resolved.
He pled.
He pled. Oh, he pled to that one, because we
Yes,
were
sir.
set for trial, that's all I remember, and then
Yes.
it resolved itself.
That's
It
correct.
pled, but that doesn't change the fact that he had orders by this court and he violated
Yeah.
them.
No, the judge knows that.
So he was on bond for the case that he's now pled to when this arrest was made.
Correct, Your Honor.
Based on the indication of failures to appear, also the fact that he was actively resisting, and according to the arrest report and the prior record, I feel the bonds are appropriate. Commission's denied.
Thank you, Your Honor. Weeks.
Have you got my paperwork? I sent you.
Mhm.
Okay.
Your Honor, during this morning's court, I was able to work out an agreement with Ms. Flowers. I need to go over it with Mr. Selman. If maybe we could put him on for a little bit later this afternoon. That way I can go over it with him. Goodness. Your Honor, this is Mr. Sheets, if you give me a moment. I have his motion here. Does the court have his motion, Your Honor?
I do.
Okay.
I
Your
think
Honor-
he filed one that was one page by himself, and then you filed one separately.
Yes, Your Honor. So he is before the court, asking the court to reduce his bonds. He is unable to post these bonds. How long have you lived in the area?
My whole life.
He's a lifelong resident of the area, Your Honor. He has children. He has, your mother lives in the area, correct?
Yes, ma'am.
He has, his mother lives in the area. He has a significant other. And he would be able to, if the court were to reduce his bonds, he'd possibly be able to post them, get out, go back to work, and pay support for his family.
State's position.
State's position that this is, he's already had a bond hearing. This was set for a pretrial detention hearing, so I believe his bond was set by Your Honor. So I think you got it right the first time. What he's charged with is sale, manufacture, deliver fentanyl within 1,000 feet of a place of worship, education. That's a first-degree felony. So I believe this is very serious sale, manufacture of fentanyl.
I don't think there was a pretrial detention hearing.
It wasn't a pretrial detention hearing. What my colleague relayed to me is that it was a bond hearing in lieu thereof.
Mr. Sheets?
Well, we'll see.
What I can tell, you went to first appearance and was given the $10,000, $1,500, and $3,000 cash or professional bonds.
Yes, Your Honor.
He then posted those and was arrested within the next week. For 25 CT 2209, which was an operating a motor vehicle without an endorsement, or I'm sorry, motorcycle without an endorsement. He was given a $1,000 bond on that case, but the first appearance judge revoked his bond for this case. So the issue is, am I reinstating his bond when he picked up a new charge while on bond?
And I apologize for that, Your Honor. Yes, so we would be asking the court to either reinstate the bonds or impose new bonds.
And the state objects to that.
He's already pled to that case. I'm looking at his first appearance paperwork from this case initially, that indicated he's got a prior failure to appear, 16 misdemeanors, and 20 prior felonies.
Anything like that.
And Judge, I would point out the obstruction to the search warrant done on his residence.
Your Honor, he says he only has 2 prior felonies.
Which is why I bring it up. Because, as you know, at first appearance, NCICs are handed to the judge, and then they all get shredded because they can't be disseminated, and then I don't have them at bond hearings, nor access to it. In 2017 CF 2808, which was possession of a weapon or firearm by a convicted felon. 2013 CF 475 was a withhold, on sale, manufacture, or deliver. 2012 was a grand theft. Don't seem to have.
Forgive me, Judge, but I have on my system, the grand theft was $300 or more, but less than 5. And then 11 misdemeanors on top of those 3 felonies, those prior felonies.
Yes.
Based on the circumstances, I understand it's a new law violation. He's already pled to it as a motorcycle endorsement case. I'm going to issue him new bonds, but they're on count 1, it's going to be $25,000 cash or professional. On the possession, count 2, I'll put it back to the $1,500. The paraphernalia would also be an ROR as previously. And on the obstruction of the search warrant, $5,000 cash or professional. So that's $31,500 cash or professional total. Part of your conditions of any bond, do not use or possess any controlled substances or firearms. Pretrial services, report to them once per week by phone.
Okay. Thank you, Your Honor.
Thank you.
Pretrial conference will be switched if he, well, I'll keep it at 2:25 at 9 o'clock unless he makes bond, that it can be put on the 23rd. And part of that's based on the seemingly incorrect information from first appearances, as well as a minor traffic issue is the reason for his revocation.
Your Honor, this is David Smith before the court on 21 CF 590. I went out to see him, to show him a video of a court smart. The videos that I had were of a different one than he wanted. I went back to the office to check to see if we had that one. We did not, so we've requested it. We're going to ask the court to put this on 226 with the understanding that if it doesn't resolve on 226, that it will go to a contested hearing.
State.
Same position as the prior defendant, Your Honor. It's been continued before, so we can set it next time.
All right, 2/26 at 9 o'clock, last continuance for, and then, I mean, I'll certainly entertain it depending on what happens, but I'm not quite sure what the court smart issue is, but.
Your Honor, this is John Smith before the court on 24 CF 258 on violation of probation. We've been trying to see if we could work out a negotiated plea. At this point, we're going to ask to put it on for 2/26, Your Honor.
Same response date.
No, different state. This would be Ms. Flowers.
It'd be no objection from the state judge.
All right, 2/26, 9 o'clock. That's subpoenas.
Yes, Your Honor. All right. Your Honor, this is Timothy Thacker before the court on 25 CF 2263, 25 CF 2279, 25 CF 2338. We're on our motion to reduce the bonds. Okay.
Sorry, Your Honor, this is.
He also has an arraignment case for this afternoon.
Timothy Tucker?
Yes.
Thacker.
Thank you.
I wasn't aware that there was a bond hearing today on this case.
A motion to reinstate bond was filed on the 20th. Notice of hearing was also done on the 20th. That's just on the. That's only on 3 of the 4. Does he have a bond on the 4th one?
Yes, Your Honor.
Okay. All right, go ahead with your motion.
I apologize. I understand. It's not my case, Your Honor. I'm covering for Ms. Bosso. I was aware that she has the 25 CF 2444, and is defense indicating that the motion pertains to the other 3 cases?
Correct.
Yes.
Okay, that.
Your Honor, he's here for arraignment on 25 CF 2444. We're in a not guilty plea, request trial by jury. That's on the 130 docket. But as for the 25 CF 2263, 25 CF 2279, 25 CF 2338, he had a bond on 2263 in the amount of $3,000, but it was revoked at first appearance. On 25 CF 2279, he had a bond of $2,000. It was revoked at first appearance. On 25 CF 2338, he had a bond of $2,000 that was revoked at first appearance. He currently has no bonds on these cases. He believes in discussions with Blocker Bell Bonds that they will go back on his bonds or that they have not gone off his bonds. He is asking the court to reinstate his bonds or to impose new bonds of a similar monetary amount. He maintains that he needs to get out to be able to help his mother with her bills and take her to appointments, and that he also has a, what did you call it, to where the trucks were?
I have 2 vehicles. Well, one of them is at Precision Auto Tune, and then the other one is the lending agency. They're about to repo the truck by the end of this month.
So he is, trying to get out to be able to save his vehicles as well. And where are you employed?
It's Wayne Ansley.
Your Honor, he is able to secure employment with Wayne Ansley at Ansley Rentals.
if I'm wrong, he's currently charged with violation of his sex offender status
Yes, Your Honor.
Got three
because of a
counts.
prior lewd and lascivious battery charge
Yes,
that he
Your
was
Honor.
convicted of.
Yes, Your Honor.
How is he not a violent felony offender of special concern? Who's committed, who's, oh, he's not a VOP. That's all.
Right. Yes, Your Honor, he's not a VOP, he's got 4 open cases, and the failure to register has 3 counts. I quickly calculated the score sheet based on all the cases that he has pending, and he scores a minimum of 89.78 months guidelines.
Based on his status, as well as the fact that this is he also has another new law offense while he was on release for his other 3 cases. Also, his prior history included a lewd lascivious battery, and I believe there was a felony battery as well in 17 CF 375. A felony battery in 16 CF 1909. I'm going to find that he's a danger to the community. Therefore, I'm not going to reinstate his bonds that were previously revoked.
Thank you, Your Honor.
Thank you.
Your Honor, this is Derek Toller before the court on 25 CF 1800. We're going to enter a denial at this time.
Say again, I'm sorry.
This is Derek Toller before the court on 25 CF 1800. We're going to enter a denial at this time. We ask to be put on the 226 docket.
With or without subpoena?
Without subpoenas, Your Honor. No, the appeal's separate.
Can y'all approach quickly on that?
Yes, Your Honor.
And if you don't have an attorney representing you, I'll go ahead and talk to you about if you want one appointed and filling out the paperwork for that. All right, let's start with Donald Adams. Mr. Maddox, I think Mr. Adams is yours.
Yes, Your Honor. Sorry about that.
No, it's fine. All right, Mr. Adams, you're here in 25 CF 2465, charged with drive one license suspended habitual.
Yes, Your Honor. Did they have an offer? That's okay. One to a plea of not guilty today, Your Honor, and ask for trial by jury.
February 23rd at 1 o'clock will be your pretrial conference date. Stay in touch with Mr. Maddox.
23rd.
The 23rd of February,
Yes, sir.
Mr. Russell?
Judge, I didn't know if you want to call him next or not.
I guess if it's going to be relatively quick, I think it's just status as to did everything go right.
Yes, sir. So I checked with.
This is Herbert Adkins, 07 CF 622, 25 CF 2471.
Correct. I checked with Ms. Gagliano with Bridgeway yesterday. She said that everything went fine. He got down there. She gave me a contact number for Phoenix Housing down there. I called them, spoke to them. They confirmed he was down there. Everything's going according to plan. He's situated. And I filed waivers for his appearance today because I didn't want to get him down there and then have to transport him back.
I think this is just status anyway.
Right. And I didn't know if the state had made a decision about his new case because it's actually set for arraignment, the 25 case. 25 CF 2471.
1 second. What's the name?
Herbert Atkins.
Fair?
Oh, can we approach?
All right, Atkins, we're gonna put on, no information's been filed, putting on 226 at 1:30 for status.
And that'll be both cases, right, Judge?
Both cases, yes, sir.
Thank you, Judge.
Thank you. All right, Daryl Brooks. Mr. Brooks is approaching. Mr. Brooks, you're here in 26 CF 16.
Yes, Your
Charged
Honor.
with possession of a controlled substance.
Correct. Information's been filed, Your Honor. Winter plea of not guilty at this time, asked for trial by jury.
Put it on, are y'all gonna want February 23rd?
For cases like this, yes. One way or the other, we'll either have discovery.
I'm gonna default to February 23rd or 25th, based on if they're in custody or not, but if you'd want longer,
Yes, Your
I'll
Honor.
certainly do that, especially depending on the type of case.
Thank you.
All right, 223 at 1 o'clock. Mr. Brooks is your next court date. Stay in touch with Mr. Maddox, and we'll see you back on that date.
Yes, sir. Thank you.
Thank you. Ryan Buckholz. Schultz.
Hey, sir. Your Honor, this is
25
Mr.
CF 2491. Go ahead, Mr. Maddox.
Yes, Your Honor. Winter not guilty plea at this time, and information has been filed. Demand trial by jury.
February 25th at 9 o'clock for purposes of pretrial conference.
Let me go ahead and ask for the April date in this one, Judge. It's a DUI with serious bodily injury. I think there's going to be a lot of investigation needed.
It's going to be April 29th at 9 o'clock.
All right, thank you, Your Honor.
All right, Kizzy Campbell. All right, 26 CF 32, possession of controlled substance, possession of paraphernalia, and trespassing.
Your Honor, our office previously represented her. We have withdrawn due to a discovered conflict.
I've got you listed. So, so you filed a motion to withdraw?
Yes, Your Honor. This was relatively recently.
The motion, I don't see an order. Oh, there's the order. I signed the order on the 26th. Well, actually, I filed it on the 23rd, but it looks like it was filed on the 26th.
For Ms. Campbell's benefit, I know she does have a standing offer to resolve her littering case. It was a lesser included offense. I don't remember the specifics of that. Obviously, I don't want her to do anything without being able to consult with an attorney, but that's just for her benefit, so she knows.
Information hasn't been filed. Information from the state.
That would be my case, Your Honor, and we're, not sure why, but I'll get it filed. I was intending on filing it.
All right, Ms. Campbell, what we're going to do is we're going to put you on for next week. Have them come back. They'll make their charging decision. I'll get your lawyer to be present because I had to appoint the Regional Office of Conflict Counsel to represent you. So Mr. Kleins will be here next week for you.
So I come to court next week?
Yes. February 5th, 1:30. Make sure a notice goes to Mr. Kleins about that. All right, Brandon Conway. I'll be followed by Patrick Curtis. This is 26 CF 15, possession of controlled substance.
Yes, Your Honor. Information has been filed, Your Honor. We'll enter a not guilty plea at this time. He does have another case, 26 CF 129. I believe we're appointed, but could you double check that? And if we're not, appoint us on that one as well. Okay.
You assume you're appointed on that. Arraignment is 226.
Your Honor?
The arraignment is set for 226 on that case, but
Okay.
you are appointed.
That's fine, Your Honor. I guess we'll just, if this case could just track that, that's fine.
I would put this on the pretrial on the 25th. And then we'll go from there. All right, February 25th, 9 o'clock for pretrial conference. Patrick Curtis,
Thank you, sir.
followed by Jonathan Day. If I tell you you're next, just come on up to the railing here and be ready to go once we finish
I'll
up
come
the
talk to you about
previous.
Thank you, sir. I'll look at it.
26 CF 22, charge of aggravated child abuse.
Yes, Your Honor. Information has been filed, Your Honor. Went to a plea of not guilty. I believe on this one, the pretrial conference is already set for April 27th, but certainly if it's not, that's what we'd ask for.
It'll be April 29th since he's in custody.
Thank you. Sorry about that, yes.
April 29th at 9 o'clock.
Thank you, Your Honor.
Jonathan Day.
All right, that's it, sir.
Day.
He pled previously, Your Honor. He was the gentleman we brought back on the 9th after January 8th, and we entered a global resolution on all cases.
Isaac Dumas. Followed by Jabari Fountain.
Hey, Mr. Dumas.
Dumas, 25 CF 2462, battery on a detained person.
Yes, Your Honor. Several open cases in the south end. I believe this will be going down there as well. Just want to confirm that with the state.
All right, is the state going to transfer this?
Yes, that should have, another thing that should have been done.
Okay. All right, so Mr. Dumas, what's going to happen is you're just going to get transferred. This case will get transferred to go with the rest of your cases in the south end. So I'm going to give you a control date just to make sure.
Yes, Your Honor.
I don't know what division, I guess that would go to Judge Clark. Is that where you're normally in front of Judge Clark? Okay. Information was filed. If you want to, I'll enter a plea of not guilty form.
Yes, Your Honor,
and
please.
Let's see what his other cases are set for. February 11th.
That's fine.
All right, we'll put it on February 11th in front of Judge Clark with the rest of his cases, but I'll need that transfer order.
Thank you, Your Honor. Hmm?
You gonna say something?
No, sir.
Oh, all right. Thank you.
Yeah.
All right, Jabari Fountain, followed by Joshua Fowler, although is Fowler the one we're doing later? Wasn't Fowler the case that there was a bond motion to?
Fowler, Joshua Fowler? No, Your Honor. Not that I'm aware of.
What was the one from this morning?
Ramsey.
Ramsey.
Oh.
That's not even close. All right. This is Mr. Fountain?
It is, Your Honor.
All right, this is 26 CF 28, battery by a detained person.
Correct, Your Honor. I believe has an information been filed? Okay. I believe this case is going to be transferred to the south end as well, Your Honor. He has a couple open cases down there.
And actually, I think this one actually is going to stay. I know there are some open cases with or CAC cases with Ms. Basso.
Okay.
But this one's going to remain in this division. That's what they wanted to do. But, and I'll get an information filed before next week.
All right, can everyone make sure their phones are silenced? We had a big issue with that this morning already.
Okay, well, guess I'll be handling it, so I'll look into it, sir.
All right, but information hasn't been filed yet?
No, I don't believe
I'll
so.
get that done for next week.
Let's put it on February 5th at 1:30. Have a charging decision by then. All right, Joshua Fowler.
Hey, Mr. Fowler, gave you a card already.
Yes, sir.
This is Mr. Fowler, Your Honor, before the court in 25 CF 2468. Information has been filed. Will enter not guilty plea at this time. Trial by jury.
February 23rd at 1 o'clock is your pretrial conference, Mr. Fowler. Make sure you come back on that date. Stay in touch with Mr. Maddox. Miranda Griswold, followed by Amy Harrell.
We're going to have a resolution in this case, Your Honor. Need to sign it, get the state signature. All Same terms we went over yesterday. Sorry about the delay, Your Honor. While Mr. Strauss is signing, I was speaking to my client. The question she had was about whether she could transfer to Alabama. My understanding is she cannot. It's a misdemeanor resolution in the case. I've informed her of that. Despite that information that she's received, she understands. She said she has a place she can stay in Florida, and so she's still going to take the agreed upon plea, Your Honor.
Couldn't she do JCS probation? Don't they do it if it's transferred? Can't they?
That's fine. If the court wants to do that, that's fine. If the court is okay with doing that, that's fine.
The issue is she wants to transfer to Alabama, but it's a misdemeanor.
Yeah, we're not able to do that.
I think that's why I can put her on JCS probation. I think they allow for that.
They haven't.
The state has no objection to that, and it would save her money too.
Then you're good. Yes, you're good. Okay, I'm going to put that in the plea agreement then, Your Honor.
Okay, but she's going to have to meet with them.
There's a QR code. I have one. I can get it. Okay, you got one too.
Okay, thank you. Thank you. Yes, thank you.
All right, perfect. May I approach, Your Honor?
All right, Ms. Griswold, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Miranda Lee Griswold, 8/22/83.
All right, Ms. Griswold, you're here in 25 CF 2164, charged with aggravated battery with a deadly weapon, which is a second-degree felony punishable by up to 15 years in state prison. Do you understand that? I've been handed a plea and sentencing agreement between you and the state that would have you plead no contest to a lesser-included misdemeanor battery, which is Florida Statute 784-03-1A. Be a withhold of adjudication, 11 months, 29 days probation, substance abuse evaluation, any recommended treatment, no violent contact with Philip Hart, no drugs or alcohol without a valid prescription. That would obviously be the controlled substance part of that. 622 court costs, $100 cost of defense, waive cost of supervision, and your supervision will be done by JCS, or Judicial Correction Services. Do I have
Judicial
that right?
Correctional Services, yes, Your Honor.
All right, so you've been given a paper with that on there. You're going to have to report to them upon your release. I'm guessing by the time you get back, you won't be released early enough to do that today. So first thing tomorrow morning, make sure you do that. They may not have paperwork for you, but you still have to report.
Yes, sir.
And it's not going to be easy probably tomorrow because they're the county court probation people for misdemeanors.
Yes, sir.
We're only doing that so you can still go back to Alabama. All right. So is that what you want to do here today?
Yes, sir.
Have you gone over this plea agreement with your lawyer?
I have.
And did you understand and sign it?
Yes, sir.
You need more time to speak with your lawyer about it? Say again?
We're good. Thank you.
We're good?
Yes, sir.
Yes, sir.
Okay.
Yes, sir.
All
Unless
right.
you-
And are you satisfied with your lawyer's representation and advice in this case?
Very much so, yes, sir.
Okay. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've read? And do you understand there won't be a trial of any kind, and you're waiving all of your trial rights, which are on page 2 of that agreement you signed?
Yes, sir.
And you understand you're waiving any potential defenses you may have?
Yes, sir.
You also understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the misdemeanor battery count?
Guilty.
No contest.
Oh, no contest?
No contest. Plea will be accepted as freely, voluntarily, knowingly given. I'm going to withhold adjudication. 11 months, 29 days of probation to be done by JCS. Substance abuse evaluation, any recommended treatment, no violent contact with Philip Hart, no drugs or alcohol, no controlled substances without a prescription, a valid prescription, 622 court costs, $100 cost of defense. I'll waive cost of supervision. I'll need your fingerprints because it is an enhanceable offense in the state of Florida, even with a withhold. And then you have 30 days to appeal the judgment and sentence. Make sure you meet with JCS tomorrow morning first thing.
Yes, sir.
All right, thank you, Your Honor.
Thank you.
You're welcome.
All right, Amy Harrell.
Ms. Harrell entered a plea on
Okay.
January 15th.
Okay. And then Becky Hicks, I think we're just rescheduling that one. Is that right, Mr. Williams?
Judge, Ms. Hicks, I think the state filed an all-pros on it yesterday.
Oh, okay. I got the email about the other issue with her needing a continuance, but, all right, so that was null prost.
Yes.
All right, Maurice Horn Jr.
That's going to be a plea, Judge. He's, all of mine are incarcerated.
Okay.
Thank you, sir. All right, are you Mr. Horn? All right, the microphone needs to pick you up, that's why I'm waiting.
Yes, sir.
All right, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Maurice Horn Jr., 08-25-92.
And Mr. Horn, you're here in 26 CF 27, where you're charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, as well as possession of paraphernalia, first-degree misdemeanor, punishable by up to a year in county jail. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would call for you to plead no contest
Sir.
as charged. It'd be an adjudication of guilt, so that's a felony conviction on the possession of a controlled substance. 18 months of probation with substance abuse evaluation, any recommended treatment. $615 costs, $150 PD fee. And you said there's another matter where he's going to 12 Oaks?
Yes, sir.
Where is that from?
Judge, can we approach on that? It's
Thanks. All right, so Mr. Horn, if you do the 12 Oaks inpatient, that would count towards your substance abuse evaluation and any treatment. If you successfully complete it, so you got to make sure you still do the whole thing. Let's see. I'd waive cost of supervision. I guess I'll point out it's 18 months probation on the possession of controlled substance, but only 11 months, 29 days on the misdemeanor.
Actually, just to make it easy, I'd suggest time served on the misdemeanor.
Oh, is that the agreement?
Ms. Flowers, you okay with time served on the misdemeanor?
All right, time served on the misdemeanor then. And I mean adjudication of guilt, so it's still a felony conviction. All right, is that what you want to do, Mr. Horn?
Yes, sir.
Have you gone over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I just announced? And you understand by entering a plea there won't be a trial of any kind? And you're giving up your trial rights, which start on page 1 and go on to page 2 of that agreement you've already signed. And do you understand you're waiving all potential defenses? And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to the possession of controlled substance and possession of paraphernalia? I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty on count 1, the felony. It's going to be 18 months probation with a substance abuse evaluation, any recommended treatment. That can be satisfied by successful completion of the 12 Oaks that you're otherwise required to do in a different case. $615 court costs, $150 PD fee, and a waived cost of supervision. Mr. Horn, I need you to talk to probation before you leave the room. You also need to be fingerprinted, and you have 30 days to appeal the judgment and sentence. This is a guideline sentence, as he scored 30.60 points. All right.
Thank you, Judge.
Thank you, Mr. Horn. Just talk to probation right behind you. All right, Michael Huertas, do we handle him today?
We did this morning, Judge. Entered a plea of not guilty, was set to 25.
Dominique Isaac?
He pronounces it Dominic, Judge. But he'll respond to Dominique.
Dominic is proper. All right. Mr. Isaac, how about that? Is here in 25 CF 2476, battery, misdemeanor, possession of controlled substance, third-degree felony, and possession of paraphernalia, first-degree misdemeanor.
Yes, Your Honor, I'll enter a plea of not guilty on his behalf and request trial by jury, 15 days, any pre-arraignment motions.
February 25th at 9 o'clock for pretrial conference.
Thank you, Judge.
You don't have an information.
Yes, Your Honor, there's 5 that I've noted that there aren't informations that I'm looking into, that there might just be some disconnect. They're in my system, but not in the clerk system, so we'll get those resolved today.
Let's pass him, I guess, until the 5th.
February 5th, 1:30 for purposes of a rearrangement.
All right. They're going to bring you back on the 5th, give the state time to finish, follow the actual formal charge. Okay. So I'll see you on the...
It won't really change much other than just one more court date.
Yeah, it's not going to change anything.
I'll ultimately still put it on 2/25. All right,
All
Michael
right.
Livingston. Followed by Robert McDonald.
Judge, Mr. Livingston's a new appointment. He wasn't even on my, my list. I'm going to enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions and trial by jury.
Make sure we have an information first. An information has been filed. It's stealing and stolen property by organized trafficking, first-degree felony, burglary of an unoccupied dwelling, second-degree felony, grand theft auto, third-degree felony.
I think he's got some other cases, and then this one, I guess, was added on.
2/25 at 9 o'clock for pretrial conference.
Thank you, Judge.
See you back on that day, Mr. Livingston.
Come on out, Mr. McDonald.
All right, Mr. McDonald, you're here in 25 CF 2441, charged with stealing stolen property and vehicle theft, and also in 25 CF 2442, another count of vehicle theft. Do you understand those charges?
Yes.
All right. I'm not sure why Mr. Williams is appointed, because I didn't appoint the public defender at first appearance, because number one, you refused, and two, you never wanted a public defender. So, do you want me to keep Mr. Williams on your case?
Yes, I need Mr. Williams.
Okay. I'll go ahead and appoint Mr. Williams to both cases.
Yes.
Okay.
Judge, I'll enter a plea of. Okay. For today's purposes, though. Judge, I'm going to enter a plea of not guilty on his behalf, 15 days pre-arraignment motions, trial by jury.
All right, February 25th at 9 o'clock for pretrial conference. We'll see you back then,
Yes,
Mr.
sir.
McDonald.
Doing all right?
Same as always, Mr. McDonald. How about you?
Mr. McDonald, I'm going to write your name on.
All right, Memory Medlin.
Judge, this is going to be a plea.
And after that plea is going to be Donald Millison.
Melody, come stand over here.
All right, Ms. Medlin, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your full name and date of birth, please?
Memory Lane Medlin, 07/16/1997.
Okay, Ms. Medlin, you're here in 2026 CF29, where you're charged with fleeing and attempting to elude a third-degree felony, punished by up to 5 years in state prison, and then possession of paraphernalia and resisting without violence, both of which are first-degree misdemeanors, punished by up to a year in county jail. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would have you plead no contest as charged. In return, the state's agreed that your sentence would be an adjudication of guilt, so that's a felony conviction. Time served, 515 court costs, and a $150 PD fee. Is that what your understanding of the agreement?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Is that the state's agreement?
Yes, Judge.
Yes. All right, and have you gone over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Do you need more time to speak with your lawyer?
No, sir.
Are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Anyone force, pressure, or threaten you in any way to do this?
No, sir.
Anyone promise you anything other than the terms of the agreement I just announced?
No, sir.
And do you understand that by entering a plea, there won't be a trial of any kind?
Yes, sir.
And you're giving up your trial rights, which are on page 1, going on to page 2 of that agreement that you've already signed?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, you can be deported or excluded from the country based on this?
Yes, sir.
All right, and what is your plea to the fleeing, attempting to elude, paraphernalia, and resisting without violence?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, be time served, 515 court costs, $150 PD fee. I'll give you 90 days to pay those costs or set up a payment plan with the clerk's office.
Yes, sir.
I do need you to be fingerprinted before you leave, and you have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
Time served each count. 548 court costs, so it's another $33.
Thank you, Judge.
I'll just change it. All right, Donald Millison, followed by Bennett Page.
Judge, is an
25 CF
information-
2494, burglary, occupied structure, and petty theft.
Has an information been filed? Oh, okay. All right, Judge, in that case, I'll enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions and trial by jury.
All right, that's going to be February 25th at 9 o'clock for a pretrial conference. We'll see you back on that day, Mr. Millison.
I'll come out and see you again.
All right, Bennett Page. All right, 25 CF 2431. Go ahead, Ms. Rivers. All right, Mr. Page, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right. Can you state your full name and date of birth?
Burnett Mark Page Jr., birthday July 4th, 1977.
Born on the 4th of July. All right, 25 CF 2431, you're charged with illegal dumping, a third-degree felony, punishment up to 5 years in state prison. You understand that?
Yes.
I've been given a plea and sentencing agreement that calls for you to plead to a lesser included of misdemeanor littering, 11 months, 29 days probation, waive cost of supervision, $270 court cost, $50 PD fee, $50 application fee. You also have special conditions to remove the debris from that parcel, and I'll reserve on restitution for a period of 90 days.
Yes.
Is that the agreement that, as you understand it?
Yes.
Is that what you want to do here today?
Yes.
Is that the state's agreement?
Yes, Judge.
All right, and Mr. Page, have you gone over this agreement with your lawyer?
Yes.
Did you understand and sign it?
Yes.
All right, are you satisfied with your attorney's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement I've just read?
No.
Do you understand by entering a plea there won't be a trial of any kind?
Yes.
Do you understand that you're giving up your trial rights, which are listed on page 1 and onto page 2 of the agreement that you've signed?
Yes.
And do you understand you're waiving all potential defenses that you may have up here?
Yes.
Everyone stop in the looks. I just want to make sure you're paying attention, Mr. Page. And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
I don't think I said this, but it's an adjudication of guilt. Do you understand that?
Yes.
All right. And what is your plea to the misdemeanor littering charge? Do you have a statute number for that, by the way?
No, you're not right, Pam.
No. No contest.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty to the misdemeanor littering. I'll find that statute number. 11 months, 29 days probation, waive cost of supervision, $270 court cost, $50 PD fee, $50 application fee. You have to remove the debris from that parcel, and I'll reserve on restitution for a period of 90 days. I need you to talk to probation behind you there, and then you have 30 days to appeal the judgment and sentence.
Okay.
All right, thank you.
Thank you.
All right, Haley Pennington.
403.413, Your Honor.
All right, we don't have an information on her, apparently.
She's on one of those on the list I'm looking into.
She charged with.
It is the state's intention to file an information. It just, I'm not sure what's going on.
So that statute number is 403.4136.
DUI stuff. They sent it.
Littering statute very often.
Your Honor, I thought she had another case. I thought it was a VOP. She was indicating it's not a VOP. Normally, I do file a motion at this stage on a case, but if she has other cases, I would ask that we put her on for 2-5. Patient filed. And if not, I'll have a motion at that time.
How long has she been in?
According to our calculations, it would have been over 40 days at this point.
Yeah, she also has 25 CF 2223, and she's set for a pretrial conference on the 23rd of February.
So, and she's been in jail since December 15th.
Like her bond was revoked in the other case due to this case.
Your Honor, she is trying to do treatment program. Goal.
All right, I'll put it on February 5th at 1:30 for a rearrangement. I mean, I think you're right, Ms. Rivers. If she's been in more than 40 days and hasn't been charged, I can release her, but she's still being held on the other case, so it wouldn't really change anything.
Exactly. This is all I have so far, but I'll come talk to you tomorrow.
Okay, thank you.
My concern is if I ROR now and then the state files an information, we may have to address bond again. So I can, however y'all want to do it, but let's figure that out by February 5th.
Yes, Your Honor.
Thank you. Brandon Pursley. We have a Brandon Pursley. Which one? Transport. Looks like he met. Bail bondsman with today's date.
Your Honor, there's also some matters going over in Walton County as well. I know that he has 2 cases, this case and another case. I don't remember.
Other case here plus Walton County?
No, I was going to say I don't remember for sure if the other case was here or Walton County, but I do know that there is a Walton County conflict with him, another person, to where there's a conflict and we have filed or should be filing a motion giving notice of conflict. Further representation of Mr. Pursley.
I've reviewed there's a notice to the bondsman with today's date, as well as the arrest report had today's date and time to be here. Based on that, it'll be a no bond KPs. All right, Tyrone Rush. All right, Mr. Rush, you're here in 25 CF 2475. There's not an information file on this one either.
Yes, Your Honor, this is charged as it was a 4th DUI, but we're
Trying to
still trying to
verify
track
if he's
down.
got that many priors.
Yes, so, but there will be a decision either to keep it or send it back down to misdemeanor court by next week.
Mr. Rush?
Sir.
They're trying to determine how many priors that you may have as far as DUIs before they make their charging decision. But I noticed that you don't have a lawyer appointed to you. Are you going to hire a lawyer?
Oh, I had a public defender.
Okay. And that's what I'm just trying to figure out.
Okay.
Doesn't look like one was appointed at first appearance, but if you'd like one, I'll appoint one.
Sir.
If you would like an attorney, I can appoint you one.
Public defender? Yes.
Okay, you just have to look at him and say it.
Yes, sir.
Is everything okay, sir?
Yeah. I'm just trying to get back to work and get on with my life.
I understand.
Your Honor, we'd ask that we be appointed, and then I would ask that this be continued to next week for an arraignment.
All right, February 5th at 1:30 for rearrangement. I am appointing the public defender's office.
See you tomorrow, okay?
He was arrested December 20th or 21st.
Yeah.
All right, we'll see you back next week. Natasha Seiler, followed by Kanika Staton. Miss Seiler? All right, Natasha Seiler's 25 CF 2414, grand theft, third-degree felony.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
February 23rd at 1 p.m. for a pretrial conference. Information has been filed. Ms. Staton or Staten? How do I say that?
Staten.
Staten, okay. All right, Ms. Staten, you're here in 25 CF 2470, charged with defrauding to obtain property and grand theft. Ms. Rivers?
Your Honor, we're going to enter a not guilty plea and request trial by jury.
February 23rd at 1 p.m., Ms. Staten. We'll see you back on that date. Stay in touch with Ms. Rivers. All right, Mr. Thacker, we already handled, correct?
That's correct, Your Honor.
Montana Yaz.
He's in custody, Your Honor. Your Honor, this is Montana Yaz before the court on 26 CF 33. We've reached an agreement in this matter, if I may approach.
Yes. Mr. Yaz, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your full name and date of birth, please?
Montana Marquis Shaws, 04/18 of 1992.
All right, and Mr. Yaz, you're here in 26 CF 33, where you're charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, as well as resisting an officer without violence and possession of drug paraphernalia, both of which are first-degree misdemeanors and punishable by up to a year in county jail. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that calls for you to plead no contest as charged and be adjudication of guilt. So it's a felony conviction, 30 days county jail, credit for time served, $515 court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Is that the agreement that you've made with the state?
Yes.
And did you go over this agreement with your lawyer?
Yes.
Did you understand and sign it?
Yes.
Are you satisfied with your lawyer's representation in this case?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this
No.
plea? Has anyone promised you anything other than the terms of the agreement I've read?
No.
You understand if there's not if you enter a plea, there won't be a trial?
Yes.
And you understand you're giving up your trial rights, which are listed on page 1 and 2 of the agreement you've signed?
Yes.
Do you understand that you're waiving all potential defenses that you may have?
Yes.
Do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes.
What is your plea to the 3 counts?
No contest.
I'll accept your no contest plea is freely, voluntarily, knowingly given, adjudicates you guilty, 30 days county jail, credit for time served, $515 court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee. I'll give you 90 days to set up a payment plan or pay off those costs. I do need your fingerprints, and then you need, you'll have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence.
No.
Each count is concurrent. Thank you. All right, is there anyone that was on the 1:30 docket that I haven't called? Yep. People put there for 1:30 or 2? Okay, I've got them on. Should just be a couple of them. Yes. All right, Mr. Maddox, are you ready to handle your quarantine?
Yes, Your Honor, I can do that. I do know that Mr. Duffy wanted to be present for Mr. Bray's. I just texted him, so we can do the other two first.
Who?
Kevin Bray, Your Honor.
No, but
Dave Duffy, Mr. Duffy.
who's that?
He is with the Fatherhood Initiative Program.
Okay.
But other than that, yes, Your Honor, ready to proceed.
You are in the meeting now.
All right, can you hear me at the jail?
I can now, Your Honor.
Yeah, sorry about this. Let me see, this worked last time. All right, there we go.
1 second, sir. You gonna want the booth first?
That's fine.
Booth is fine, yes.
Down.
Okay, I'll have to print it.
Your Honor, state's printing the score sheet now for Mr. Booth, but this is a guideline sentence, exactly what the guidelines were, 16.8 months, Department of Corrections.
Do you have the plea form?
Yes, Your Honor. May I approach?
Yes, please. All right, Mr. Booth, can you raise your right hand?
Yes.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Can you state your full name, sir? And your date of birth?
69.
All right, and Mr. Booth, you're here in 23 CF 2118, where you're charged with violation of probation. Do you understand that?
Yes, sir.
All right, and I've been given a plea agreement that calls for you to admit your violation, in return to be a revoke and terminate of your probation, adjudication of guilt, $100 VOP fee, $150 cost of defense, 16.8 months in the Department of Corrections, with credit for all time served, and your costs will go to judgment. Is that your understanding of the agreement?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Is that the state's agreement?
Yes, Judge.
All right. And did you go over this plea agreement with your attorney, Mr. Maddox?
Yes, sir.
And did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Are you currently suffering from any mental health issues?
No, sir.
All right. I didn't hear your response if you responded. That's why I'd asked it again. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've announced?
No, sir.
You understand if you enter an admission to your violation of probation, there won't be a hearing where the state would have to prove how you violated your probation?
Yes, sir.
And do you understand you're waiving all potential defenses?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying that? All right, I'll accept your admission as freely, voluntarily, knowingly given, and revoke and terminate your probation, adjudicate you guilty, 16.8 months in the Department of Corrections with credit for time served, $100 VOP fee, $150 cost of defense. All costs will go to judgment. Mr. Booth, you have 30 days to appeal the judgment and sentence of the court. Otherwise, I think that's everything.
Thank you, Your Honor.
All right, thank you, Mr. Booth.
Good luck, sir.
Thank you.
Your name, sir?
That's Mr. Bray.
Are you ready to handle Mr. Bray?
Mr. Duffy just texted me, Your Honor, that he'll be here, so if we could handle Mr. Fountain first.
I'm not going to have the jail juggling
Understood.
back and
Then,
forth.
yes, Your Honor, I have no stake in it, so that's fine.
I understand if he wants to be here, but this is a 2 o'clock case. It's 2:49.
Yes, Your Honor, I understand.
I'm dealing with a jail quarantine. I don't want to have them shuffling everybody in and out.
Yeah. Getting the state signature, Your Honor.
Mr. Maddox.
Can I approach, Your Honor?
I mean, there's already a 5-year suspended in place.
He had agreed to a 5-year suspended sentence in a previous plea agreement. That's what's being imposed here per this plea agreement, Your Honor, and then the new law charge is being dismissed.
Okay, I've got you.
Yes, Your Honor.
Just wanted to make sure.
Of course.
All right, Mr. Bray, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Can you state your full name and date of birth, please?
Jerome Bray, July 26.
All right, Mr. Bray, you're here in 23 CF 2408 and 2409, which are both violations of probation. And in 25 CF 1808, it's a possession of a controlled substance, which is a third-degree felony punishable up to 5 years. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that calls for you to plead, admit your violations of probation. In return, you'll be sentenced to 5 years in the Department of Corrections with credit for all time served. That'll run concurrent between those two cases. Revoke and terminate your probation, $100 VOP fee for each case, plus $250 total cost of defense. Your costs will go to judgment, and it is an adjudication of guilt. In return for that, the state is also going to dismiss 25 CF 1808. Is that correct?
That is correct, Judge.
All right, thank you. Mr. Bray, is that your understanding of the agreement?
Yes, sir, it is.
Is that what you want to do here today?
Yes, sir, it is.
All right, and did you go over this plea form with your lawyer?
Yes, sir, I did.
Did you understand and sign the agreement?
Yes, sir.
And are you satisfied with your lawyer's advice and representation?
Yes, sir, very much so, sir.
All right, and are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, I'm not.
Are you currently suffering from any mental health issues?
No, sir, I'm not.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir, they have not.
Has anyone promised you anything other than the terms of the agreement that I've read?
No, sir, they have not.
And do you understand by entering an admission to your violation of probation, there won't be a hearing where the state would have to prove how you violated your probation?
Yes, sir.
And do you understand that you're waiving any potential defenses that you have?
Yes, sir.
Okay, and what is your plea to the violations of probation? Are you admitting those violations or denying them?
Admitting.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given. adjudicate you guilty, 5 years in the Department of Corrections with credit for all time served, run concurrent. Revoke and terminate your probation, $100 VOP fee in each case, $250 total court costs, total cost of defense, all costs and and monetary to go to judgment. And the state have an announcement in 25 CF 1808.
Dismissed for plea to the other cases.
Okay, and I'm waiting on a score sheet, but this is a guideline sentence, I've been told.
Yes, Your Honor.
That's correct, and it's suspended as well, so.
It was a suspended 5-year DOC, which is what he's receiving.
Yes.
And
All right.
May we approach on that?
Yes. All right, thank you, Mr. Bray.
Yes, sir. Thank you.
I think we have one more.
Yes, Your Honor, Mr. Jared Fountain.
Fountain.
Yes, Your Honor.
He's coming in now.
Thank you, sir.
This one, I've got the signatures and the score sheet ready for you. So, small improvements.
It's not easy when your client is not here, so through no fault of anyone's.
I appreciate that.
All right. This is Mr. Fountain. Go
It
ahead.
is,
and
Your
announce
Honor.
it.
Your Honor, this is Mr. Fountain before the court in 24 CF 27, 26, and 2780. We've reached an agreed upon resolution, if I may approach.
Yes.
All
right. This would be a downward departure
A slight one, yes, Your Honor.
Yes, it is a downward departure,
based on,
uncoerced
Plea
negotiated plea.
okay. Mr. Fountain, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Can you state your full name and date of birth, please?
Jared Fountain, 11/26/93.
All right, Mr. Fountain, you're here in 24 CF 2726 and 2780, both violations of probation. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that would have you admit your violations of probation in those two cases. In return, it'd be 18 months Department of Corrections to run concurrently with credit for all time served in each case. Revoke and terminate your probation, adjudication of guilt, $100 VOP fee for each case for $200 total, $250 total cost of defense, and all of those costs will go to judgment. Is that your understanding of the agreement?
Yes, sir.
Is that what you want to do here today?
Yes, sir.
Did you go over this plea form with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've just announced?
No, sir.
Do you understand by entering an admission to your VOPs, there won't be a hearing where the state would have to prove how you violated your probation?
Yes, sir.
You understand you're waiving all potential defenses?
Yes, sir.
All right, and what is your plea to the violations of probation? Are you admitting or denying them?
Guilty.
All right, I'll take that as an admission.
Yes, Your Honor.
I'll accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, all cases, all counts, 18 months Department of Corrections to run concurrent, credit for all time served. Excuse me, revoke and terminate your probation, $100 VOP fee times 2, $250 total cost of defense. All your costs will go to judgment. And Mr. Fountain, you have 30 days to appeal the judgment and sentence of the court. This is a downward departure based on an uncoerced plea agreement between you and the state. He scored 23.7 months. All right, anything else from Mr. Fountain?
No, Your Honor. Thank you.
All right, thank you, Mr. Fountain.
Good luck, sir.
Thank you, sir.
All right, man. And then, Your Honor, I can go ahead and handle Mr. Moore and withdraw that motion to suppress if the court would prefer. Otherwise, I'll wait and you can handle whatever you want to handle, Your Honor.
Yeah, that's fine. What was the name again?
Stephen Moore, Your Honor, 24 CF 2937.
And you're just
Moore.
withdrawing your motion to suppress?
I am, Your Honor, based upon agreement reached with the state.
Is there a plea agreement? Is that-
There is, Your Honor.
Oh, okay.
May I approach?
Yes. Okay. Okay, it's reduced to reckless driving. I was going to say.
Yes,
we
Your
might. Okay, because it has to be reporting probation if it's a DUI. All right, Mr. Moore, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, sir.
All right, can you state your name, full name, and date of birth?
Stephen Bird Moore, 29 May 1963.
All right, and Mr. Moore, you're here in 24 CF 2937, where you're charged with possession of a controlled substance, third-degree felony, possession of drug paraphernalia, DUI, and possession of marijuana. Do you understand those charges?
Yes, sir.
And I've been handed a plea and sentencing agreement that calls for you to plead to the possession of paraphernalia and reduced or amended charge of reckless driving on count 3. That's Florida statute 316.1921A. In return for that, it'd be 11 months, 29 days probation concurrent between counts 2 and 3, adjudication of guilt, $368 court costs, $100 cost of defense, substance abuse evaluation, any recommended treatment. Supervision to be done by JCS, which would include mail-in reporting probation and waive cost of supervision. In return, the state also agrees to dismiss counts 1 and 4. Is that your understanding of the agreement?
It is, Your Honor.
Is that the state's agreement?
Yes, Judge, that's the understanding. That's all, sir.
Is that what you want to do today, Mr. Moore?
Yes, Your Honor, it is.
And just to make sure it's clear, we were here for a motion to suppress today, and your attorneys announced that you're going to withdraw that motion and accept the plea based on your settlement or negotiated resolution with the state.
Yes, Your Honor, that's correct.
Do you have any questions about that?
I do not.
Do you have any more, need any more time to speak with your lawyer about that?
I do not. Thank you.
Okay. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir,
And
in
did
depth.
Did you understand and sign it?
I did, sir.
All right. And are you satisfied with your lawyer's advice and representation?
Completely.
All right. And
Outstanding.
Thank you.
are you currently under the influence of any alcohol, drugs, or controlled substances?
Negative, sir.
Are you currently suffering from any mental health issues?
None professionally diagnosed.
Okay. Do you understand what's
I'm-
going on
I'm-
here today? Okay.
You don't need to be so technical, just yes or no.
I think we might all fall into that category to some extent, Mr. Moore.
Yes, Your Honor.
All right, has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've read?
No, sir.
You understand by entering a plea, there won't be a trial of any kind?
Yes, sir, I do understand that.
All right, and do you understand that you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
And do you understand that you're waiving all potential defenses?
I do. Yes, sir.
Do you understand that if you're not a U.S. citizen, that you could be deported or excluded from the country because of this?
Yes, sir, I understand that.
Okay. And Mr. Moore, what is your plea to the possession of drug paraphernalia and reckless driving?
As a no contest, sir.
The state have an announcement on counts 1 and 4.
Counts 1 and 4 would be dismissed in exchange for the plea.
All right, thank you. All right, as to counts 2 and 3, it'd be 11 months, 29 days, concurrent probation with JCS, adjudication of guilt, $368 court costs, $100 cost of defense, complete substance abuse evaluation, any recommended treatment. That's mail-in reporting probation. You're going to have to go meet with JCS. Can you get over there today?
I've spoken to Ms. Gilbert. I've already cleared him. She just said he needs to scan the QR code and they'll set up an appointment from there. That's how she wanted to handle his case. I've already given her all the information, but I'll make sure that gets done, Your Honor.
All right, make sure to report to probation as they instruct you.
Absolutely, sir. I've got one. I finished that information.
Okay, good.
I don't think I need fingerprints on a reckless driving.
Not to my knowledge, Your Honor. I don't believe it's
think so.
enhanceable.
All right, Mr. Moore, make sure you meet with JCS probation and follow up with that QR code. If they tell me that you didn't do that for a week or two, you're going to have to come back.
Yes, sir.
And you have 30 days to appeal the judgment and sentence of the court.
If you have any issues, call me.
Absolutely.
Thank you, Mr. Moore. All right.
I have 2 recalls I'm still working out, Your Honor.
I'm going to handle some of the other lawyers, get them moving when you guys are getting that stuff worked out. All right,
Of course.
Mr. Shaw. You got Mr. Laggett. It's 2012 CF 48. We're here on the, what was it called, a reconsideration, a rehearing?
Yes, Judge, we filed a motion
Maybe
for.
both?
Yeah. And court's aware, I think, what the issues are. I'm sure the court's.
I mean, I know what the underlying issue was, and then the motion was about whether or not the victim in the case had an opportunity to talk to the state and go ahead.
That's correct. And what I'd point out to the court was, at that hearing in March of this past year, and the court put in paragraph, I think it was 16 of the order, that the state had indicated they had talked to the victim. I subsequently talked to the victim, said that she told me, she's an adult, of course, now. Okay. So that's why we filed the motion. The court also, I think at the last hearing, when you granted the motion for rehearing, they wanted to know what her position was. Objected. She should be on Zoom.
I believe she is. Is that
So, Judge, we can ask her that question.
Maddie, is that who it is?
Yes, Your Honor. And to be clear, Your Honor, I don't believe I said I spoke to the victim. I said I know the victim's position because I had not spoken to her. So I did not want to mislead the court on that, but the position has been from the beginning, from her mother, who was her guardian at the time, that they did not want to get off early. I have subsequently spoken to the victim, so I do know her position now by speaking to her personally, but she's also available.
Yeah, and Judge, I was just going, obviously, by a recollection from what was said at the hearing and paragraph 16 of the court's order, which indicates the state advised it reached out to the victim in the case, and the victim opposed early termination.
And maybe I wrote that down. I don't recall. Usually I go back and listen to things when there's a confusion like that. I think I did at some time.
Judge, that's the main issue for today. There's one other issue about the 777 and the 794, all these websites. I told the court I would make some phone calls. I'll relay that to you.
Okay. All right, let's bring in, you want to bring her in and have her testify at this point?
Should be very quick.
All right, Ms. Boydston, are you there?
Seen her 19 years.
Yes,
Okay. Are you able to turn on your video or no?
I can.
Yeah, it's fine.
All right, thank you. All right, if I can get you just to raise your right hand to be sworn in. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes.
All right. Mr. Shaw, do you have questions?
Yes. Ms. Boydston.
Just make sure you speak into the microphone or she might not be able to hear you.
Ms. Boydston, my name's Tim Shaw. I've talked to you on the phone a couple of times. Is that right?
Yes.
And you've told me on the 2 occasions that I have talked to you that the state had not reached out to you prior to the March of 2025 hearing. Is that right?
Yes.
Okay. So you had not made your position known to the state as to early termination at that time. Is that correct?
Yes.
Okay. Currently, what is your position with regard to Mr. Laggett's request for early termination?
No. To protect my safety.
Did she?
I think she said no. Ms. Boydston, are you indicating that you're against the early termination or?
Yes.
Okay. That's what I took it as, but I can understand there's a little bit of a lag in the conversation.
Thank you, Judge. I don't have any further questions.
All right, Ms. Basso, do you have any questions?
No, Your Honor, I did speak with Ms. Boydston myself this week, and I was aware of her concerns for her safety. So thank you, Ms. Boydston. I appreciate that.
All right. Anything else from Ms. Boydston?
Not from Ms. Boydston, Judge.
Okay. So Ms. Boydston, you're free to go. You can also stick around while we finish up the hearing if you'd like. It's up to you.
Thank you.
All right, thank you.
Judge,
Shaw?
Mr. Laggett would like to say a few words to the court.
Okay.
And I've asked him to keep it as brief as possible.
Okay. Go ahead, Mr. Laggett.
Yes, good afternoon, Your Honor. I just want to say, this all started off, this was a 10-year custody battle for custody of my daughter. For 4 judges over a 10-year period. I finally got shared parenting from my daughter, and that's when things went south for me. Hired the wrong attorney. Polygraph's not admissible, but I've spent almost 13 years with probation without a single violation, not a one. We went to court back in 2023 with Judge Gonteric, and the argument was between the state's attorney and my attorney regarding Florida State Statute 777.04 and 794.011. We were going to reconvene a couple weeks later. I never made it. That same day, charges were filed against me for having a post office box that was authorized. I spent 9 months, 272 days incarcerated for having a post office box that was authorized. False arrest, false incarceration. I sustained a traumatic brain injury while I was incarcerated. Here I am today. Almost 13 years with not a single violation. My daughter's been brainwashed, coached by her mother. This is so wrong on so many levels. That's all I have to say.
All right.
And Judge, just for the record, I'll point out, I didn't represent Mr. Laggett initially when he had entered into the plea agreement.
I took his commentary on his previous attorney as the family law attorney, not the criminal attorney, but I understand, Mr. Shaw.
Thank you, Judge. Nothing further with regard to the motion for rehearing, Judge.
Well, I asked, or I granted the rehearing based on the issue that was talked about as far as what the victim had requested. Obviously, there hasn't been any change in circumstances as to what she's actually said versus what was, I guess, proffered by the state at the time. So based on that, I'm not going to change my previously entered decision.
Okay. Thank you, Judge. And the last issue with regard to Mr. Laggett was that discussion about the record still showing that he's under 794 as opposed to 777. I have looked at the DOC website.
Now, what is showing that? I just want to make sure I'm clear as to what you're referring to.
Judge, if you'll look at the clerk's page, and I have a copy here, if I may approach.
Yes, sir. Okay, and it says attempt, but it still says 794.
Correct. I have spoken with Mr. Embry, and he has indicated he's running it by his counsel.
Okay.
At this time. I also pulled up the DOC website, and it says attempt on the DOC website. It does not have any statute number, though, associated with it.
So basically, your concern is that the clerk's office is listing it as 794 still, even though it's an attempt.
Right. And Mr. Laggett has indicated he's spoken with FDLE himself, and and probation has told him they're not going to change it from 794. And so that's kind of where we are, based on the court's ruling that it is properly under 777 as opposed to 794. We'd ask the court to enter another order in these entities to make any changes to any documents they have as far as what the conviction is for to be 777. We understand the initial charge was 794.
I'm looking at DOC's website again, and it does say attempted.
Correct.
Doesn't list the statute number.
Correct.
As far as what the clerk lists, it says attempt to sexual assault, but then it has 794. Is it just the 794 statute number that's your concern?
That's Mr. Laggett's concern, yes, Your Honor.
Okay.
He wants it to say 777.
Yes, Your Honor. I've been under the wrong Florida state statute for almost 13 years. And yes, it does matter who you're...
I think everybody knows over the past 7 or 8 months, knows that the judiciary doesn't really have any control over what the clerk's office does. So I'm not quite sure what an order would do other than an order clarifying that he pled to the I'm forgetting the number. I'm sure Mr. Laggett knows it by heart. What's the 77604? Is that
777.04.
That's all right. It was off by one.
And Judge, I think, your order, I think, the order you've already entered should suffice. I mean, you made it very clear in the order that he was convicted under 777. So I think that should suffice. Like I said, Mr. Embry's looking into it right now and speaking with his counsel.
Well, I would suggest if you don't get any satisfaction from the clerk's office, we can certainly readdress it. I think my order spells it out. It's all based on a District Court of Appeal, First District Court of Appeal case. I guess I could also point out the fact that opinion was written by now Justice Tannenbaum. So I have to follow the rules just like everybody else. I think I've explained the situation according to the Gould case, which is the opinion I'm talking about. It changes how we've done things for at least the 20-plus years I've been in the criminal justice system, but it is what it is, and I think we've followed everything that needs to be followed. But if you don't have any satisfaction with the clerk's office, Mr. Shaw, we can certainly readdress it. But I think my order is clear, but if an order clarifying that is needed, I'll certainly entertain that. I just want to know what the response is first before I change it. I think I've already done what you've asked for. It's just a matter of making sure everyone agrees with me. As I jokingly kind of say almost weekly, is that some of the agencies don't really read our orders the way we expect them to.
And again, I agree with the court. I think the order is perfectly clear. When I find out from what Mr. Embry says, then if a motion is necessary, I'll lay it all out in the motion and file it, and then we'll address it again.
Okay. And frankly, that may be something I'll consider just on the paper as to what it is, because it depends on what the clerk's office response is to why they wouldn't change it.
Thank you, Judge.
Judge, so what is your decision about my early termination?
It's denied. It was previously denied.
It's still denied. So doing 9 months in jail, 272 days for a false arrest and false incarceration.
Mr. Laggett?
Yes, sir.
We're here for a reconsideration. I reconsidered it based on the issue that was brought up.
Perjury?
I'm sorry, you are?
I'm Anthony Modis.
If you make another outburst like that, you're going to be looking at contempt. Don't ever do that in my courtroom again.
We don't have anything further, Judge.
All right. Thank you, Mr. Laggett. Anything else, Mr. Shaw?
Yeah. Judge, Mr. Nopes had contacted me and asked me if I was going to be here today and would I cover his case, Bonnie Sue Hahn.
She present?
Is she? Could we take that now, or do I need to wait?
I don't have a problem with that. I mean, I'm trying to get the private lawyers out of here.
Appreciate it, Judge.
As we run a little late on our morning docket.
I should have told you. I apologize.
We're dealing with another quarantine at the jail, so it's slowed us down some today.
May we approach, Judge?
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
I got this. Let's roll.
Fight fire with fire. Take 1.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Fire. Damn thing ain't working. Whoa. Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath.
call coy.
All right. Are you Miss Hahn? All right. So, Miss Hahn, we're here for your violation of probation hearing. It's my understanding that the lawyer I appointed to you, which was just about 2 weeks ago, is going to be moving to withdraw or file that motion today. Have you had a chance to speak with him yet?
No.
Okay, because sometimes the paperwork doesn't get to him very quickly, but once it did, he's informed me, and it's not Mr. Shaw, he's just kind of filling in.
Okay.
Because Mr. Nopes, who I appointed and he's moved to withdraw, has a trial that he's dealing with, so that's why he couldn't be here, and probably the reason why he hasn't been even had a chance to see you, or there's a conflict. I haven't read the motion yet. But he does say he has a conflict. So I'm going to have to appoint someone else. What we were addressing at the bench is just, you've got another new case, right? And the Regional Office of Conflict Counsel has been appointed to represent you there. But that was just, again, less than 2 weeks ago. My concern is, I know they represent someone else who's involved in the same set of circumstances. So they're going to have to make a decision if they're going to withdraw from that person's case or your case. They get to make those decisions. They just probably haven't received the paperwork yet because, again, it's less than 2 weeks ago. So what I'm going to do in this case is allow for Mr. Nopes to withdraw based on his motion he filed this morning. Who's the next person on the list? It'll be Charles Williams. And then ultimately, let's just make sure we keep that. If RCC, Mr. Kleins withdraws from your case, I'll make sure to appoint the same lawyer so you're not dealing with two different lawyers on two related cases. So I just want to make sure of that. So because of that, we won't have your VOP hearing today because you don't have a lawyer here to represent you. Mr. Shaw, again, is just kind of filling in for Mr. Nopes. And then I'll set it for the next possible date that we can get it in. I just don't like setting hearings for lawyers who aren't here. So what I'm going to do is put it on for next week, February 5th. We'll get notice to Mr. Williams. That way he knows to try and reach out to you and contact you in the jail, talk to you before that date, and then y'all can at least establish some sort of plan as to how you want to go about things. But I don't want to push it off for a month for that to happen if I can get y'all back next week. Because after next week, I don't have another criminal court date until the end of February. And I don't want everyone to have to wait that long. All right. So February 5th, let's put it on for the 9 o'clock docket because it's not going to be a contested hearing on that date. And then we'll address everything as it kind of works itself out over the next week. All right. Thank you, Ms. Hahn.
Thank you, Judge.
Thank you. All right, Mr. Dyram, who do you have?
I have Mr. Klein, Judge. He's
Okay, I did see that, but,
Judge, it is going to be a contested hearing.
okay. Anything else we have to address before we bring it up for that purpose? I just want to see if I can maybe get a couple other people out of here, if at all possible. Mr. Gilbert. You're going to have a contested hearing, and who's that on? Clemens? Okay. Why don't y'all have a chat with your prosecutors to see who might be a faster hearing, and I'll see if I can get everyone out of here. Do I have anyone else?
2 pleas ready to go, Your Honor.
Okay. Who's that in the back? Did y'all talk?
Please ready to go, and I've got a sentencing and a motion to suppress hearing.
Okay. All right. Oh, boy. All right. Well, let's handle the pleas to get people out of here. And if y'all want to see which ones we'll talk amongst yourselves to see what you think might be shorter hearings that we can get more
Ramsey's gonna be the longest. I think the Kleins and the other one that's
Clemens?
they're gonna be the same time.
Okay. All right, let's,
Also, Your Honor, if I may, there is a Mr. Rape from, I think he's from out of town on a case that now is Miss Flowers, but is not on the docket. It was for a bond hearing, modification of bond.
okay.
I'm not sure if the.
I think I remember the case. I can't remember the name, though. Come on, good, come on up. What was the,
Case TA 25, 2125, Ivana Brinson.
2125?
I apologize, it's not Mr. Sprouse's case, it's Miss Flowers' case.
They've just
I apologize.
moved some people around. All right, what do you think we're here for, sir?
Motion to remove the income monitor, modification of the.
When was that filed?
December 11th, I believe, Judge.
Okay, I see the motion. Was it set for a hearing?
Yes, Judge.
When was that?
For today at 2.
No, I understand. When was it set for the hearing? Because I don't see anything as far as a notice of hearing.
The 20th, I think.
This was, I had coordinated with your JA in the email, so I'm not sure what.
But you have to file a notice of hearing, so that we know there's a hearing to be held. You have to put the other side on. I mean, what's the issue with the monitor? My concern is that she doesn't live in Florida, right?
Yes, Judge. They just created a financial strain. She's lost her job because of the GPS monitor, and she's having difficulty obtaining new employment. And because she's lost her job, it's affected her family and her kids, and supporting them.
Why would the GPS monitor cause her to lose her job?
Because it's present, Your Honor. Seeing a GPS monitor as a social worker is not the best thing to see as an employer.
Well, I understand. They're going to rehire her if she doesn't have it on?
It's preventing further employment.
I see that you filed a motion to dismiss as well.
Yes, Judge, and I would like to set that for hearing if possible. I just hadn't gotten a response.
From?
I sent her a copy of the motion to dismiss with the proposed order, trying to get another date, and I was trying to set that if I could.
Right. Typically, the clerk sets motion hearings in criminal court here. So I'm just. Please.
If the court is going to consider victims, victim and that that out of state, I think.
This is what I'd like to do, is organize one hearing date. Let's get both things heard. I've briefly reviewed your motion to dismiss. I'm not sure what the state's going to do with it because they have to review it and they can file something called a traverse or a demurrer, but typically a traverse or not. And then depending on how the state reacts to it, we can have that hearing. But the fact that a no notice was done it is required to set it for a hearing. And frankly, this happened in a civil case with me the other day. My assistant gave everyone a date and said, send your notice in, and nobody did, and half the people didn't show up. So, but the state has a right to notice as well. So I would suggest we just pick a date and put both on there if need be. My only dates, I've got one next week. I'm not sure if that would be enough time for the state to review and respond to your motion to dismiss. So if y'all want to, I agree. And just so as you saw, Ms. Flowers just took over this portion of the division herself. They've kind of shuffled some people around because of some personnel issues. So I can put it on February 26th is my next miscellaneous date where we can have those. Otherwise, and we're talking about, at least March.
Scheduled to come in on the 23rd as well. So,
well, that's a pretrial conference date. So we typically don't address motions on that date, just because, as you'll see when you get here, there's a couple hundred cases on that docket that day. So we're usually here till 5 or 6 o'clock on those dates, only handling kind of housekeeping, no motions, but just setting trial dates and things like that.
I'll coordinate with the state so we can find a date that works. If that's fine.
Well, I think we can put it on the 26th right now at 2 o'clock. Because otherwise, there's not going to be any other dates until after that. All right, so let's call it February 26th at 2 o'clock. Do a notice for the motions you want heard.
Thanks, Judge.
All right, thank you all. See you then. Yeah, any pleas that we can resolve? I think some of them are still from the 9 o'clock docket.
Yes, Your Honor.
Have anyone else on Zoom? Is anyone expecting anyone on Zoom for the rest of the afternoon?
No, Your Honor.
No, you're on.
Go ahead and turn that off.
Although did we coordinate any of the ones we discussed this morning in here about Slater Cole and the others you mentioned?
right, I've already sworn in Mr. Wilkes, correct?
Yes, Your Honor.
All right, Mr. Wilkes, we've already went through these questions. I've already sworn you in, right?
Yes, sir.
Okay, so you're here in 24 CF 2906. This is a plea and sentencing agreement on your violation of probation for 90 days in jail, credit for time served, revoke and terminate, and costs. Is that what you want to do today?
Yes, sir.
Did you go over this with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Do you need more time to speak with your lawyer?
No, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced you to take this plea?
No, sir.
Has anyone promised you anything in order to get you to plea?
No, sir.
You understand if you enter a plea, there won't be a VOP hearing where the state would have to prove how you violated your probation. And do you understand that if you're not a U.S. citizen, this could lead to your deportation? And what is your plea to the VOP? Are you admitting or denying it?
Admitting.
I'll accept your admission as freely, voluntarily, knowingly given. Sentencing to 90 days in the county jail, credit for time served, revoke and terminate your probation, $50 cost of prosecution, $50 PD fee, and a $50 application fee, all monetary. Well, I'll give you 90 days to set up a payment plan for that. All right. And as a guideline sentence, it is a misdemeanor probation. So, all right, thank you. You've got 30 days to appeal, Mr. Wilkes.
Yes, sir.
If there's no probation, it has to be an adjudication, especially if there's jail time.
All right, Mr. Selman, you're going to need to sign it right there.
Unless it is considered a special condition for probation, which is something we do very rarely just to.
Your Honor, this is Thomas Selman before the court on 25 CF 401 on a violation of probation. We've reached an agreement in this matter. If I know-
All right, so this convert the remainder to community control?
That's correct, Your Honor.
How much probation is he on?
How long were you placed on probation? 2 years?
All right, Mr. Selman, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I need to hear you out loud, sir.
Yes, sir.
Okay. Can you tell me your full name and date of birth?
Thomas Selman, November 19, 1961.
All right, Mr. Selman, you're here in 25 CF 401 where you're charged with violating your probation. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that would call for you to admit your violation. You'd be reinstated, convert your remaining probation time to community control, $100 cost of prosecution, $100 PD fee, $50 application fee, waive cost of supervision, and complete the terms that I've already ordered you to do.
Yes, sir.
Is that what you want to do here today?
Yes, sir.
Did you go over this form with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced you to do this?
No, sir.
Has anyone promised you anything other than the terms I just read you?
No, sir.
Do you understand that there won't be a VOP hearing where the state would have to prove you violated your probation?
Yes, sir.
And do you understand you're waiving all potential defenses?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying that?
Admitting.
Meaning.
I'm going to accept your admission as freely, voluntarily, knowingly given, reinstate you, convert your probation to community control, $100 cost of prosecution, $100 PD fee, $50 application fee, waive cost of supervision, complete all same and remaining terms of your original probation. Was he originally adjudicated?
Yes, sir.
Yes, Your Honor.
Sorry. All right, it says guilty. So All right, so Mr. Selman, I need you to talk to probation who's sitting behind you about your reporting, and then you have 30 days to appeal.
Judge, may I approach Madam
Yes, sir.
Clerk with a score sheet, or actually?
I still need it, yes. What was the sentence on the 5 years? Well, it's not suspended, right?
Okay, perfect. Yeah, I believe you. Yeah, you're good.
I've got
Thank
the
you.
score sheet on Bray. I've reviewed it and signed it.
Thank you, Your Honor.
Bray is from earlier. All right, Ms. Rivers.
Your Honor, this is Joshua Ramsey. He's before the court on a motion to set bond on 25 CF 1091. Your Honor, he was previously given a bond, but he later was charged in, I put 25 CF 77, but that should be 26 CF 77, and his bond was revoked at first appearance. Okay. Now, Mr.
So
Ramsey.
we're here for the 25
Correct.
CF 1091, but he also has 26 CF 77. Okay.
And when he got 2677, they revoked his bond on 25 CF 1091. Gotcha. Your Honor, Mr. Ramsey, I'm going to take some testimony from him regarding an incident where he fell in the shower and broke some bones on his face, and he needs to get out and get some surgery.
Okay. Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
So, Mr. Ramsey, did you bond out on 25 CF 1091?
Yes, ma'am.
All right. And did you have an accident while you were out on bond?
Yes, ma'am.
And what type of accident was that?
I passed out in the shower and hit my face and broke 6 bones.
All right. Are you asking the court to release you to get surgery for that injury?
Yes, ma'am.
All right. Have you made your court appearances in the past on these cases?
Yes, ma'am.
All right. And how much would you be able to post?
I'm not sure it's going to be up to my family at that point.
Okay. So you're asking the court to post, if you could post a similar bond as previously posted?
Yes, ma'am.
All right. So, Your Honor, he's asking for the court to give him a similar bond as previously given.
Mr. Sprouse?
Trying to figure out how to start. Mr. Ramsey, did you crash into a phone pole?
You can advise him, Ms. Rivers.
Yeah. You don't have to answer that question.
I choose not to answer.
You invoking your Fifth Amendment rights?
Yes, sir.
Okay.
Have you made any jail calls while you were incarcerated?
Fifth Amendment, I plead the Fifth.
I don't think that's incriminating,
I'm not
Judge.
sure how that would incriminate him, other than there could be something incriminating on the phone call, so.
Probably.
Which we have no knowledge at this point, so.
So I think he's free to not answer based on the Fifth Amendment right.
Who would you stay with?
My mother.
That's all I have. As far as questioning the
Okay. Anything else from him?
No, Your Honor.
Any other evidence?
No, Your Honor.
Any evidence from the state?
Just if the judge would, if the court would take judicial notice of case number 25CF 1091.
That's what we're here for, the
Forgive me.
CF 77.
That's correct.
I reviewed it.
Okay.
He's
So-
arrested for DUI and leaving the scene of an accident.
Yes, and
among other things.
DUI and leaving the scene of accident, he crashed into a phone pole and fled from the scene of the accident, went to the hospital, fled from the hospital too. What the defendant said his injuries from is falling and passing out in the shower. I submit that it's from crashing into a phone pole when he was DUI.
I would say he's not entitled to a bond.
I guess my question is, Ms. Rivers, do you have anything from a doctor or anyone that says that he even needs surgery, let alone what caused it and when?
Your Honor, we were trying to get some of that information from his mother, but we weren't able to get it in time. So at this point, the answer is no.
Anything as far as argument?
Your Honor, only that he has been given a bond in 26 CF 77. The court has addressed that issue. And
Entitled to one, yes.
yes, Your Honor. So we're here for the 25 CF 1091. He is asking the court to either reinstate his previous bonds or grant him new bonds that are similar in the amount as he previously posted. And he has sworn under oath that he fell in the shower, that he broke 6 bones, and that he is in need of surgery.
Any argument, Mr. Sprouse?
Yes, Judge. The defendant is dangerous. He is currently charged in the 25 case with trafficking in fentanyl. That is a dangerous crime under Florida statute. Furthermore, he's clearly dangerous by driving DUI and crashing into the property of this county. One being a phone pole, I believe, also a sign. So he fled from the scene of the accident and fled from the hospital. So he's in custody now. I think that's where he needs to be, given that he was out on bond. At the time, I believe it was SMD fentanyl, but I recently amended it.
Sale, manufacture, deliver.
Yes. So he's dangerous for the charges that he's from the case we're on, and he's dangerous from the new law that he picked up while he was out on bond. So I don't believe he's entitled to a bond. I believe that it should remain the same. Thank you.
Anything else, Ms. Rivers?
Your Honor, if I may ask if Mr. Ramsey would be willing to submit to drug testing and alcohol monitor if necessary, alcohol or drug testing? If the
Absolutely.
court would consider releasing him for the purposes of obtaining him some surgery?
Absolutely.
Did you already have a surgery date scheduled prior to your arrest?
I didn't have a schedule for surgery. I had an appointment with a specialist that was planning to give me a date for surgery when I went to go see him. And but I would be willing to submit to drug testing, ankle monitor, whatever the case may be, to be able to get out and get the medical attention that I need, Your Honor.
Again, I say it multiple times a day now, it seems, but the reason for bond hearings is we have to talk about danger to the community, flight risk, and integrity of the process. Mr. Ramsey was out on bond in this case when he picked up new charges that involve dangerous behavior as well as flight risk concerns based on leaving the scene of an accident. I have read that report where a judge has previously found probable cause that those things occurred. I don't have any evidence to show, other than his own word, that that there was some surgery that was being planned before the second case happened. I certainly would reconsider it if I had those things, but I don't. And frankly, I find his story to be less than credible. So, motion's denied.
Thank you, Judge.
All right. Thank you.
Your Honor, this is Mr. Quillen before the court. Filed a motion for bond.
What's the case number?
There's 2 case numbers, Your Honor.
We have one.
Yes, Your Honor, if you give me just a moment, I will, my
This is
screen.
one that wasn't on the paper docket, right?
Correct. All right, Your Honor, he is
And
before
I know
the court.
I talked about, I think before the lunch recess, that I may know Christopher Quillen. Now that I see him, you're not the person I was thinking of. So I think I represented someone with the same last name at some point, but I don't think it was you.
Your Honor, he's before the court on case number 26 CF 128, 26 CF 138. Your Honor, we filed our motion to reduce bonds And in so he has on the first case, he has a charge of possession of a controlled substance. Bond was set at $2,000, cash professional. Possession of drug paraphernalia, $1,000, cash professional. Fleeing or attempting to elude law enforcement, a bond of $10,000, cash professional. The second case, which was served on him the next day while he was in custody, he was charged with resisting an officer without violence, $1,000, cash professional, attaching improper tag, where he got an ROR. He got a driving while license suspended, no vehicle registration. The driving while license suspended, he had $1,000 bond, cash professional, no vehicle registration. He got a release on his own recognizance, and then he had a failure to have insurance with a release on his own recognizance. Okay. Then, he also had 26 CF 138, where he had flee and elude law enforcement, $10,000 cash professional bond, driving while license suspended, $2,500 cash professional bond. Current bonds total approximately $27,500. Mr. Quillen is unable to make these bonds. He's requesting the court substantially reduce this bonds or impose signature bonds. Mr. Quillen is a longtime resident of Okaloosa County. He has family, kids, grandkids, all kinds of family that live in the area, and he does have employment if he was released. He was employed at the time of his arrest.
I'm looking at Mr. Quillen's DOC record, which includes numerous prior prison history, including 2 counts of escape. First appearance paperwork indicate he's got multiple failures to appear, including as recently as 21 and 22. Based on that and the nature of the charges, I'm not denying bond. I'm just not willing to reduce anything at this time.
Thank you, Your Honor.
Thank you.
Your Honor, this is Tony Tatum before the court on 20 CF 1826, 20 CF 2406. We are here because PD2 filed a motion to correct illegal sentencing errors pursuant to Rule 3.800B2. And that is what is before the court. We have previously had
I don't think it was an illegal sentence. It was just the score sheet wasn't correct.
Right, Your Honor.
I like to be
Yes.
accurate.
Yes.
My understanding was I asked, and I went back and listened to it.
Yes, Your Honor.
Is that I went back and saw that there was supposed to be a new score sheet. Y'all had talked about it went from 53.775 to 50.775. But when I looked at that score sheet now, it still has the 3 violent felony offender points where there was no finding of that at the VOP hearing or the sentencing.
Basically, Your Honor, it seems like it kind of stopped after the hearing. So I think that's why PD2 filed this motion.
Yes, well, I know part of my order was, I believe, was that there would be new guidelines, and I don't think they've ever been filed.
That's correct, Your Honor.
So I think the issue is, should the guidelines have those 18 points removed because they should have been, I think we kind of dealt with this in another case today, they should have been 6-point violations instead of 12 because there were no factual findings that were made regarding it being violent felony offender.
That's correct, Your Honor.
So my calculation then turns the lowest permissible to 40 point something.
275.
Yes, okay, thank you, Mr. Sprouse. This is following having not been at the original hearing. Does everyone agree with that?
State agrees.
Yes, Your Honor.
So do you have guidelines indicating that, Mr. Sprouse?
Yes, Judge.
Have them?
Yes, you may.
Have you seen them? Make
Yes.
sure there's no other concerns?
Yes, Your Honor, I did.
Date of sentencing is, well, sure. Well, today would be basically a change in the sentencing. All right, so that was removed. So instead of section 6 being 36 points, it's 18 points, which reduces it again from 50.775 to 40.275. Now, I went back and listened. I didn't make any determination that I was making the sentencing based solely on what the guidelines were, so I don't think I'm required to go below what I previously did. However, I did go back yesterday while preparing for today's docket and listen to the VOP hearing that we had. And I know Ms. Rivers made arguments that regarding hearsay issues. I found that there was some exceptions to hearsay, so they weren't hearsay because of that, and ultimately made a determination that he did in fact violate his probation. So it's really just the sentencing. Do y'all have any argument regarding sentencing? What's the state asking for?
May I confer with my colleague real fast?
Sure. Just because I know you weren't here for that particular.
Thank you, Judge, for your patience. The state would ask for what he was already sentenced to. I know that the score has changed, but that's the floor as far as the state's concerned, so we would still be asking for I believe it was 50 months EOC.
Your Honor, in speaking with Mr. Tatum has, since that sentencing served this additional time, plus the time that he has served prior to the VOP hearing, he's asking for the court to give him a time-served sentence.
What would be the reason for the downward departure be? And frankly, I don't even think I can entertain that because it wasn't argued at the original sentencing.
Yes, Your Honor.
In fact, I made a comment on how there wasn't any reason for downward departure. Just to make sure it's clear, I went back and listened to the sentencing hearing, which is separate, I believe. No, I think it was at the same time. But I went back and listened to the previous issue where it got reduced from 53 to 50. So I listened to all that on Court Smart. I watched the recordings of those videos. Again, the court didn't make any indication that the decision was made solely on what the score sheet was. Based on that, I'm going to resentence Mr. Tatum to 48 months Department of Corrections, which is a guideline sentence.
Thank you, Judge.
Yes, Your Honor.
Again, I don't think I can go under the 40.275. But there's nothing requiring me to go all the way to the bottom of the guidelines.
Yes, Your Honor.
Thank you, Mr. Tatum. Plank, Brianna Plank.
Yes, Your Honor.
none of which actually works.
This is a Ms. Basso case, Your Honor. See if there's any notes, because Ms. Basso stepped out.
I'm going to just state to the court that based on the notes that I have from Ms. Bozo on this case, she indicates that the offer right now, it's incarceration. Is that what the...
Okaloosa County Jail, that's the offer. Revoke and terminate, 6 months, Okaloosa County Jail. It's a plea, it was a plea to misdemeanors.
Ms. Plank?
That's correct, Your Honor. Last trial cycle. It was set for trial, and we resolved it. Jury trial review. She pled to 2 misdemeanors.
Say the plea form says 2 lesser included, 2 counts misdemeanor battery, consecutive. I just want to make sure everything's right, because an amended information was then filed. It's still charged with child neglect and battery. Filed on 11/4. Order of probation indicates 2 simple batteries. I think that's what happened. I just think the information that was filed the day after is incorrect. The amended information, excuse me.
Yes, sure. I did just provide Ms. Leone a copy of the email from Ms. Basso where she conveyed the offer.
All right.
She also responded in the meantime. She said yes.
Be clear, she was put on 2 consecutive probations, and the offer would allow it to where she would, this probation would be revoked and terminated, the next probation would be eliminated, and she would just do 6 months Okaloosa County Jail, credit for any time served.
Did she do anything on probation?
She wasn't on very long. She was homeless, and that became an issue. Her children are now in another state.
With whom?
With the family members in another state. So at this point, she just wants to do her time and be able to get out and relocate to the state where her children are.
Is there another case involving the children? Or dependency or anything?
Yeah, they closed that out, right?
Yes, they closed it out.
That you got a letter from DCF closing the case.
Ms. Leone, I know this is not your case, but has the state investigated this case and this is what you're comfortable with as far as a resolution to her VOP?
Yes, Your Honor.
All right, Ms. Blank, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes, sir. Can you state your full name and date of birth, please?
Michelle Plank, January 16th, 1998.
Ms. Plank, you're here in 25 CF 1027 on a VOP on 2 misdemeanors. Do you understand that? I've been handed a plea and sentencing agreement where the state has agreed that you can enter an admission to your violation of probation. Court would revoke and terminate your probation. The probation on count 2, which is set to begin after count 1, will be modified and deleted. So basically, all probation will be over with. Do 6 months in county jail, credit for time served, $100 cost of prosecution, $100 PD fee, and $50 application fee. Is that what you want to do here today?
Yes, sir.
Have you gone over this agreement with your lawyer?
Yes, sir.
Are you satisfied with her advice?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Oh, nobody's dated it. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
Yes, sir.
Did anyone force you to take this plea?
No, sir.
Anyone promise you anything to take this plea?
No, sir.
Do you understand there won't be a VOP hearing where the state would have to prove how you violated your probation?
Yes, sir.
And do you understand that you're waiving all potential defenses?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying it?
Admitting.
I'll accept your admission as freely, voluntarily, and knowingly given. I'll revoke your and terminate your probation on count 1, modify your probation to be deleted on count 2, 6 months county jail, credit for time served, $100 cost of prosecution, $100 PD fee, and $50 application fee. That is an adjudication of guilt. Was it a withhold or not beforehand?
There was not.
Judge is guilty. Okay. All right, so Ms. Plank, you have 30 days to appeal. Thank you. All right. Ms. Leone, it looks like the clerk's office has reached out about the amended information still that was filed the day after the plea still has it as a felony. So if that could be amended again to reflect what was done in the plea agreement for Ms. Plank.
Yes, yes, Your Honor. I'll put a note right now.
That was my confusion, is one thing said felony and misdemeanor, but everything else said misdemeanor.
I understand.
Just want to make sure the paperwork's right. We got to get through these contested hearings too.
This is Conrad Franklin, Your Honor?
Yes.
I'm appointed on this case.
All right, Mr. Franklin, you're here on a violation of probation in 2015 CF 1363. I think there was a second case number. You intend to hire a lawyer, sir?
No, sir.
All right. You want me to appoint you a public defender?
Please, sir.
Also 2024 CF 151. I'll appoint the public defender in both cases.
Yes, Your Honor.
What would y'all like to do today?
Are they both VOPs, Your Honor?
They're both VOPs.
Winter denial at this time unless the state has an offer that get him out. Winter
No.
denials, Your Honor.
Oh, yeah.
All right. What do you want to put it on? 26 in the morning?
Is this the arraignment for?
This is the arraignment.
Okay. I would ask for the 26th, Your Honor, without.
February 26th at 9 o'clock without subpoenas.
Thank you, Your Honor. I'll come see you, sir.
Thank you, sir.
All right. All right, do we want to flip a coin on Mr. Dyram versus Mr. Gilbert?
We worked it out.
Okay, who's going first?
Mr. Dyram's going first.
Mr. Dyram, okay. Was Miss Flowers excused to go? I just want to make sure one of y'all was.
It's always a struggle, you know. You know very well.
Definitely know. Mostly out of that phase, but.
Yeah.
Did y'all resolve it, or?
No.
Okay.
Between the attorneys, we figured out who was going to go first.
Usually I just say arm wrestle for it, but.
Mr. Gilbert might have me.
Yeah.
Your Honor, Mr. Klein is present in 22 CF 1153, and we are prepared to proceed on a hearing.
For the violation of probation. Nate, how would you like to proceed?
The state would like to call Officer Otis Brown.
Otis Brown, please. All the way up to, yeah. We're running out of room for everybody else, so. All right, Mr. Brown, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir. Can you take a seat there? Make sure you speak into that microphone for us. All right, go ahead with your questioning, Mr. Sprouse.
Thank you, Judge. Officer, could you please say and spell your name?
Yes, Otis Brown, Otis Brown.
And where do you work at?
I work for the state of Florida for probation.
And
down
how
in Fort
long?
Walton.
How long have you worked for the state probation office?
3 years.
Okay. And are you familiar with a Christopher Klein?
Yes.
How so?
By his records.
Okay. What records?
His probation records, his folder. I haven't personally met him.
Okay. Those probation records, are those kept in the normal course of business?
Yes.
Okay. Do you know if Mr. Klein is currently on probation?
Yes.
Okay. And is he currently in violation status?
Yes.
Why?
Because he didn't complete his conditions of probation.
Which were what?
He had to complete DUI conditions. He had to complete, no, I'm sorry, not DUI. He had to complete mental health. He had to complete 50 hours community service, and he had to pay his fines.
Okay. And before Mr. Klein was arrested on this violation, did he do any of that?
No.
Did he do anything?
No.
Did he get arrested for a new law violation?
He had a FTR in Georgia.
An FTR?
Yes, a failure to appear.
Okay. So do you mean FTA?
Sorry, FTA.
Okay. Was Mr. Klein instructed on his conditions?
Yes, he was.
How do you know that?
Because he signed his probation orders.
Okay.
I have signed probation orders on him.
Okay.
Yes.
Do you recognize this?
Yes.
What is it?
It's a Florida standard conditions of probation. It's a temporary orders that they first sign when they leave the courthouse and come to the probation office.
Okay. And how do you recognize this?
It's one of our standard forms.
So is this document this is a copy of a document that's in Mr. Klein's file?
Yes, sir.
Is this is it altered in any way?
No.
Okay. Your Honor, permission to enter States 1?
Objections, Mr. Dyer?
No objections.
Did it without objection.
And permission to publish, Judge?
Me?
Yes.
Please, if I could review. Mr. Sprouse.
How many times was Mr. Klein instructed on his conditions of probation?
At least twice.
And you know that how?
Because the form you just showed me was his temporary orders before the judge signed, and then he signed a copy, he signed another copy that the judge signed.
Okay.
That was put into court records.
Since Mr. Klein has been arrested on this violation, has he remedied any of the discrepancies?
Yes, I looked in the court records this morning and noticed that he paid his fines and court costs.
Okay. And did he make a donation to a charity?
Yes, I seen that today when I came in the courtroom. His attorney showed me that.
Okay. But all of that was done after he was arrested on the violation of probation?
That's correct.
Tell me about the mental health evaluation. What was he supposed to do with that?
It has in his records he was supposed to went down to, I believe it was Bridgeway, and have them do his eval and treatment if necessary.
Okay. Does Bridgeway have any record of that?
No,
And how do you know?
because I contacted Bridgeway and asked them.
So they never even met Mr. Klein?
No.
Okay, that's all I have.
Mr. Dyram?
Thank you, Judge. Mr. Brown, you stated earlier that you had never met with Mr. Klein, is that right?
That's correct.
So you did not supervise him, correct?
No.
Do you know who his original probation officer was?
Officer Thice.
And approximately how long was that PO on his case? Do you know?
Not exactly sure, no.
Okay. He transferred his probation to Georgia, is that right?
Yes.
Do you know when that was done?
That was done in 2023. He had another officer at that time who did that paperwork for him.
So he had one officer when he got placed on probation, is that right?
Correct.
Then he applied to transfer to Georgia, had another probation officer, is that right?
Correct. His original probation officer left the agency, and he left the agency. So he had another one that was in our office.
And then he transferred to Georgia and had a different probation officer there, is that right?
Correct.
Did you, or to the best of your knowledge, did your office ever communicate with his probation officer in Georgia?
Yes, I sent several papers to his probation office up there.
Did you ever hear back from them?
No.
So do you know if his Georgia probation officer ever told him that he had outstanding things to do?
No, I don't know.
And at the date and time that he was violated, you had reached out to Georgia but did not hear back, is that right?
Correct.
Okay, I don't think I have anything further. Thank you.
Yes, briefly. Did Mr. Klein sign documents acknowledging that he was aware of his conditions of probation?
Yes, sir.
Thank you.
Step down, sir. Thank you.
Thank you.
Any other witnesses, Mr. Sprouse?
No, Judge.
Any other evidence?
No.
Dyram?
Your Honor, if I can call Mr. Klein, and if you'd like him to take the
I
stand.
like that.
Yep, go ahead.
Take a seat up there. Mr. Klein, if you could raise your right hand, do you swear or affirm the testimony about to give us the truth, the whole truth? Make sure you speak into the microphone.
Yes, sir.
Mr. Klein, please state your name,
Christopher Klein.
and can you please tell the court when you were placed on probation?
I want to say August of 23,
And did you?
or 22, I'm sorry, excuse me.
Okay. And where did you transfer your probation?
To Columbus, Georgia, Muskogee County.
When did you do that?
At the end of December on 23, year 23, or 22, I'm sorry.
When you transferred your probation, were you informed that you had anything outstanding?
No, I was not.
When you moved to Georgia, did you check in with probation there?
Yes, I did.
And who is your probation officer there?
Officer Andrea Mixon.
When you were in Georgia, how many times did you check in?
I checked in the one time originally, and I was put on no supervision probation, which is where I would call the 1-800 number every month to verify if anything changed with my status, my working status, things of that such.
Were you ever told by your probation officer in Georgia that you had anything outstanding?
No, I was not.
When you found out about the warrant, what did you do?
I got my affairs in order and I turned myself in.
I don't think I have anything further, Judge.
May I get States 1, Judge? Signature?
Yes, sir.
Okay. This line right here. What is that?
Which one?
What does that
The
say?
no contact with Jeffrey Moore?
No, underneath it.
Mental health evaluation.
Okay, what does that mean?
I'm not really sure what it means. I'm assuming it's an evaluation for my mental health status.
Did you do that?
No, sir, I did not.
And you know you didn't do that, correct?
Yes, sir.
Even when you went to Georgia, you know you didn't do the mental health evaluation.
No, sir.
Were you aware that you didn't do it?
I was aware. When I checked in with Georgia and asked them, did I owe anything? Did I have any special stipulations? They told me I did not. So when I was transferred to Georgia, I was under the assumption that everything was transferred to Georgia.
So it's correct that you're assuming that you did something that you know that you didn't do?
I wouldn't say that, but I'm assuming, like I said, I assumed that everything was transferred to Georgia. That was the assumption I was under. When my probation was transferred, I figured everything was transferred.
So possibly a mistake with Georgia, right?
Yes.
So you just wanted to benefit from that mistake?
No.
No further questions.
No, Your Honor, I don't have anything further.
Step back to with your address. Any other evidence?
No, Your Honor. Argument.
Any rebuttal evidence?
No, Judge.
All right. Argument from the state.
Briefly, our standard here is preponderance of the evidence. I think we're actually at beyond a reasonable doubt as far as the defendant not completing his terms. It's willful. He was instructed twice. He was also instructed by the court on what he agreed to and what his conditions were. It appears through the testimony that there may have been a mistake through the interstate compact, but that doesn't change the fact that he knew that he had a mental health evaluation and wanted to essentially get a windfall that we know of. But that's what the defendant has told us. We have not heard from his probation officer in Georgia. So I believe he is in violation of his probation willfully.
Judge, Mr. Klein has obviously been on probation since 2022. I think the testimony has shown he's had multiple POs, 3 here in Florida. When he transferred from here to Georgia, he's under the impression that everything was transferred with him, so he would have been told what to do. He was in Georgia for close to 2 years. He checked in one time in person, and then he called every single month. Not really sure about the FTA that was brought up, but he's not charged with that here. Every time he called, he said nothing prompted him to do anything else. So once the warrant came out, he is married with kids. They got everything wrapped up and moved down here, and he turned himself in, and he's been in jail since June. I'm asking the court to find that this was not a willful and substantial violation. Since he's been in jail, he has paid his court costs. The community service has been paid. He was aware of a mental health evaluation while he was in jail. I believe he tried to sign up for one, but there was a delay, and he never got on the list to get that done, Judge. And I believe that's the only thing that's outstanding now is the mental health eval. Nothing further.
Just briefly, before he was picked up, nothing was done. So I believe that if somebody doesn't do anything on probation, that is substantial.
All right, based on the evidence that I've heard, there's clearly a substantial violation in that he didn't do the things that he was ordered to do. He was instructed on what to do. The only question is whether or not it was willful. I can't say exactly what happened at the plea hearing, other than I can review the court file as to what the plea agreement said, which is he was required to do these things. I don't know what was said as far as what, I didn't go back and review it from 2.5 years ago. Actually 3.5 years ago, right? I'm getting confused in 2022 and 2023, just like Mr. Klein's. Klein, I'm sorry, it's Klein, not Klein's. But I find it hard to believe he didn't understand that he had to do the conditions that he was told by a judge and told by a probation officer and reported to them. I think being supervised in another state through the interstate compact is a privilege. That doesn't mean you get to go there, and if they don't follow up, you just don't get to have to do your conditions. I think he knew he had to do his conditions. He didn't give, when he took the stand, he didn't give me any reason to believe that, he was told by anyone he didn't have to do them. It was just out of sight, out of mind. And at this point, I find that he is in a willful, substantial violation of his probation. It's my understanding that Mr. Klein had pled to the probation and also a suspended sentence. Is that right?
Correct, Your Honor.
Of 36 months in the Department of Corrections.
That's correct.
All right. Mr. Dyram, based on the fact that I found him in a willful, substantial violation of his probation, how do you want to proceed?
Your Honor, I'd like to have a sentencing hearing if the court wants to entertain a brief sentencing argument now.
I mean, I'll give you a sentencing hearing if that's what you'd like. Again, I'm not one that typically gives suspended sentences. I understand it was part of a plea agreement with two different lawyers and a different judge. So I don't mind putting it off so we can discuss that. And then y'all can certainly put on your case as to whether or not I should give the suspended sentence. I think we've talked about it on other cases, even just today. Mr. Dyer, maybe in a case that you weren't on, but Mr. Sprouse was. I don't always understand the purpose of a suspended sentence, because all it does is limit the judge's ability to make a fully fashioned, individualized decision on a case. But I'd like to hear the arguments, but I don't think we're ready for that today. I want to make sure y'all have a chance to put together those arguments and any sort of mitigation or aggravation arguments y'all want to make.
Understood.
All right. When would y'all like to place that?
Beginning of February or the next available miscellaneous docket, Your Honor?
Well, I've got next week. I'm not sure that's going to be enough time for y'all. Other than that, it'd be 2/26.
I'd be fine with actually the 5th for.
Just because the 26th is already getting pretty hectic.
It would be Thursday the 5th at 2?
A week from today.
That's fine, Your Honor.
All right. Let's do that at 2 o'clock.
Thank you,
February
Judge.
5th.
Thank you, Judge.
Have a good day.
All right. Thank you, Mr. Dyer, Mr. Klein. We'll see y'all next week. If you're going to draft anything, just make sure you send one directly to my office so I get it and can read it in advance. All right. All right, Mr. Gilbert. All right, and it's Mr. Clemens, correct?
Yes, Your Honor.
State of Florida versus Isaiah Clemens, 24 CF 273. We're here for our contested evidentiary hearing, correct?
Yes, Your Honor.
All right, is the state ready to proceed?
Yes, Judge. State's ready to proceed.
Who's your first witness?
It's going to be Ms. Bentley Clemens.
Clemens? Oh, there she is. Clemens, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Seat there. Make sure you speak into that microphone. You may proceed with your questions, Mr. Sprouse.
Thank you, Judge. Good morning, ma'am. Nice to see you again.
Good afternoon.
Yeah. Can you please spell your name for the record?
EENTLICLEMONS.
Do you know Isaiah Clemens?
Yes, sir.
How so?
My ex-husband, father of my child.
And you're a victim of a crime, correct?
Yes, sir.
Where Mr. Clemens is the perpetrator of that crime?
Yes, sir.
And there were special conditions that was placed on his probation, one of them being no contact with you. Is that correct?
Yes, sir.
Okay. Did he contact you?
Through my roommate, yes.
When did that happen?
On November 24th.
Okay. Where were you at?
I was at work at the time when she shared the message with me.
And who is your roommate?
Savannah Adams.
And what did that message say?
I'm sure you're aware of my situation, but I'm really needing some type of copy of Monty's birth certificate. I've been for health insurance. I've been providing health insurance for her the entire time and paid her medical bills.
You paid her medical bills and provided health
That was the
insurance?
message from him.
That's what he said?
Yes, to her.
Okay. Is that true?
Not that I'm aware of, no. I've paid all of her medical bills and provide her health insurance.
Okay. And is that through your employer?
Through my employer, yes, sir.
And who is your employer?
Regenerative Labs,
And where's that at?
Pensacola, Florida.
How long you been there?
Currently 6 months, and then previously I was at Orthopedic Associates for 3.5 years.
Yes.
Do you recognize this?
Yes, that's a screenshot of the message.
Okay. How do you know?
That was sent to Savannah Adams. She screenshot it from her Facebook Messenger and sent it to me and let me know that he contacted her.
Objection, Your Honor. She's discussing someone else's experience here. This is hearsay.
Is a VOP hearing judge hearsay is allowed, as long as it's not just
I understand. Usually in VOPs, I make a determination if they're hearsay on each individual thing, just to determine if there's anything besides the hearsay ultimately. I think anything that was said by the roommate, Miss Adams, would be hearsay unless I hear for an exception for it.
So, I just want to understand what the objection is. Is the objection to the document or what Miss Adams said?
The objection is to what she was relating about what Miss Savannah Adams did or told her. It's clearly outside of court communication, trying to come in to prove something. Is Miss Savannah Adams going to testify?
No.
Then clearly they're trying to use hearsay as the replacement.
This is the defendant's words, so I would say it's not hearsay.
Well, I think it's double hearsay, potentially, as far as how you're authenticating that to be.
It's also his profile picture and my daughter's
Ma'am,
name.
this is a legal argument. I'll just let Mr. Sprouse handle it. That she didn't receive the actual text message. It would take Miss Adams to say, this is what I received from him, right? So, again, it's admissible because it's hearsay, but it is hearsay. Go ahead. I'm sorry, it's admissible because it's a VOP hearing, but I do determine it's hearsay at this point. I'll entertain any arguments further as we go through different statements, but.
Commission to enter State's Exhibit 1.
The only objection I have, Your Honor, is when she read it, she did not read it verbatim.
Okay.
So if we're going to use that, then we need to correct that.
Well, but once it's admitted, obviously the court will read it.
Yes, Your Honor.
Okay. Well, and there being no objection will be admitted. Yes. I believe we just had a bond hearing where this was also introduced a couple weeks ago, right?
Yes, Your Honor.
What feelings were elicited once you received that message that came from Mr. Clemens?
I was extremely uncomfortable and uneasy, and it definitely spiked anxiety. As I met Savannah after I left him, So, as I'm going throughout my workday, and then he's requested to message her, I don't understand how he would have known her, and, we've had no contact. And as I mentioned, I provide her health insurance and documentations for that, so,
Does Savannah, your roommate, have important documents?
no, and that's only something that I would have.
Does she have access to?
Absolutely not. It's locked in a safe.
So the only way for Mr. Clemens to get those documents would be through
me.
you? That's all I have, Judge.
Over across.
So Savannah Adams gave you the email?
Yes.
Did she say she had talked to him?
No, she has never spoken to him before.
So he hadn't asked her to hand it to you?
No, absolutely not.
That's all I have.
No, Judge. State would call Officer Fowler from probation.
Fowler. Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth?
Good afternoon, officer. Would you please say your full name and spell it for the record?
Jasmine Fowler, JASMYNNEFOWLER.
Where do you work at?
I work for the Florida Department of Corrections.
How long have you worked there?
3 years.
Are you familiar with Isaiah Clemens?
Yes, sir.
How so?
I'm his probation officer.
Okay. Was he instructed on the conditions of probation?
Yes.
How do you know?
From the probation order and the case notes.
Okay. And did he sign a document acknowledging the conditions of his probation?
Yes.
Was he instructed about no contact and what that means?
Yes. He was instructed on no contact, direct or indirect, per the probation order.
And how many times was he told that?
2.
That's all I have, Judge.
No question, Your Honor.
Any other evidence, Mr. Sprouse?
No, Judge.
I'd like to call Mr. Isaiah Clemens.
Clemens. Raise your right hand. Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth? Take your seat. Make sure you speak into the microphone, please.
Please state your name.
Isaiah Lamar Clemens.
You sent the message to Savannah Adams,
Correct.
and why'd you send it to her?
Because of the previous daycare, she was on the pickup, so I figured that she was a trusted guardian of Monty's for the most part.
So could you explain that a little more?
I stayed on the daycare app. It was just a way to stay up with my daughter. They send pictures, and they just kind of send her whatever happened throughout the day, new updates on her.
And do you have any restrictions of contact with your daughter?
Incorrect, no.
And so again, why did you contact Savannah Adams? What?
I just felt like she was trusted in a sense. She would know. Oh, yeah, or she would be able to get it for me.
And how did you know that she was somehow involved with your daughter? You mentioned the daycare.
The previous daycare my daughter went to, I was still in the app, and they sent updates throughout the day. And she was on the pickup list, and that's how I found her. That's how I knew about her.
So she's someone who's close to your daughter.
Correct.
Why did you say you understand my situation?
Because from my understanding, there was no contact with Bentley, and I didn't really expect the message to get to her. I just expected either a picture or a no.
How long have you been on probation?
Since November of 2024.
Have you had any other incidents?
No, sir.
Where do you work?
USIC, infrastructure company.
Have you had any contact with your daughter?
No, sir. Or the one day I went to daycare, then she was withdrawn the next day.
All right, and what are you doing about that now?
I'm working with Cotton and Gates, currently doing financial paperwork so we can get divorce finalized and hopefully get rights back to her.
And until that's resolved, if you do need to contact Ms. Clemens regarding your daughter, how would you plan on doing that?
Definitely through Cotton and Gates.
That's all I have, Your Honor.
Yes. When you sent that message, you knew that it was probably going to get to Bentley, correct?
No.
So you had information that Savannah Adams had the birth certificate for your daughter?
Honestly, I didn't know. That's why it was a question.
What was the question?
If she could send it, please do. If not, that's fine.
So you found on, can you explain what this daycare app is?
It was basically just an app so you can stay in tune with your child, know what they do throughout the day, know what they ate throughout the day. And it was a pickup list on there. It was me, Bentley, her father, I believe, who stays in Washington, and then the Savannah Adams.
Okay. And did you know the relationship Bentley had with Savannah Adams at the time?
Negative, but I was concerned on who was picking my daughter up, so I looked her up on Facebook, and that's when I seen endless pictures of my daughter, so I assumed that she was somebody that was trusted and very well close to Monty.
So what did you want from Savannah Adams? A picture?
Is this some type of copy or picture of the birth certificate, correct?
And what makes you think that she would have that?
Because she was very much trusted to pick her up, and I figured that she was trusted to take care of her and be around her.
Have you ever picked somebody up from daycare before?
My daughter, yes.
Have you had to have the birth certificate with you?
Negative.
So I don't understand how that meshes.
Well, based on the name, I looked her up, and then I seen pictures of my daughter and that they stay in the same home, so.
So you do know that she's the roommate of Bentley?
My daughter stayed with her. I didn't know anything about Bentley.
I don't have any more questions, Judge.
Anything else for him, Mr. Gilbert?
Did you ask her to pass that message on to Bentley?
No, sir, negative.
That's all I have, Your Honor.
Stand back with your lawyer. Any other evidence, Mr. Gilbert?
No, Your Honor.
Rebuttal evidence, Mr. Sprouse?
No, Judge.
Argument, Mr. Sprouse?
Judge, the defendant asking the victim's roommate for something that only the victim would have, in the state's eyes, is indirect contact. There'd be no way for Miss Samantha Adams to get that information, regardless if she's a trusted individual or not. The defendant's testimony doesn't logically make sense. So he knew, it's clear from the text messages, that he knew that he was not supposed to contact Bentley. It's clear that he's been instructed not to contact Bentley either directly or indirectly. Ms. Bentley is entitled to not have contact and not to have messages relayed on behalf of Mr. Clemens. His request, despite what he says, he knew that Miss Adams would have to go to the mother to get that information. So that's why the state is saying this is indirect contact and that Mr. Clemens is in violation of his probation conditions.
The defendant did not contact the victim, Ms. Clemens. He didn't ask anyone to pass on a message. He didn't ask anyone to tell her anything. He didn't inquire about her in any way. Savannah could simply have said, no, I can't get this, and said no. He explained the reason why he asked her, and that is that there's only a few people that are involved with his daughter. He has full rights to his daughter, and he has a business, or he works for a business that provides medical insurance, and so he has to satisfy their requirements for some documentation. Now, this isn't necessarily going to be the greatest person to approach for it, but it's a possibility that it could happen, that she would have access to it, since she was, in fact, actively involved in caring for the child. It's defense assertion that this does not constitute contact or even attempted contact of the mother. If you look at the message, there's no reference at all to the mother, to Bentley Clemens. It straight up explains exactly what he's trying to do. He's trying to get a copy of a birth certificate so that he can get insurance, his insurance squared away. Is this a possibility that she can get it? If the answer is no, okay, he'll have to do something else, which that's what he's working on through his lawyers now. That was a simple request of someone who might have the information he needed at the time. There's no, again, request for her to go ask anybody anything or contact, which he's not allowed to do, to contact to Bentley. So it's really not there when you're looking for willful and substantial. He's been on probation for over a year. He's had no issues. He's in the process of divorce. They do share a child together. Going forward, he's secured family law support and is moving to establish visitation with his daughter. The issue of parenting coordination will ultimately be resolved through that process. As you know, Your Honor, the bar is not the same as in a criminal trial, and you do have broad discretion to determine whether this is willful and substantial or not, and we respectfully submit that this is not a willful and substantial violation of his probation.
Anything else, Mr. Sprouse?
Yes, briefly. It's not what's said, it's what's communicated, and it's clear through the communication that what Mr. Clemens said to Ms. Savannah Adams was probably going to get to Ms. Bentley. He knew that.
All right, here's my concern. I've looked at the plea and sentencing agreement, and I've looked at the order putting him on probation. And both of them say he's to have no contact. I'm reading specifically from the order now. You will have no contact, direct or indirect, with the victim, Bentley Clemens, except as provided by family/injunction court during the period of supervision. What I haven't heard is what family law case is pending and what does it allow?
Well, if Your Honor remembers the bond hearing, that's where we went into it a little bit more in depth. I believe what's been relayed to me, I'm out of the family law bar, is that they are moving forward with discovery, and
I understand. There's a pending family law case.
Correct.
There's no evidence of what that case allows or doesn't allow, right?
I don't think it allows or doesn't allow anything. I don't think it's there.
Correct. So on the
I don't have any evidence of that.
Right.
That's my concern. So, this is one of those things that I had a discussion with a colleague just today about court is not supposed to go digging for the information. Court has to be provided it. And my concern is I don't know what's allowed because the order that's part of the court file allows for some sort of contact potentially. But I don't know if there's an order in the family law case or an injunction case that says they can't have contact. I think we talked about this.
I may be able to inform a little bit. On the injunction, what happened was right after the injunction was withdrawn. So that was voluntarily withdrawn by Ms. Bentley. So what was, when we did the plea, was that there was no contact allowed by one of the courts listed, which was the injunction court. What happened, though, was right afterwards, she removed that. The court removed that restriction, so that's gone. Family law has been delayed and is now being turned on, and he's working with his attorneys to get the support agreement and all that stuff done. But there is no standing family case that has permissions or any exceptions on this that I'm aware of, Your Honor. I mean, he wasn't allowed any contact by an external court at the time of the plea, but that was then removed. I mean, I think there is a little argument there that, well, that happened, that was a removal of the restriction. But if you're looking for something that gives you permission, then that does not currently exist.
Anything else, Mr. Sprouse or Mr. Gilbert?
No, sir.
I think there's some ambiguity there. If it had said, if the text message said, please ask Bentley to send me a copy of the birth certificate, I'd still be concerned as to whether or not it's that substantial. Because when there's a family law case pending, and I can tell you from being on the family law bench from before I was in this division that these are the types of things that are often allowed. Communication regarding children, it's often done on a parenting app or even through text message, depends on what the stipulations of that particular case are. So these are the kind of things that are often allowed even when there's a no contact or a no violent contact. I think Mr. Clemens probably knew this would get back to Ms. Clemens, but I don't think there was an attempt to directly contact her, and any indirect contact is minimal at best. So I don't find it to be substantial. So I'm not going to find that he's violated his probation. However, Mr. Clemens, I think you understand what the concern is at this point.
Absolutely.
All right. This is a situation where you're on probation for a felony offense committed against Ms. Clemens, and you can understand that even the slightest bit of contact that's not allowed by the courts or that she's agreed to in some way is scary to her because it makes her relive the issues that led to y'all not being together anymore and a felony offense where she was the victim. So I'm going to make it crystal clear. No contact means no contact unless there's an order from a judge that specifically in your family law or injunction cases says you can have this contact under these circumstances.
Yes, sir.
Because I don't know if there is one because the injunction was ultimately dismissed, right?
Correct.
After the plea, which throws another layer of kind of ambiguity where you're saying this case kind of controls what happens in the probation case and then suddenly that case doesn't exist anymore. But I want to make sure you understand, Mr. Clemens, I'm not saying this is what your one chance to get it wrong because now I'm specifically telling you, and I'm sure probation will continue to inform you, do not have any contact unless it's allowed by a court.
Yes, sir.
This has been going on for a while, so I'm not sure why you haven't gone anywhere with your family law case other than potentially a financial issue. But at this point, contact means indirect as well. Don't do anything that could even possibly lead back to her unless there's some change, either in this court or a family law court that allows for it. This is why I don't like the idea of having our court orders reference other court orders when those court orders can change. Because then it puts us in a situation of, well, which one rules over the other? And if we can all argue about that as experienced legal minds, what is the layperson supposed to do? When part of the issue is getting the funds to pay for a lawyer to help them through that process. So, are we clear, Mr. Clemens?
Yes, sir.
All right. So I'm going to find that you haven't violated your probation, at least not substantially. I think you knew it. This would get back to her. So I think it's willful, but I don't think it's substantial. Because there was no attempt to pass along a message or request anything other than something you're entitled to as the father of that child that was born during your marriage, correct? So he has a right to it. Again, talk to a lawyer next time. Don't try to do things on your own. All right. But you're still on probation.
Absolutely.
So I want you to meet with probation really quickly so they can give you any further instructions. But I think you're taking my instructions very seriously at this point, correct?
Yes, sir.
Thank you.
Thank you, Judge.
Thank you. All right. And what else do we have? For Jackson? What case is, who has Michael Jackson?
I have